Go ahead. Day 23. Hello. What's going on? Man, stop real quick. Possibly 1012, the signal free driver. What's going on?
I don't know.
You don't know?
No.
Alright. Were you just in a crash? Ma'am, come up here. Don't walk away.
Wait, hold on.
No walking. Come over here. Okay?
Okay.
Walk upstairs, alright? Let's get out this water area.
I don't wanna. I'm scared.
You're scared? Alright, let's walk up here. Let's get off this water, okay? Don't run. Slowly walk.
The woman you just saw on that body cam footage was Leigha Michelle Day. Leigha Michelle Day got into a car accident. She left the scene of that accident and was walking down the beach. This police officer went to find her, and this was their interaction. When she turned around, she pulled out a knife and stabbed him in the neck. This video will go through what happened during her trial and how we ended up where we are today. The court. All right, the jury panel has exited. Counsel, let's address the state's motion in limine. Mr. McRae, you've had an opportunity to review. Mr. McRae says, I have, Judge. I was just looking right now at the medical report about Miss Day was brought to Lawn Wood, and I could not get a doctor who was able, possibly, or willing to testify as to this document. So, as far as the state's motion in limine goes, obviously, Mr. Bruin's first point, voluntary intoxication, not a defense, not one that I can pursue, nor will I. Diminished capacity is not a viable defense. Not only do I agree with that, but I would have had to give notice in reliance thereof, so I agree there. Now, on March 25th, we did list Dr. Sheila Rappa. She did a follow-up evaluation on June 27th of 2022. She titled it herself, and it is titled, Psychological Evaluation to Form an Opinion Regarding Any Psychological Diagnosis and Need for Treatment. That may well have been useful at some point in time, but that's more mitigation, and it's not admissible at trial, in my opinion. But what I wanted, I do have testimony from Deputy, blanked out, as well as information on Miss Day's medical evaluation, which suggests she had suffered a concussion or head trauma, I believe was how it was written. Now, I can't get up there and just scream to the world that she had head trauma, and this is why that happened, obviously. So in order for me to get any testimony regarding the possibility that her behavior was affected somehow by having just rolled a car 3 times on Indian River Drive, crawled out of it, and ended up in the water, she was standing in the water with very little ambient light. The only testimony that I wanted to get from Dr. Rappa was, in her opinion, under those circumstances, could a person's behavior be altered? Court. All right, so Mr. McRae, it sounds like you agree that any voluntary intoxication, whether it be alcohol, prescription drugs that use in a way not prescribed by the treating physician, or any illegal substances, it is irrelevant to the case and cannot come in any form. Mr. McRae, agreed. The court. Now, let's state the arrest affidavit. Obviously, there's a car accident. That's why the deputy is there. Let me hear your response to Mr. McCrae's ability to question the witness about the accident, the extent of the accident, or whether or not he saw any visible injuries on the defendant at the time. Mr. Bruin. Whether he saw visible injuries, I suppose that part is relevant, but as far as that is diminished capacity evidence, and he's asking about any kind of head trauma or injury which would have resulted in her behaving the way she did, that's diminished capacity evidence. The court. Right. Do we have any cause I don't know what the evidence shows. I don't know what the medical reports from. I presume she was then taken to Lawnwood and examined due to the accident. Mr. McCrae, yes. The court. Is there any medical evidence as to diagnosing A, that she was concussed or anything of that nature? Mr. McCrae. Judge. There is. They said she had scrapes and abrasions on her torso. And if I can find what I'm looking for, so no ethyl alcohol, presentation, chief complaint, altered mental status, abrasions present on abdomen. I don't really think that altered mental status is specific enough to be the court. No, it's not a diagnosis of a concussion. Mr. McCrae, and I would the court. All right. So it sounds like there's no diagnosis by any medical professional of a concussion. So, Mr. McCrae, I'm not sure about that, Judge. I apologize for the interruption. I believe that I did see that. Oh, here's forehead abrasion. The court. Right. Well, Mr. McCrae, let's assume somewhere in her medical records somebody diagnosed her with a concussion as a result of that accident and talked only about a diagnosis of a concussion, not any other effect of alcohol or drugs or other substance affecting her ability. Wouldn't that still be diminished capacity, even if it is not from alcohol, drugs, or anything, but from an injury she sustained in the accident? Mr. McCrae. Well, Judge, as far as the legal definition of diminished capacity, I guess that can be either a function of short-term or long-term capacity, but they have nothing by which to measure this. As far as what I was going to do, Your Honor, was I took Deputy Blank deposition, and he said that he felt that he observed her as she was in distress. It's coming awfully close to violating the golden rule by saying, well, how would you feel if you flipped your car 3 times? And obviously I can't do that. But I can't say anything other than cross-examining, saying, didn't you observe her in distress, correct? Now, what I wanted to do was tie that in literally one question for Dr. Sheila Rappa by saying it is close to diminished capacity, but I also believe that this is a causation, so is closely linked to the injuries that the Deputy Blank suffered. Causation so close and linked to the car wreck, her effect, disaffect, her confusion, and I'm not going to make this I can't make it a feature of the trial. I would have had to do much more in terms of advising the state of my intent to rely on. Court. Well, anything short of legal insanity at the time of the offense goes towards mitigating her intent. So it is either diminished capacity in some form. What do you anticipate that Dr. Rappa is going to testify about? Mr. McCrae. Well, Dr. Rappa said that she felt that the defendant was disoriented as there was no light. She ended up standing in water. I didn't know where she was and had a fight or flight response. The court. All right. But Dr. Rappa did not find, based on her evaluation, that she was legally insane at the time. No. Okay. Mr. McCrae. I've had her psyched twice, Judge, and the first time was early on in this case, not clearly. The court. Mr. McCrae. And that was Dr. Edney. No. Incompetence. No, she didn't find her ICP or NGI. The court. All right then, Mr. McCrae. My question to you then would be, if there is no, and there isn't because you obviously didn't file anything because you didn't have a doctor support it, if there is no claim of legal insanity at the time, wouldn't anything else, as far as her mental state, go towards mitigation? Mr. McCrae. The court. If the court is in the position that I have discretion at sentencing, it would go towards mitigation at a sentencing hearing, but not as to guilt of innocence with the jury. Anything that the jury must determine. Mr. McCrae. I definitely understand the very close line here between mitigation and whether or not it goes to not guilty at the time of the offense. I mean, insanity at the time of the offense. The reason I didn't file that because I didn't have a basis to the blood, didn't suggest that, nor did anything else. But what it did seem, it seemed that, to me, that either I should be able to allow, or at least point out, or have Dr. Rappa say, didn't find, she didn't say, I didn't find her insane or incompetent, but certainly being thrown from a car that's flipped 3 times could affect one's behavior. That's it. I'm not allowed to say it. The court. But presenting that evidence for that purpose goes towards the defendant's intent. Involuntary intoxication, diminished capacity, all not viable defenses here in Florida. So, if I'm understanding this right, the defense is trying to find a way to essentially, they want to bring up the fact that she's disoriented, but they can't say it themselves. Mind you, I'm going off court transcripts. I don't have, their motions or anything like that for this recording. I'm trying something new because I have this recording. So, I understand what the defense is trying to do, I think. I think they can't obviously... How would you feel? They can't do that. And the judge is basically saying, well, here in Florida, it's diminished capacity, and it's not a defense, so you can't do that? You can't bring that up in court? Mr. McCrae, it may go, I wasn't thinking of using it as an intent as so much as her knowledge of where she was and whether or not this was a police officer. Ooh, going off the idea that maybe she didn't know it was police. I'm going to be honest. With what I know of what happened, I don't think whether it's police or not is needed. I think she'd be facing similar or the same charges, with a regular person. It's not going to, it not being a police officer doesn't do anything for her, in my opinion. There is her being, you can hear her in the background when she's taken into custody. She says, I think I stabbed a cop. Now that would go to me to whether or not she was aware at the time as a result of being thrown out of this vehicle into the water that she was. I'm not saying she's long-term incompetent or guilty by reason of insanity. I'm saying by anyone's reasonable standard, wouldn't it be rational to assume that would have some impact without having to file a notice of intent to rely on insanity? I mean, the court. All right, state response. Mr. Bruin, Judge, that's precisely what diminished capacity evidence is. That's precisely what it is. So there's a notice requirement. There's a reason for that because it's either insane at the time or pretty much nothing. There are very, very rare and specific circumstances where other type of mental evidence can be used. But it also requires a notice, and it's very, very specific. So essentially, what he just described is diminished capacity evidence is precisely what it is. The court. All right, based on the state's motion in limine that was filed, the arguments of counsel, I agree with the state's analysis of this type of evidence coming in and the purpose for it. I am going to grant the motion in limine as to paragraph 1, 2, and 3, Madam Clerk. So Dr. Rappa, that's all she has to offer, then the evidence she would provide would be irrelevant to this case. Now, certainly if there are lesser included charge that she's found guilty of, something where the court has discretion as to sentencing, then, Mr. McCrae, there is. The court, absolutely, you can present her reports for mitigation at that type of sentencing hearing, all right? Is there anything else we need to address today? Mr. Bruin, no, Your Honor. Mr. Stone, no, sir. The court, all right, state, Mr. McCrae, did you let them know of any lessers that you're asking for? Mr. McCrae, we went over a few of them, we did briefly, the court. All right. Let the state know of any lessers that you're asking for that we can work on the packet of instructions. I have a feeling it's going to be on the long side. And go back and forth to the charge conference. Now, obviously, that's not going to happen until Thursday, but I'd like to be ready to go as soon as we have the opportunity to do a charge conference and have everybody well aware of what the instructions look like at that point. If there are any issues that come up, you need to come before the court. Please set them tomorrow. Mr. Bruin, yes, Your Honor. The court. Because I really don't want to have a jury sitting, waiting, morning of, when we should already be getting into testimony. Mr. Bruin, yes, Your Honor. The court, okay. Mr. Bruin, I've already provided a rough draft and forwarded it to Mr. McCrae. Jury instructions, once we've decided on lessers, we just have to remove the ones that we're not using because they're going to be presented. There's a couple of added. The jury instructions pretty much done. The same thing, just once we got to figure out the lessers. The court, okay. Mr. Bruin. And then I plan on, hopefully, if I have time to be able to do it, I'll come by the clerk tomorrow and try to have the evidence marked tomorrow so we're not just kind of sitting around all morning. Court, perfect. Mr. McCrae, as soon as you and your client decide what lessers to you're asking actually got to ask for, just let the state know as soon as you know so that they can get those instructions prepared. Mr. McCrae, yes, Judge. I have one other question on this. Yes, sir. So this woman is thrown from her car. And I know that this is, I'm not trying to revisit something you've already ruled on. Will I be prevented from saying to the jury that she was thrown from a car and stating the facts that led up to this? The court, I would say this, Mr. Bruin. Judge, I'm just going to clarify this. She wasn't thrown from a car. Ooh, we're getting spicy here. One of the first witnesses, the Sandells were there, is that she climbed out of the car. She was not thrown from the vehicle. The court. A recitation of fact that comes from the stand, certainly you can do that. The tricky part here is in how you do that. If you're just regurgitating what was testified to, then obviously that's not going to draw any objection. But the argument put to it may, Mr. McCrae, now, the court, it all depends, Mr. McCrae. And I do understand what you're saying. Okay, so she wasn't thrown from the car. It was, the state will agree that the car was rolled? Mr. Bruin. Sure, yeah. Mr. McCrae, okay. And that she was in it at the time, and she somehow got out and ended up on the beach standing in the water. Mr. Bruin. I mean, she walked, but yes. Mr. McCrae. Okay, I wasn't saying she was thrown into the water. I mean, it kind of sounded like you were insinuating it before to me, but okay. But so the state will concede to that. The other thing that I specifically talked to Blank about was ambient lighting and what she could see when she first encountered what she later found out to be law enforcement. And that was virtually dark, as you can see, as you well know, Mr. Bruin, from the videos at approximately 3,500 lumens light, handheld. What's lumens on your flashlights, deputy? The bailiff. I don't know. They're bringing the bailiff in. Mr. McCrae. Okay, so the court. 3,500 is exceedingly bright, Mr. McCrae. Mr. McCrae. All right, let's bump it down to 2,000. Mine is, the one that I have is 3,500, so I guess I'm ahead of law enforcement. But this jury ought to be able to see that. The court. Mr. McCrae, nobody, Mr. Bruin. Judge, that has nothing, court. Is saying you can't question the deputy as to lighting conditions. Mr. Bruin. No, I'm not. The court. The flashlight. Was he shining it in her eyes? How bright it is? The physical surroundings in which she encountered her? Nobody is saying you can't talk about that. Mr. McCrae. I have talked. I mean, that's what the deposition was. So you're saying there's no way I can use any type of visual, Mr. Bruin? No, that's a completely different defense. That's fine. Yeah, the court. If she, Mr. Bruin, we didn't touch on that. The court. If based on poor lighting, bright light in the face, not hearing him, whatever, identity, or even believing that he's law enforcement, as long as you are not going into it because she was in the accident and injured her head, or she was drunk, or some sort of medication or drug, Mr. McCrae, I know, the court, that caused it. It's the environmental factors that she couldn't see, couldn't hear, that's all fair. That has nothing to do with diminished capacity. That's her ability to perceive based on those environmental factors. Mr. McCrae, I understand that that's a different argument from diminished capacity. I get that. I was saying there's got to be some way, rather than to hermetically seal this incident, which will change her life forever. Obviously, hermetically seal it, and here's what happened. She's in the road. Who gives? Who cares how she got out of the car? There's no light. There's a flashlight to her head. You can't argue diminished capacity. That didn't have any effect on her. She didn't remember it. How do we know? So rather than try and figure out what we know, I'm shut down from giving, from saying to a jury, my client crawled from a car. The next thing she was aware, well, I can't say that either, but this is what Deputy Blank describes, and that's the light in her face, which is obnoxious under the best circumstances and disorienting. I'm sure after having gotten out of a car in the middle of the night off Indian River Drive. The court. Mr. McCrae. All those are environmental factors. That has no correlation to ingesting any alcohol, drugs, or head injury. So see how the evidence comes out, and then you'll know how you're able to argue. As far, all that's fair game about the conditions, yes. The court, in which she encountered law enforcement. Mr. McCrae. And you've made your ruling, and obviously that's that, but that was, it was not set forth so much an NGI or an incompetence to proceed. I've done it before, and I know that I understand procedurally how it needs to be done, but when you go and see that car and where this happened, how it happened, I just don't want the jury to hear solely from a room full of law enforcement that she came flying at him with a knife and sunk it in his neck when there are other factors to consider. But we will. You've addressed it, Judge. The court. Okay, and that's your job to bring that out. Mr. McCrae, yes, sir. The court, okay. Mr. McCrae, yeah. The court, anything else? Mr. Bruin, no, sir. Mr. Stone, no, Your Honor. The court, counsel, thank you, Judge. All right, everybody have a good evening. You as well. See you, Judge. All right, we're in recess until 9 a.m. So, I'm recording this before I record my opener for this, by the way, because I forgot to record the opener. But I think this gives people a lot of context of what happened that night and the arguments going into what might be used as a defense. To me, it doesn't sound like a good defense, because no matter who's there, her response doesn't make sense to me as a defense. But we'll see how this shakes out as we proceed. April 3rd, the court. Madam Clerk, go ahead and call the trial. The clerk. Leah Day, 22 CF 726. The court. All right, Miss Day is present with counsel, Mr. Stone and Bruin for the state. Are there any issues that we need to address outside of the jury? Mr. Bruin, no, Your Honor. Mr. Stone, no, Your Honor. Mr. McCrae, yes, Your Honor. Court, Mr. McCrae. Mr. McCrae, I have an tennis motion in limine, one that is in some of the records. First, I'd like to invoke the rule of sequestration. Kind of intermixing things there, and the court says, all right, the rule of sequestration has been invoked. I'll leave it to the attorneys if you have any witnesses that rule will apply to make sure they are informed it has been invoked and repercussions of violating that rule. Unless I'm mistaking it, this is the rule where witnesses can't, watch other witnesses and things like that. Mr. Bruin, Your Honor, I instructed them that the rule would be invoked right at 9:30. At that point in time, from 9:30 on, they cannot discuss the case with one another. So the state has no problem with that. The court, thank you, counsel. Mr. McCrae, thank you, Your Honor. Further to that, when she got to the medical care of the hospital, they did a tox scan, found a trace amount of some type of illicit drug. A trace amount. Like there was no way that they could retroactively figure out, when this had been ingested, nor does this constitute any part of the crime alleged against Leigha Day. I would ask that any testimony as to illicit drugs, be excluded as being prejudicial. An uncharged crime and would serve only to prejudice the jury when the examiner herself said they're not able to make any determination when that was ingested. Thank you, Judge. Court state. Your Honor, that falls in line with our motion in limine, no discussions of any sort of toxicology or drugs. Mr. McCrae. Okay, great. Well, great, okay. So the other way around. The court. All right. So state you have no intention of eliciting that information from any of the witnesses. Mr. Bruin. No, Your Honor. The court. All right. is that the extent of the or tennis motion, Mr. McRae? Mr. McRae, it is, Your Honor. Thank you. Any other issues before the jury joins us? Defense? Mr. Bruin, no, Your Honor. Court, state? All right. Then if the jury is ready, let's get our jury. The bailiff, yes, sir, and the jury enters. And here they are just explaining the crimes. So we have the bailiff, please stand for the jury. The court, all right, everybody, please be seated. Ladies and gentlemen of the jury, you have been selected as sworn as the jury to try the case of the state of Florida versus, I'm gonna say this name wrong at some point, but I believe it's Leigha Michelle Day. This is a criminal case. Miss Day is charged with the crimes of attempted first-degree murder of a law enforcement officer with a weapon, leaving the scene of an accident, causing property damage, and driving with license suspended. Now, the definition of those crimes will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Miss Day in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Now, before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law that is applicable to this case. Now, after the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you have heard all the evidence, the argument of the lawyers, and the instructions in the law by the judge. Till that time, you should not discuss the case amongst yourselves. Now, your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you to not communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, no text messages, tweeting, blogging, or other forms of communication. You cannot do a research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify the court personnel of the violation. Now, during the course of the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell them you are on the jury, trying the case, and ask that person to stop. If they persist, leave that person at once. Immediately report them out to the court deputy, who will advise me. Now, you cannot have any cell phones, tablets, laptops, or other electronic devices in the courtroom. Now, you may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. Now, at the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. Now, if someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. We provided you with that contact number on Monday. Now, the case must be tried by you only on the evidence presented during the trial in your presence, in the presence of the defendant, the attorneys, and the judge. Hold on 1 second here. I'm just going to try this real quick. Trying to get rid of the little dots that are appearing on the actual text. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, or internet, any electronic devices, or any other means to get information relied to in this case, or the people and places involved in this case. Now, it applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look up maps or pictures to see any place discussed during the trial. Now, jurors must not have discussions of any sort with friends or family members about the case or the people and the places involved. So don't let even the closest family members make comments to you or ask questions about the trial. Now, in this age of electronic information, I want to stress again that just as you must not talk about the case face-to-face, you must not talk about this case by using an electronic device. You must not use cell phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss the case or ask for advice by means at all. including posting information on an internet website, chat room, or blog. Now, why do we have these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries of your own, the trial judge has no way to make sure that the information you obtained is proper for the case. The parties, likewise, have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent journalism by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Now, any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. Now, if you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand does not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had they been permitted to answer. Now, during a trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of this case. Now, if you would like to take notes during a trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. Now, that will be left up to each of you individually. Now, you will be provided with a notepad and pen for use if you wish to take notes. Any notes that you will take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we can reconvene. Now, after you completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. Now, if you take notes, do not get so involved in note-taking that you become distracted from the proceeding. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Now, at this time, the attorneys have an opportunity, if they wish, to make their opening statements. State, Mr. Bruin. Now, a big reason I decided to read all of that is because I didn't transcribe that during watching the Sarah Boone case. And I thought people would find it interesting. And of course, it's all written out for me here, which saves me so much effort. My fingers do not hurt. I'm loving this as an option, but it's not as good as watching a live trial, I must say. Watching a live trial was a lot more exciting. Mr. Bruin says, "Thank you, Judge. Ladies and gentlemen, on March 23rd of 2022, that was almost the last night Deputy Blank put on a uniform. It was almost the last night he ever took a breath. Because on that night, this defendant plunged her knife into his neck in a complete unprovoked attack on a police officer. See, because unfortunately for Deputy Blank and for Blank, he didn't know she would be so desperate not to be arrested that night." Mr. McRae says, "Judge, this is an argument." Court, "All right, counsel, opening statement, what you believe the evidence will show." Mr. Bruin, This is what it will show, Judge. She was desperate not to be arrested because she had just been driving in Indian River Drive. She had been passing on the shoulder, flipped her vehicle. She flipped her vehicle. She crawls out of her vehicle. She's also driving on a suspended license. She gets out of her vehicle on Indian River Drive. She doesn't stick around that scene very long. The evidence will show she leaves the scene. She starts heading north on foot by the water. Now, also unbeknownst to Blank, Deputy Blank, she has a knife on her. He's not aware of this. He's just doing his job as a police officer. When he gets to near the crash scene, all the officers realize she's left the scene. The driver of the vehicle that just flipped has now left the scene. All they're doing is looking for the driver of that vehicle, and that's all Blank was doing. The evidence is going to take us back to that date, March 23rd at 11 p.m. on Indian River Drive. You're going to hear from many witnesses during this trial. You're going to hear from the Sandells, a couple who was driving in their vehicle and witnessed this defendant driving, passing on the wrong side of the road, passing on the shoulder on Indian River Drive, 2-lane little road. They see her flip her vehicle. They see her get out. They see her leave the scene. Now, of course, the officers become aware of this, so they all go looking for her down Indian River Drive. Now, Blank, Deputy Blank, he starts heading north in his vehicle. He's gonna, if you're familiar with that area, and you'll see pictures, there's a lot of docks that go out towards the water. Okay, off of that road. So it's 11 p.m. It's pretty dark out there. They gotta go searching for her and see where she went. So Deputy Blank goes that way, heads north, starts looking for her. Starts walking down docks, driving his vehicle with the lights on, red and blue lights, and the other officers go as well. They're all looking for her. Well, again, I guess you could consider, unfortunately, Deputy Blank is the one that locates her. As he's going down, he drives his car about roughly a mile or so from where the crash was. He sees her out near the water. So he's doing his normal police duties, acting in his courteous manner. He's in his uniform. He's got his badge. He's got his flashlight. He's got his police vehicle with the lights on right behind him in the roadway. He makes contact with her. Now he speaks with her, and you'll see this. He asks her if she just got in a crash, tries to get her to come. Hey, we need to talk to you. Asks her to come up the stairs. We need to talk. You can see, because Deputy Blank has a body cam, so you can see now as she starts coming towards him, she's got what looks like a sports bra on. She's got shorts on, but she's hiding something. And you can see it in the body cam. She's hiding something behind her back as she's walking towards him. Mr. McCrae, Judge, I'd object. That goes to the ultimate fact for the jurors to make a decision. The court. Ladies and gentlemen, the opening statements are what the attorneys believe the evidence will show during the trial. Go ahead, Mr. Bruin. Mr. Bruin says, and you will see for yourself that she's concealing one side as she's walking up to him. Now, as we've just discussed, there's a bunch of docks. This is a dock that he's trying to get her to walk up the stairs. She goes in front of him, and you can see this. As she walks in front of him, she starts going up the stairs. Deputy Blank starts going up the stairs, and she violently and suddenly turns and stabs him in the neck as they're just walking up the stairs. Now, he's stunned, of course. You can see from his body camera, you can see the blood spurting out of his neck, and at this point, he takes a shot at her as she runs off. He misses her, and he radios out what has just happened. The other officers start to come to his way. Everyone can see him because they know where his vehicle is. It's sitting right there in the road with the lights on. Deputies Leckenbusch and Guerrero, they come and they see Blank. He tells them what happens, points where he thinks she went as Blank is trying to tend to his neck. He's bleeding all over the place, and they see her, again, standing in the water. They get her to come back. They get her in custody. They got her down the ground. You'll hear her say from the body cam, it's on Deputy Guerrero's body cam, and you're the fact fighter, she'll say something along the lines of, I can't believe I just stabbed an officer. I don't believe I just stabbed an officer. You're the fact finders. You'll hear it. She's totally aware of what she just did. Mr. McCrae, Judge, again, objection. That goes to absolutely the providence of the jury. The court overruled. Can we just end the trial here? Like, if this is what they're going to show, how do you not find her guilty? Is kind of the question, I think. That's kind of why I think the defense is objecting here. If she's aware she stabbed the officer and was fully aware while doing it, isn't she guilty? I mean, of course, if you're not pleading, you're going to put on a defense. Maybe they didn't offer her a plea. It wasn't officer. But this is already, and I haven't looked into it too much, the case, because I found it, I remember seeing the body cam when it first came out. and I saw the end result, so I am biased on how this will end. But the way it's being presented right now by the state is very strong. Now, of course, the defense has to give their opening too. Mr. Bruin, the state, you'll hear the body cam, you'll hear the audio, you'll hear she's well aware of what she just did. And as they get her up, they're taking her. They don't know exactly. The officers are Leckenbusch doesn't know exactly where the stabbing occurred. So as he's going up the stairs, it happens to be he comes upon the very place where the stabbing was, as evident by all the blood, and he doesn't want to walk through the crime scene. So as he's talking to the other deputy, she's now walking with him in cuffs. Says, "What are you, a pussy?" Because the blood is there and he doesn't want to walk through the crime scene. So, the suspect attempted to kill a police officer with being claimed with a knife. And then because they didn't want to walk through and contaminate the crime scene, she called another officer a pussy. Now after that, as you may imagine, thank goodness there was an ambulance right there at the scene. They rushed Deputy Blank to the hospital for life-saving surgery. All he was doing was his job. Not only was he just doing his job, he was doing it in a courteous manner with respect, the normal course of his duties. What you'll see is she was so desperate not to be taken into custody, she tried to kill a law enforcement officer, all because she didn't want to be arrested. And at the close of the evidence, we're going to ask you to hold her accountable for what she did and find her guilty as charged. The court, thank you, Mr. Bruin. Mr. McCrae, do you wish to have an opening? And the answer is yes. But before we get into that, that's very strong. And if it's backed up by the evidence shown, I don't know how the jury finds otherwise. But let's see what the defense does. Mr. McCrae, Your Honor, thank you. May it please the court, ladies and gentlemen, Leigha Day is not guilty of attempted murder of a law enforcement officer. And as the facts in this trial unfold, you will see why that is true. We talked about this in jury selection. I have jury selection, but I skipped it. I'm going to be honest. You all agree that someone can be wrongly accused. You will remember that, I'm sure. This is one of those cases. She is wrongly accused. And again, pay attention to what you hear from the witness stand. Look at the evidence as you, and listen to the law from the judge. Easy. As you put the pieces of this puzzle together, as you try to figure out why this happened. Pay very close attention to what is said and what isn't said in any conflicts. So the evidence, the lack of evidence, or a conflict in the evidence. So on March 22nd at about 11:20 p.m., Blank does receive a call from spectators who say there's a car on its roof across the street on the east side of Indian River Drive, very close to where it drops off to the water. Deputy Blank responds, sees the car, doesn't see the driver. He continues down north, actually looking for her. Sees footprints and locates her. You will learn that there's virtually no ambient light. It's dark. When he sees her, she's partly in the water, he says. Hey, something happened here. Are you okay? Something to that effect. And she is, in his words, appears to be very distraught, very upset, possibly crying. He gets her to approach, and she complies, and he gets her to walk up the stairs before him, the wooden stairs that lead down to the beach. As they get about halfway up, she turns around and stabs him in the neck and takes off. Blank fires his weapon in the direction that she ran. We don't know what happened to that round. Well, I don't know why that matters. Seriously, why does that matter? Is it just trying to put that maybe the officer was careless? You know, he stabbed in the neck and he missed. Oh no. Like, if I am... This is me. If I'm on the jury, and that line is said, my first thought is, who the hell cares in this situation where the round went? I am immediately having a bad impression of the defense already. Because obviously they're going to make some argument that I would assume if I was on the jury, and I don't know what's been discussed previously, I'm going to assume that maybe she's out of her mind or she hit her head, which we've already know they can't say that, right? But I might think in my back of my head that's going to be said. But then when you're like, where did the round go? Immediately I'm turned off. Immediately I'm turned off. I don't know why you would say that. I don't think it helps. A little bit of a rant there, but I don't know how it helps. What is the point? Maybe I'm interrupting. Maybe he'll get to it. Now you've been picked for a very solemn duty here. This is a big case and it's very important. Nobody wants to see our law enforcement hurt in the execution of their duties, and no one wants to see somebody go to prison wrongly. If we're going to convict people, it has to be for the charge that matches the allegations that occurred. As you hear this story unfold, you will realize that the only verdict that you can come to the verdict of not guilty. Thank you. The court, thank you, Mr. McCrae, your first witness. Yes, Your Honor, the state would like to call Mason Sandell, the bailiff. Stand right here, face the clerk, raise your hand to be sworn. So, obviously, the charge involves a police officer. I'm not sure how different the sentencing is if she just attempted to kill someone who isn't a police officer. But they have to just be going for that, right? Like a lesser charge. They can't be possibly thinking she's going to be found not guilty. Mason Sandell called a witness on behalf of the state, was sworn and testified as follows. Witness, I do. Bailiff, have a seat. By Mr. Stone. Good morning, Mr. Sandell. How are you doing? How you doing? Good morning. Would you please introduce yourself to the jury? Hi, I'm Mason Sandell. Mr. Sandell, can you spell your last name? Sandell. Mr. Sandell, where do you live? I live in Cambridge, Massachusetts. Okay, and do you live part of the time or any part of the time down here? No, I don't. So I'm going to take you back to March 23rd of 2022. Were you in the St. Lucie County area back on that day? Yes, I was. And what were you here for? I was here for a week with my wife. Our son's high school baseball team was spending a week playing baseball down here. Were there any other family that was with you guys too? Other than my son who was traveling with the team, it was just me and my wife. Okay, yeah. What did you guys do that day? Well, that day, we, since we were on vacation, we just spent it at the place we were renting, spent the day at the beach, and then that evening had gone to our son's baseball game in Fort Pierce at the Lawnwood Baseball Complex. Gotcha. And so we were there from 8 to 10:30 or so, watching baseball. So around roughly 11, yes. Were you guys heading back to the house? We were, that's right. And do you remember which road you guys were heading on? Yeah, we were on the Indian River Road. We were heading south, coming back from Fort Pierce. We were driving on that road. And do you remember anything specific about the road? Well, it was dark. We were driving south. There was another couple following us because they were coming from the same place we were. Do you remember their name? The Talachis? Okay, Tony and Lisa Talachi. And they were right behind you. Yeah, they were right behind us. Okay, was anything off on the left of that road? Off to the left was the waterway, the docks to the right, intermittently houses, nice houses, but also woods. Okay, at some point in time, did something occur with another car that kind of startled you or got your attention? Oh, absolutely. And what was that? Oh, well, so we were headed south, and the Talachis were behind us, maybe a couple hundred feet. Then all of a sudden, we were passing a wooded area. On the wooded area was on our right, and the waterway was on our left. And just as there was a loud crashing sound that was totally unexpected, because we could see the Talachis behind us, the headlights. So a car came swooshing around us, and I just heard a loud slamming in the car. I don't know what it was because I didn't think it could be a car because of the woods being right there. There was no shoulder, there was no driveway or anything, and there's just this rushing slamming sound, and then this car came like hurtling like over our hood basically. It was kind of airborne, and then it hit the pavement. It was going way, way faster than we were. So how fast did you say we're going? 30, 35? And how fast would you estimate that vehicle probably was going? Mr. McCrae, object. The witness, I'd say 20. Mr. McCrae, speculation, Your Honor. The witness, I'd say 60. The court. Do you want to be heard as to the objection on speculation? Mr. Stone, no, Your Honor. All right, I'm going to sustain. Ladies and gentlemen, you are to disregard the last statement by the witness as to the estimated speed of the other vehicle. Go ahead, counsel. I mean, okay, I get it. I get the objection. But the picture painted without a given speed is, I think, enough. In fact, I would argue I was picturing above 60 from the way they were wording it. Maybe 60 would make it sound better, slower, some of the jury. Maybe that wasn't the best objection. Okay, so, answer, it was traveling a lot faster than we were. Mr. McRae, objection. Question, okay, a lot faster. Mr. Stone, well, that's judge, that's not the witness. It passed us. The court, all right, overruled as to traveling faster. I mean, if it's passing you, it's got to be faster. By Mr. Stone, faster, correct. At that time, after that point in time, after you saw it kind of go over the hood, what did the car do next? Then it hit the pavement, so there was like a spray of sparks, and then as it passed us through the cause, a spray of glass came flying into our car, and the wood debris and the stuff like that. And then let me ask you this, yeah? You were driving the vehicle. I was driving the vehicle. And your wife was in the passenger seat. She was in the passenger seat with. Were the windows up or the windows were open? The windows were open? The windows were open. Okay, the windows were open. I think the windows were open. That's a lot of the windows were open. So the actual glass and tree debris came into the car. Yeah, it came into the car. It wasn't, yeah, our car was unharmed. So the car is unharmed. They're getting hit physically with glass and debris. Okay, so vehicle hit, sparks fly, do you stop? We stopped the car that came past us, like, started rolling because it was going way faster and it rolled. So we hit the brakes and stopped. Okay. And it rolled a couple of times where sparks and it landed and then we stopped. Did you see anyone inside the car when you got out? I did, yeah. And what did they do after the crash? So we pulled over, got out of our car, made sure my wife was all right, and then approached the vehicle. It had landed on all four wheels, okay? You know, it was in the incoming lane side. And so I was clearly expecting there to be, like, people injured in the car because it was just a horrific crash, you know? And I approached the driver's side or the passenger side, and then there was a single occupant in the car. She started climbing out of the car. I was maybe 10 feet away. Pause. All right, so pause. The reason I'm pausing is maybe it was something I read earlier. It landed on I thought it didn't land on all four wheels. I thought it landed on the roof. Maybe I'm misremembering. You thought. I thought I was going to have to help, but ended up not needing to. Okay, did you get a good look at her? I did. And can you describe what she looked like? So, yeah, so a young woman, maybe 5'6", short hair, was kind of dyed, a dark hoodie, kind of like a tube top leggings. I'm trying to think back. It's been a bit since I watched the footage. Does she have a hoodie with her? Anyway. Okay, yeah. Is that person in the courtroom today? Yes. Can you point to her and describe an article of clothes she's wearing? What she's wearing now? Yes. She's in a dark suit with a peach top. Okay, sitting right there. Mr. Stone, Your Honor, let the record reflect the witnesses identified the defendant. Court, proceed, counsel. Mr. Stone. Okay, so at that point in time, what did you do next? Well, initially I was concerned that there were other people that needed help, but it turned out there weren't. And so she got out of the car and I said, "Are you all right?" And she didn't appear injured at all. Did she say anything to you? She started looking for her phone. She was concerned she was looking for her phone. She was like, "I gotta find my phone." Started, okay, looking around for a phone. At some point in time, did you go back to your wife and guys call anybody? Mr. McRae, leading judge, the witness. Yeah, court overruled. At some point, did you go? Yeah, I think my wife called 911. Question, okay. You know, and then we sort of moved away from where the car was altogether and moved to the front yard of the house that was kind of abutting the street. Where was the driver of that vehicle in that time? Was with us. So she was with them. Okay. And so I remember saying, hey, I think you ought to sit down, because she was trying to find her phone. Okay. She was concerned about her phone. I'm sorry. I just keep thinking Sarah Boone. When am I getting my phone back? At some point in time, did that person leave where you were standing? Yeah. So, like, initially she was sitting sort of on the side. There was a grassy kind of berm, or might have been a wall in the front yard of that house, and was sitting there. But then, within a couple of minutes, like we were talking to other people too, and then a couple of minutes later, she was gone. Okay. After that, did you stick around to talk to law enforcement or anybody else? Yeah, you were there for a couple of hours. Okay, do you know if the person driving that vehicle was wearing any shoes or anything? I think she was barefoot. There were shoes there were at least one shoe on the road. Okay. Which I noticed as I approached the car, which was thinking that maybe someone had been thrown from the car, but that wasn't the case. All right, Mr. Stone, I have no further questions. Cross-examination? Thank you, Judge. And now it's the defense, Mr. McRae. Good morning, sir. Hello. You said it was very dark, correct? It was night. And that this car passed you. It was very dark, and you saw it roll a couple of times. Can you estimate how many times, 1 time, 2 times, that it rolled, that you, maybe 1, that you saw? Yeah, maybe 1. So it rolled and landed on its tires? Landed on its tires, yeah. Okay. So she stuck around the scene with you briefly. Okay. Yeah. And then you said your testimony was she had to find her cell phone, correct? Yeah. Okay, thank you, sir. I have nothing further for you. Okay. Court, any redirect? No, Your Honor. Is Mr. Sandell released? Mr. McRae, no objection. He's released, Your Honor. Mr. Sandell, that will conclude your testimony in this trial. You're free to go, sir. Thank you. The witness, all right, thank you. State next witness. Your Honor, the state will call Leigha Cruz. The bailiff, raise your right hand and face the clerk. So, I mean, obviously the defense, I guess, has to ask something. I guess? I don't think it did anything. I guess it did say roll 1 time, and she wanted her phone. Why is her wanting her phone? I guess maybe the defense, and yes, I did get a second monster for this. I guess maybe the defense is going to argue that, trying to think of how I want to word this, that she wasn't running, she was looking for her phone. But if you're looking for your phone, why are you in water? Because at that point, you find your phone in the water, probably not working. You're also not finding your phone in night in the water. Okay. Called a witness on behalf of the state was sworn in. Testify as follows. I do. Watch your step. Direct examination, Mr. Stone. Good morning, Miss Cruz. How are you? Good. How about you? Good. Can you please introduce yourself to the jury? My name is Leigha Cruz. I swear I'm so bad at names. Anyone who's watched the channel knows I'm bad at names and certain words, and these names are going to kill me. And Miss Cruz, could you spell your first name? Juliana. You know what? Doing more Florida stuff might help me pronounce these names, because I look up a lot of them afterwards to make sure I'm not completely bad. And Miss Cruz, do you live here in St. Lucia County? I do, yes. And I'm going to take you back to March 23rd of 2022. What were you doing that evening? I was driving home from work. Okay, and around 11, what road were you on? I was on the Indian River Drive. In what direction were you headed? Northbound. Northbound? So while you were driving down Indian River Drive that day, did you come across something that kind of caught your attention? Yeah, there was a vehicle that was crashed in the middle of the road. Okay, did you stop? I did, yes. When you stopped, what did you see? I saw, my immediate attention was on the car, but I did see off to the left side that there were 2 other cars pulled over, and a couple was approaching me as I was walking up to the car. Okay, and did you speak to these people? I did, and yes, they told me that I needed to call 911 because they weren't from here, and Mr. McRae, objection. The witness, they didn't know where they were. Mr. McRae, it's hearsay. The court sustained as to hearsay. okay, I understand the objection. It's hearsay, right? Because she's saying someone else said something. Another witness said something, right? I guess he did it because they didn't know what was going to come next, and didn't know he was just going to say they didn't know where they were from. I get it. Okay, I'm just thinking if it like it changes anything, and the answer is no. Did you call 911 yourself? I did. Yes. Did you happen to see anyone else on the scene aside from that couple? Yes, there was. After I had been there for a moment, I saw another couple and the lady that was in the accident as well. Were you able to describe what she looked like? From what I could see, she was around my height. She had a whiter complexion, a black hoodie on, and if she had pants on, they were nude, or she had shorts on. I couldn't tell. Gotcha. At the time. Now, while you were on the phone with 911, was that person near the area? She was near the car. Yeah. Okay. Did she ever go in the car, or I think she was looking for her phone? Okay, but no. At some point in time you were there, do you know they were talking to 911? Did you lose sight of her? Yes. And can you describe that? Well, I was pacing as I'm on the phone, trying to stay out of the road as well as off to my side. I saw her kind of pacing as well, and I noticed she had gotten a little bit further. But as I was on the phone trying to give correct information, I lost sight of her. And the next thing, the 911 operator asked me where she was, and I looked around. She was gone. Okay, I have no further questions. Thank you, Miss Cruz. Cross-examination. Thank you, Your Honor. Now it's Mr. McCrae up. Good morning, Miss Cruz. Good morning. You see, you were driving north on your way home, and the first thing you saw, correct me if I'm wrong, you were some sort of spectators standing around? Uh-huh. And a couple of cars parked, correct? Yes. Now you saw a car that had crashed, right? Yes. Can you tell the jury where was that car positioned on Indian River Drive? I was in my lane northbound, okay, and kind of like half in the lane, half in the grass, okay. On the roof, on the tires, on the side. It was on the tires, but it looked like it had rolled, so there was like damage to the roof, I'm assuming. Okay, could you see anything that would indicate that maybe it hadn't gone off the road prior to stopping in the middle of the road? Not at that moment, no. And okay, at that time, had law enforcement blocked off the road from any other traffic or no? I believe I was the first one to pull up on the scene beside the spectators that were involved, I believe. Okay, and you described the defendant as wearing what appear to be very dark shorts and a hoodie. Is that accurate? Very light shorts. Yeah, and a dark hoodie. Yeah, if she was wearing shorts, I couldn't see what they looked like, but I definitely saw a big black hoodie. And she had a black short hair. I believe put in my statement she might have had a colored strip, I do believe. Okay, so she was, at that time, she stayed at the scene, correct? Uh-huh. And she was worried about her phone? Uh-huh. All right. The court, Miss Cruz, yes. Please say yes or no instead of uh-huh or uh-uh. Oh, okay. Okay, that's funny. Please say yes or no. Oh, okay. Oh, I gotta get the laughs in while you can while covering something like this. What was the answer? Yes. Okay, thank you, ma'am. Thank you, Ms. Cruz. That's all I have for you right now. Okay, any redirect state? No, Your Honor. Is Mr. Cruz released? Yes, Your Honor. You agree, counsel? Yes, Ms. Cruz. That will conclude your testimony in this trial. You're free to go, ma'am. Thank you. State next witness. Your Honor, can I have 2 seconds to step out in the hallway? Go ahead, Your Honor. The state would like to call Deputy Blank. Now, they've been blanking out a couple names, but this is probably the victim, right? By Mr. Stone. Direct examination. Good morning, Deputy. Would you please introduce yourself to the jury? My name is Deputy Blank. And Deputy, where do you work? You know, I do wonder sometimes why these are blanked. For the reason that... How do I want to put this? The names are blanked out. This is the official transcript, and the names are blanked out. But these names, who was involved, is public. Like, I've definitely seen the name of the officer that was stabbed so many times. Maybe it's like a procedural thing and they just always do it, but it's weird to me when, especially when it's law enforcement. Like, I get he's the victim here. I'm assuming this is a victim, but it's weird to me when law enforcement is blacked out. I just don't like that. Because, I mean, sure, he's the victim, but he was the victim while working in his official capacity as well. Just a personal thing. I don't enjoy it. I don't like it. And I don't understand the point realistically because, I mean, his name that he was stabbed, it was out there that night, I believe, right? Deputy, where you work? I work for the St. Lucie County Sheriff's Office. And how long have you worked there? Coming up 4.5 years. Do you have prior law enforcement experience prior to St. Lucie County Sheriff's Office? Yes. Where was that at? Vero Beach Police Department. And how long was that for? A couple of months. And did you have training and experience prior to that before becoming a law enforcement officer? No. Do you do any sort of a schooling or anything to become an officer? Yes, I did basic law enforcement academy. Okay, so I'm going to take you back to March 23rd, 2022 while you're working at the St. Lucie County Sheriff's Office back then. Yes, and in what capacity? As a road patrol officer. Can you describe your duties as a road patrol officer? It's to answer calls for service, conduct patrols of your zone that you're assigned to. And what zone were you assigned to that night? Zone 8. Can you kind of describe the parameters of zone either? It would be 8. That'd be around Midway Road from like 95 to Indian River Drive all the way down to Kitterman Road. Okay, and so you were assigned to that zone that evening, yes. So I'm going to take you back to roughly 11 that night. Were you stationed within your zone? I was around middle US 1 area. Did you get a call for service? Yes. What was that call for? For a crash. Do you remember exactly what time that was at? Exactly, no. If I show you something to refresh your recollection, Mr. Stone, may I approach, Your Honor? Court, you may. Witness, okay. Mr. Stone, and this is your recollection refreshed at this point. So he showed something. Yes. Do you remember what time it was at? Around 11 p.m. And did you respond to that call? Yes. And where was it at? It was on Indian River Drive towards the south end. Okay, and by south end, was that how far south? About the 11,000 block of Indian River Drive. Now, as you're responding, what are you doing? On my way, I'm responding with my lights and sirens. And were your lights and sirens on the entire way? The majority of the way, yes. Okay. And what road did you pass? I guess side streets on your way to that area. I took Midway Road out to Indian River Drive and Indian River Drive down south until the crash scene. Okay, so lights are on almost the whole way. Sirens are on almost the whole entire way. Yeah. When do you arrive at the scene? Yes. When you get there, what do you do? I was flagged down by witnesses. And after being flagged down to them, did you, what happened next? At that point, I began canvassing the area for the driver of the vehicle. Was the driver on the scene? No. What were you told as far as where the driver was? I was told the driver left northbound along the beach. Mr. McCrae, objection. This calls for hearsay. Mr. Stone, its effect on the listener, Your Honor. It's exactly why he started going northbound. All right, I'll overrule the objection. Go ahead. I mean, really? That objection? I think I'm getting the feeling we're going to get a lot of objections in this. Maybe I'm wrong. So we're told that they fled foot northbound. Yes. And what did you do next? At that point, I began canvassing the beaches northbound from my location. And how were you doing that? I would go out to the beach. I would see if there was any footprints or anything. Then I would, if there was, I'd continue traveling, get in my car northbound, go walk along another dock and see if the footprints were still there, if they were gone. Now, you were there for a crash. Is that what you're there to investigate? Yes. Okay. Now, with your vehicle, are your lights still on at this point? Yes, my rear lights are. Okay, so now with your real lights, should be rear. Where are they? What are they? They're red and blue lights on a light bar on top of my vehicle to let other vehicles and people know that I'm in the roadway. Okay, now you see you went down a few docks. Do you see anything as you're going down these docks to lead you to believe that the person or someone was down there? Yeah, I saw fresh footprints traveling north. And at some point in time, did you reach an area alongside the drive where you came into contact with somebody? Yes. And where was that? Can you repeat? Where was that at? Where I made contact? Yes. The beach area off the dock of Indian River Drive. Do you know exactly that location or whereabouts that location is? Off of, I can't tell you the exact address. I don't recall. Okay, now, deputy, when you got there, where is your car parked? Off the roadway. And are your lights on? Yes. Can you see the lights from where you were? You were standing. Yes. This is key against the defense's argument, right? How could you see them? You could see them reflecting in the area. I think it's kind of a universal experience for everyone in America. At some point, you've been at night and seen the lights on a police car. And they do kind of illuminate the area. They, shine off water, glass, trees. You know there's police there. That's the point of these lights. They're made to be visible. and if they're visible, wouldn't you assume that the people approaching you are an officer? Okay, so you stay down there and you make contact with her. Can you describe the contact you made with her? Okay, let's go a little bit farther. If you were in a car crash and you see those lights and someone approach you, you would assume they were an officer, I would think. Now, there is a situation where if you have no idea why there are lights and suddenly there is a man approaching you in the dark, theoretically, that could be a threat. Theoretically. Manhunt, something like that. But if you just crashed your vehicle, you flipped it, you kind of know why the lights are there. You fled the scene. They don't know if you're bleeding out on the side of the road, right? They don't know how injured you might be. You might be dying. People get into accidents all the time, and they have internal bleeding and other issues like that. So, you know those lights are for you. Okay, so you stay down there, you make contact with her. Can you describe the contact you made with her? I observed walking along the beach. At that point, I asked if they were okay. Then I began walking down the dock. Okay, so you say you observed her. Were you able to observe her just in plain sight? Or, yeah, I observed her walking northbound on the beach. Okay, how were you able to observe her? Was there pole lights? What were you using? I used my flashlight. Okay. Now, when you start walking down the dock, are you still talking to her at that point? Yes. And what kind of movements or where is she? Can you describe where she's moving at that point? On the beach, it appeared she was going to continue walking northbound as I asked her to stop. Okay. How close do you get to her when you got down there? 5-10 feet. Okay, now you're down there with her about 5-10 feet from her. Do you still have your flashlight on? Yes. Now, what are you doing with your flashlight? Kind of aiming it around the area, like at the ground to illuminate the area. Do you ever aim it at her at some point? Okay, now let me ask you this. Why are you aiming it at the ground? Because it illuminates the area so that she can see who I am, I can see who she is, so we can see everything that's around us. Is that for your safety? Yes. Is that for her safety? Yes. Now, you say illuminated. Are these strong flashlights? Yes. So they're getting ahead right there of the defense right there. Because the defense is going to try to probably claim that she was blinded. Okay, so you're down there, you're about 10 feet from here, you're kind of illuminating everything. What were you wearing that day? I was wearing our sheriff's office uniform, our Class B. What are you wearing today? I'm wearing our sheriff's office uniform, Class B uniform. Or I'm wearing our sheriff's office Class B uniform. So this is similar to the uniform you wore that day, yes. I see different things on your shirt. Can you describe what you kind of have on your uniform? So on my left side is our agency badge, on the right side is my name tag. Then on our shoulders we have a patch that says sheriff's office on. Now, why would you have all these insignia on your shirt? To let people know when we approach that we're law enforcement. Okay, so you're down there with her. What explains the conversation you have with her? I began to ask if she was involved in some sort of crash. And what did she say to you? She just started saying that she was scared. Okay, what do you do next? I request for her to walk up to the dock and onto the roadway. And while you're talking to her and you're requesting to walk up, where were her hands? Behind her back. Were you able to see what's in her hands? No. So she walks up past you, or you tell her to go up. And does she go? Yes. Let me rephrase that. She walks up past you. Yes. How close is she when she walks past you? Pretty close, less than a foot away. So again, important. She's within a foot of this man, following his orders, listening to him. And we're supposed to believe she doesn't know he's an officer. And does she go up the stairs? Yes. Do you follow her? Yes. How far behind her are when she's going up the stairs and you're going up the stairs? About 3 to 4 steps behind her. If you're going up the stairs, you're able to see your vehicle? Yes. And the lights are on? Yes. So you can see the lights. She sees the vehicle. She knows there's an officer behind her. And you said your rear lights, the red and blue, yes. And okay, she goes up the steps. You say you're 3 to 4 steps behind her, and what happens next? At that point, she turned around rapidly and lunged towards me. Okay, when she lunged towards you, what happened? I saw a shiny object and it stabbed me in the neck. Okay, how did you react to that? At that point, I kind of fumbled backwards, took a few steps back. I notified on our dispatch that I was just stabbed in the neck. And what did she do? So she fled northbound or fled up the dock. Okay, towards the roadway. Now, you've taken steps back. Are you still in the dock or are you down the sand area? I'm just like about the sand area. Okay, describe what you're doing with your neck at that point. I began seeing a lot of blood coming out of my neck and it started squirting. And what did you do in regards to that? So I ended up taking my left hand, and holding pressure on my neck to try to stop the bleeding. Do you have anything in your hand while you were doing that? Yes, my flashlight. Okay, at some point in time, did you ever draw your weapon? Yes. And describe how that occurred. At that point, I drew my agency weapon as she was fleeing northbound and began to yell at her to show me her hands. At that point, I fired a round. How many shots did you fire? 1. So, where were you at the point on the dock when that occurred? About 15 feet from her. Okay, now do you make it off the dock onto the roadway? Yes. Where was she at that point? At that point, she began to flee a little bit northbound, back eastbound onto the beach area through some woods. Give me 1 second. This cough does not leave me, by the way. So at this point, he's describing, it sounds really bad for her, right? Like, obviously, the defense hasn't crossed yet, but this isn't sounding good. It's sounding like she knows exactly this is an officer. So I just kind of stayed in the area holding pressure along my neck to try to stop the bleeding. I didn't chase. I just kind of held down the area, stand there with my weapon to make sure she didn't reappear. Did you call anyone for service at that point? Can you repeat? Did you call anyone for service? Yes, I called for other units in the area and for rescue. All right. So blank. You describe being stabbed in the neck and you say it was squirting. You're holding pressure. How are you feeling at this point, your body-wise? I'm feeling scared. I didn't feel like, I felt like a little bit off, like I was pain coming down my left arm. Did you feel lightheaded at all? Yeah, a little bit. What was going through your head at this time of it happening? I thought I was going to die. Now, did you eventually, how long did it take for the EMS to get there? About 2 or 3 minutes. Okay, did anyone arrive at the same time? Yeah, Deputy Guerrero. And did you speak to Deputy Guerrero? Yes. What did he say to him? I explained what had happened and where the suspect had fled to. Okay, did you not go attempting to find the suspect? No. When EMS arrived, what did you do next? I walked to the back of the EMS truck where they began to render first aid to me. Let me ask you this, and if you don't, I can refresh your recollection. Do you remember around what time that evening you came into contact with her on the beach? No. Your Honor, may I approach the witness? You may. Deputy, does that refresh your recollection as to around the time you called out or some came into contact with her? Yes. What time would that have been? About 11:22. All right. So roughly 22 minutes after the accident is when you came into contact with the suspect. Yes. Now, can you describe what she looked like? So, I mean, I'm going to be honest. You have 22 minutes. You've been standing around with people. You know 911 is called. And you wander off and you're looking for your phone. I'm not seeing the defense here saying she somehow didn't know this was an officer. Like, she even knew 911 was called, right? I mean, at the very least you assume, but I'm assuming she heard them say they called 911. She was a white female wearing a green shirt. She had shortish red hair. Is that the person in the courtroom today? Yes. Can you point at her and describe an article of clothing she's wearing? She's wearing a black jacket and pink shirt. Okay, Your Honor. Let the record reflect the defendant. The witness has identified the defendant. Proceed, counsel. Mr. Stone. Now, Deputy, I'm going to ask you this. It seems like kind of a dumb question, but did all of this occur within St. Lucie County? Yes. Okay, so Deputy, do you have when you got to the hospital, and I know what occurred while you were there at the hospital, yeah, they immediately brought me in to get a CAT scan, and they brought me into surgery immediately after that. Okay, and you're aware of what occurred? Yes. What happened at the surgery? Surgery, yeah. So they had to make a repair to my carotid artery. And how did they make that repair? They had to take a piece of my artery out of my leg and attach it inside of my neck to replace it. Do you have a permanent scar from that? Yes. Where is it at? It's on the left side of my neck. Can you point to it, and how far does it go? Where is it? Goes down to about just about my chest. Do you have any permanent issues, ongoing issues since that day? Yes. And what are they? I have a little bit of numbness in one of my fingers on my left hand. Then I have a pretty much follow-up with my surgeon for almost the rest of my life, just to, on a yearly basis, to ensure everything is going fine. And why is that? Why does it say you need to do that? Because they're scared that the artery might eventually clog up and cause a stroke. Now, Deputy, what I'm going to show has been marked as States 1. Your Honor, may I approach the witness? You may. Deputy, do you recognize what this is? Yes. What is it? It's my uniform from that night. And how do you know that's your uniform from that night? It's got my name tag on it. It's got my blood all over the front. Is it a fair and accurate depiction of what your uniform was that evening? Yes. Mr. Stone, Your Honor, at this time, the state would like to introduce States 1 into evidence. Any objection to States 1? Mr. McRae, I have no objection, Your Honor. Your Honor, at this time, I would like to ask the witness to step down and publish the uniform to the jury. The court, all right, it's been previously marked as States 1 for identification, now in States Evidence 1. Deputy, you can step down. Oh, this is interesting. Ooh, this is interesting. So they're asking the deputy to show it. I want you to hold it and show it to the jury. Now, deputy with that uniform, I see the insignias on the arm. Can you elaborate on all that stuff that's on the uniform as far as similar to what you described before with the Class Bs you're wearing today? So on the left side is my badge. On the right side is my name badge. It's my name. Up on the shoulder, it says Sheriff's Office, St. Lucie County with a star around it. And there's a stripe on my shoulder indicating I'm an FPO. All right, thank you. Can you go back and have a seat, deputy? Deputy Blank, I'm going to ask you, do you guys have body-worn cameras? Yes. Now, were you wearing body-worn camera that day? Yes. Can you describe exactly what body-worn camera is and what it all captures? It's a camera that I have in the center of my chest. It activates shortly after being dispatched to a call, and it records audio and video from the time I get dispatched to the call to the time I clear the call. Was it activated that evening? Yes. Do you remember when you activated it? Shortly after getting dispatched for the call for the service. Okay. Now, what all does it capture? Does it capture this video? Where it captures video, audio, it's got a GPS on it that tracks my location while it's on, so it's viewed, so you can see where I was on that part of my video. Okay, deputy. What I'm going to show you has been marked for identification in States 12. You can take a look at this for me, deputy. You recognize that? Yes. What is that? It's the video of my body cam. How do you know what that is? Because I previously viewed it. And did you put any markings on it to ensure that's the video you viewed? Yeah, I initialed right here on the bottom. Is it fair and accurate depiction of your body cam from that evening? Yes. Mr. Stone, Your Honor, at this time, the state would like to introduce States 12 into evidence. No objection, Judge. All right, without objection, what's been previously marked as States 12 for identification is now in evidence of States 12. Mr. Stone, Your Honor, may we approach, and there's a bench conference. Mr. Stone, Your Honor, at this time, I'm going to publish the video. Request a redaction instruction. Okay. Mr. Stone says okay. The court, no problem. End of bench conference. Mr. Stone, at this time, the state would like to publish States 12. The court, all right, members of the jury are about to view a video recording. The court instructs that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and should not impact the way that you view and consider this evidence. The video recording starts. Male voice, 377. Female voice, 377. Mr. Stone, live in courtroom. Now, deputy, this goes on for about 10 minutes, correct? The witness, yes. Mr. Stone, it's safe to assume that you would have passed. You passed that dock with your lights and sirens on, the dock that you came to contact with. Yes. Yes, okay. I'm just gonna proceed forward past this point. You watch this. This is you traveling to the location, correct? Yes. Male voice indiscernible. Female voice 10-4. Male voice indiscernible. Deputy Blank 330 indiscernible. Female voice indiscernible. Deputy single laney indiscernible. Walking along the woods and along the shore northbound. We're just pulled into the area looking for a possible indiscernible. Hello. Male voice indiscernible. Deputy Blank, you can go on. Sorry. Male voice, thank you. Deputy, yep. Yeah, I'm on the dock. 10-4, 10-4. I'm going to undiscernible. Look back. 51. Can you undiscernible? What was she wearing again? Male voice, black hoodie, a tall, skinny, white female. Deputy, 10-4. Male voice, hey. Deputy, yeah, go ahead. 10-23. Hello. The defendant, hi. Deputy Blank, what's going on? Can you stop real quick? Possibly 10-12. Signal 3 Charlie. What's going on? The defendant, I don't know. Deputy Blank, you don't know. The defendant, no. Deputy Blank, all right, you just hit, you were in a crash, ma'am. Come up here. Don't walk away. The defendant, wait, indiscernible. Deputy Blank, no walking. Come over here, okay? The defendant, okay, crying. Deputy Blank, walk upstairs. All right, let's get out of the water area. The defendant, crying, I'm scared. Deputy Blank, you're scared? The defendant, yes. The Deputy Blank, all right, let's walk up here and get out of the water, okay? The defendant, okay. Defendant Blank, don't run, only walk. The defendant, crying, okay, makes noises. Deputy Blank, what the fuck? Indiscernible. I've been stabbed. SO, get me traffic. I'm bleeding. Show me your fucking hands. Gunshot, indiscernible. Give me rescue. Shot fired. White female northbound. White shirt. Gray, heavy breathing. Stabbed in the neck. Heavy breathing. She's right here in the woods somewhere. Give me rescue. Undiscernible. Heavy breathing. She's in the woods. Gray or green sports bra, black pants, red. Heavy breathing. She went to the woods. I'm stabbed in the neck. Deputy Guerrero, she stabbed you. Yeah. Deputy Guerrero, show me your fucking hands. Deputy Blank, okay. Deputy Guerrero, where are you at? Come out of there. Deputy Blank, rescue. I'm stabbed in the neck. Deputy Guerrero, it's a knife, right? Deputy Blank, yeah. Deputy Guerrero, get the fuck up here now. Get the fuck up here. Deputy Blank, it's clear for rescue. I'm walking down the road. Start. Siren, engine noises. Deputy Blank, a lot of blood. Indiscernible, down. EMT, indiscernible, right. Deputy Blank, yeah, tell me when you're to indiscernible, pressure. EMT, not yet. Not yet. Sorry, that made noise. Deputy Blank, ready. EMT, okay. Help me get this. I'm taking off. Video recording, stop. That's something. Mr. Stone, no further questions, Your Honor. The court, cross-examination. Mr. McRae, thank you, Your Honor. May we please the court, opposing counsel. Okay, now we get to see the defense try to... I don't know what they do. It's very obvious this is an officer, right? It's very obvious. I think everyone knows it. Good morning, Deputy Blank. Good morning. I speak for all of us when I say it's an upsetting video. Are you back on the job now? Yes. Okay. Obviously, that video is upsetting for a number of reasons, but we're thankful it wasn't worse. But I'd like to, do you recall when you and I spoke during preparation for trial? It was a while back. I can understand if you don't remember, it was back in November of 2022. I believe so. Okay, I just wanted to remind you of who I was, and I do represent, I'm trying to keep this, Leigha Day. Trying to make sure I keep it straight. At least say it the same if it's wrong. Let's talk again about what happened. You got a call in from someone who had observed a crash or observed a car that had crashed. Is that correct? Yeah, I got a call for people that observed a crash, and okay, so you're riding along, right? You responded to the scene. There were a few people there, presumably people who live in the neighborhood. Is that right? Yes. So when you got there, you're aware of them. Your kind of situational awareness is on high. Is that correct? What do you mean? I mean, you're on, something is going on here. We've got a crash. The person who's in the crash is not in the vehicle. There are people from the neighborhood who are out there flagging. You down. So you got a number of things that you've got to be aware of, correct? Okay, that would be a yes, right? Yes. I think the deputy's not happy right now. Thank you. Can you estimate how many people came out to talk to you, screaming at you, deputy is over there, there's a car there, or anything like that? Can you estimate? I don't recall how much. Fair enough. Do you take any information from any of those witnesses? Information, what do you mean by that? Like, did you get any names? No. Okay, so you proceeded onto the crash site, which you located fairly quickly, correct? Yes, there are already deputies there. Okay, driver's not in it. You then drive due north at a relatively slow pace looking for the driver, correct? Yeah, I continued north to look for the driver, yes. Yeah, and part of that was looking onto the sand to see if you could follow footprints and so forth. As you said, it was dark that night, right? Yes. So your visibility, or depending on your visibility by your flashlight, yes. And as we saw, it was a pretty bright flashlight. You eventually find Leigha Day, and as the jury just saw, she was, would you estimate, just ankle deep in the water there? Would you say it's accurate? I don't remember if she was in the water, but it didn't appear. Okay, it didn't appear? From what I recall, no. That's fine. Did she appear upset to you? Yes. Did she appear distraught? Yes. Did she appear scared? She said she was scared. Okay, so what the jury just saw and what you encountered was this woman there, but at no time were you able to see what was in her right hand prior to your encounter with her, correct? When I first walked up, there was like maybe a wallet or a phone or something, but that was it. All right, and you said that your first words you heard when we heard them, you got your flashlight out there, your hello, correct. Hello, were you just in a crash? We saw her response. I don't know. She seemed almost nonverbal. Would you agree with that? She almost couldn't speak to you to tell you what was going on. Mr. Stone, objection. Judge, can we approach? Counsel, approach. Bench conference. Mr. Stone. Judge is kind of dancing around the motion in limine. He's saying nonverbal, not able to speak. It's almost like we're trying to get into what she said. Distraught, said she was scared. I'm worried that we're going down the avenue trying to discuss that she might have been on some sort of diminished capacity. That's all. Mr. McCrae, oh no, okay, that wasn't my intention. Court, all right, at this point, Mr. McCrae, I'm done. The court, it's still a description. Mr. Stone, yeah. The court of what he's observing, okay. The court, which is fine, just be very careful, Mr. McCrae. Yes, sir. That you don't start asking about any mental state or anything like that. Mr. McCrae, no, I'm just going. The court, just as observations. Mr. McCrae, right. Court, okay. End of bench conference. Now we're back to Mr. McCrae. So what we're talking about is your observations of her actions while you were engaging with her, the intent to find out what was going on, right? When you told her to stop, we started walking a little bit. You told her to stop. Did she comply immediately? Yes. And you could not observe her right hand. You could have the light on her. You could see her body clearly. Is that correct? Yes. But you couldn't see clearly what was in her right hand. No. Behind her back, was it your impression that she knew you were a police officer? Yes. Okay. I'd like to draw your attention to the deposition, your deposition I took on November 21st, 2022, if you'll give me a moment. Mr. McCrae, I would like to direct counsel's attention to page 10, lines 10 and 11. May I approach the witness, Judge? You may, Mr. McCrae. Deputy blank. I'm going to approach you and hand you a copy of the deposition in which I question you regarding a specific issue. Can you read lines 9 through 12 to refresh your recollection? So do you, the court, deputy, to yourself. The witness, oh, court, just read it to yourself, sir, by Mr. McCrae. You can just look up whenever you're done. Answer, yeah. And take your time, okay. Mr. McCrae, may I approach, Judge? You may. Mr. McCrae, thank you, sir. So your question today in court, when I asked you if you felt she knew that you were a deputy, you said yes, On that deposition, November 21st of 2022, I asked you, is it fair to say that she would have just seen you in a silhouette, or do you think she might have been able to identify you immediately as a police officer or a deputy? Your response, I'm not sure. There was, my car had lights on. There were lights from before from the vehicle where I was walking from. Do you recall that? Yes. Okay. I see what the defense is cooking. I see where they're going. I still think it's obvious. I still think there really isn't a question that she knew. I mean, I could argue, well, immediately, maybe not, but then, there was a continued moment of them talking, her approaching within a foot. Like, even if she immediately didn't know, lights flashing, asking about the wreck and all of that, there's no way you wouldn't know. First glance, sure, I can give it to the defense. Sure, first glance value, right? But it doesn't take long. So, as far as this issue, when you first approached her, you said, hello, have you been in a crash? You didn't immediately identify yourself as law enforcement, correct? Yes. Okay, so did she comply with you? You told her to stop. You wanted her up on those stairs off the beach and figure out what's going on. You're taking her into custody, get her medical help, whatever she needed, but your objective at that point was to get her off the beach, up onto the road where where the other deputies were responding in large numbers. Is that accurate? To get her up in my vehicle, yes. Again, if she doesn't know it's an officer, why is she following his orders? And how do you not know it's an officer when you get within 1 feet? Like 1 foot, right? Yeah, you wanted to get up by your vehicle, that's better put, but you never told her to lie down. Well, I'll make sure I said it. Oh, to get her up by my vehicle, yes. So you want to put her by your vehicle, that's better put, but you never told her to lie down. Let me see your hands spread out. No. Well, he had no reason to, right? Like, you don't think this woman's just going to attack police. She got into a car accident. Okay, you got her up, you told her, let's go, and you terrified her, she got very close to you, she walked by you. That's the whole reason this court case is so interesting to me, is it's so out of nowhere. No one's going to suspect that attack, right? No one's going to suspect that. and directed her towards up those wooden steps. There's a lot of them along that road. You know, she walks very close to you, up the steps, turns around, stabs you in the neck, takes off, correct? Yes. Okay, could you see her body? Did you see her when you fired? Yes. Again, what does this matter? If my argument is that she didn't know it was an officer, what does the shot matter? I'm not seeing it yet. I'm not seeing it. And would that have been because your flashlight, or what light would have given you the ability to see Leigha Day as she left that dock? Oh, multiple lighting. My flashlight and other sources. Like maybe his police lights? Okay, all right, sir. What happened at this time? If you know, because after this, you're in a situation, you're in a crisis. I mean, this is when EMS was going to take over and get you to the hospital as quickly as possible. This may not be a question you can answer, but do you know if the people who called this in were still around at the beach when you came up the road? Right there? Yeah. No, I wasn't in the area where they called in. Okay, so you were still farther south, right? A little bit. All right. And the car, again, I'm sorry, can you explain the situation, the position that the car was in, and where it was in relation to Indian River Drive? My patrol car? No, sir. Miss Day's car, the crash. I never saw her car. Okay, so do you recall whether it was in the bushes, in the middle of the road, on its side, on top, or its tires? I couldn't tell you. All right, sir. Thank you, Deputy. I'm glad you're better. I'm back on the job. I have nothing further. Judge. State any redirect? Yes, Your Honor. Now we're at the redirect examination. Deputy, you actually never made it to the crash site, correct? Sorry, I got like emergency alert. No, you stopped short of it? Uh-huh. And then you started going northbound? Yes. So what I'm going to do is I'm going to show you what's been marked as Stage 12 that you already watched a while ago. This would be your body cam. If you want to look behind you or look to the right, whichever is easiest for you. So the question you were asked in your deposition is, when you came into contact, would she have been able to immediately recognize you? Is that accurate? Is that the question you were asked? Yes. So I'm going to show you what's marked State 12 here. Video recording started and stopped by Mr. Stone. At this point, is that her off in the distance? Yes. How far away would you say she was when you were standing on the dock when you first came into contact with her? Mr. McCrae, stalls for speculation, Your Honor. The court. He overruled. He can estimate the distance. The witness, 20, 30 feet. Okay, video recording restarted. Deputy, hello. The defendant, hi. Deputy blank, go ahead. So here's where you contact with her. Again, you would consider this still intermediate contact with her. Yeah. And where were you standing in relation to her? Up on the dock, okay, and she was on the beach. Now, if you look at the tree line above you, yes, sir, what do you see? I see blue lights. And what are those from? My patrol vehicle. She can see the lights. She could always see the lights. Okay. And the thing is, oh, it was dark out. That doesn't help. That just makes the lights more prominent and noticeable. It's blue light. It's red light. You see that. Okay. Now you're still out. How far of a distance from her do you think you're at this point? 15 feet. Video started. Hello, defendant. Hi, what's going on? The defendant, indiscernible. Deputy, can you stop real quick? Video recording stopped. You asked her to stop and she complied, correct? Yes. Okay. Video recording started. Possibly 10-12. Signal 3 Charlie. What's going on? Video stopped. You're having a conversation with her. She's still at this point. You're still far away from this point. 10 feet. Okay. Now listen. Listen. If someone asks you to stop, let's say you can't see them, right? It's completely pitch black. They're a black silhouette. You have no idea. It's a man's voice. You can't see them. And they ask you to stop, and then they say, you hear them say, possibly 10-12, signal 3 Charlie, what's going on? How much brain power does it take for you to go, that's a cop? Or at the very least, probably a cop. So now you're having a conversation with her still at this point, and you're how far away at this point still? 10 feet. Okay, video recording started. Defendant, I don't know. Deputy, you don't know. Defendant, no. Deputy blank, all right. Were you just in a crash? Ma'am, come up here, don't walk away. The defendant, indiscernible. Video recording stopped. By Mr. Stone. So she tries to walk away. You ask her to stop. Does she stop? Mr. McCrae, he's testifying here. We've already been through this, Judge. The court overruled. Does she stop? Yes. Does she comply with you? Yes. Video recording started. Deputy blank. No walking. Come over here, okay? The defendant, okay, crying. Video recording stopped. So now we're how far from how much time do you think has elapsed in you and since you originally saw her at this point? 20, 30 seconds? Okay, so how far away from her are you? Less than a foot? At this point in time, is she able to recognize that you're an officer? Yes. Mr. Stone, no further questions. The court, any follow-up, Mr. McCrae? Yes, thank you, Judge. So the state did what I thought, right? If at first glance she didn't know you were an officer, 20 to 30 seconds later, everything being said, the light shining, she knew. Deputy blank. First of all, let's talk about your flashlight. You had testified earlier that you were shining the light sort of around her so you could gain familiarity with her surroundings, correct? Yes. As well as keep an eye on her. But there was, what we just saw there, the flashlight was in her face for a moment of time. Do you agree with that? No. You wouldn't agree that flashlight was shining in her face? No. Okay, would you say she identified you? How you know she didn't say you were law enforcement? Because she could clearly see by my uniform and the lights up above, listening to commands. Do you know if she wears glasses or contacts? No. Do you know if she can see? Do you know the limitations of any hearing she has? No. Or vision? You never did say police or deputy, do you know? Hold up. She was driving the goddamn car. Unless they're going to say she has eye injuries, and even with an eye injury, right? Even with let's say a really bad astigmatism, I'm thinking here. There's a reason I'm thinking like this. With a really bad astigmatism, without a contact in, which is literally my left eye right now, by the way, because I need to get a new prescription. My old one, my astigmatism shifted, right? And I haven't bothered to go get it done. With this, and I would say that right now, like if I look at my computer screen, I can't see words. I can't see letters. I can't see, like that. It's blank white. Like I want to be clear to you. The page I'm looking at is blank white. With this, there is blue. Now, in thin lines, I can see blue. In thicker blue, from my recording software, I can see blue. The little red dots, I'm going to be honest right now, I'm giving you a real play-by-play. I can't see it. But if I spike my voice, and it spikes, I can see red there. From a line. I would argue that as long as she can see enough to walk around, she can see the police lights. And as for hearing, she's following the commands. This wouldn't work for me on the jury, is what I'm trying to say. This doesn't play. This doesn't play at all. Because it doesn't make sense. I mean, there's a lot of things where you could be like, well, maybe she has some disability. But, I mean, if you're driving a car and you are given that license and you don't have a new injury since you've been given that license that is being established, you are given the right to drive a death machine down the road. I think it's fair to assume you have basic mental faculties, you have basic functioning vision at the very least. You know, being deaf, I could see, maybe, right? Like people do drive that are deaf, I believe. Which with sirens, I would be worried. But I'm sure they have some way to compensate for that. Audio detector, maybe set off a light or something on the dashboard. If not, they need to make that. This just isn't flying for me. This is, And at this point, it feels almost like you're insulting the victim. Kind of like with the shot, right? Oh, you shot at her, but you missed. It doesn't play. It doesn't play. But I've ranted enough. Let's get back into it. Did you know what she could see? Do you know the limitations of any hearing she has? No. Or vision? You never did say police or deputy sheriff, did you? No. Nothing further. State anything additional for Deputy Colangio. No, Your Honor. Is he subject to recall or release? He can be released, Your Honor. Do you agree, counsel? Yes, Your Honor. All right, Deputy. That will include your testimony in this trial. You're free to go, sir. Ladies and gentlemen, how are you doing? Does anybody need a break? All right, we're going to take a short recess, about 10 minutes, give everyone an opportunity to give their faculties a stretch their legs. Use the facilities and stretch your legs. If you'd like to take the pads face down on your seats, we'll follow the deputy, please. The bailiff, watch your steps. Coming down, please. I'll stand for the jury. All right, just taking a second here. The defense is screwed. I don't know. I don't know what you do, right? What do you do? Like it has shades of Sarah Boone in the way that, is this person, they're not a killer, but attempted to kill? I think the answer is always yes. Like, that's not a question. So now the question is, what charge should it be? And in Sarah Boone, you would say, well, was it manslaughter? Was it negligible homicide or something like that? Negligible something. I forget what exactly the word was. Or was it second-degree murder, right? In this case, they're fighting over, it sounds to me, and we'll see as it goes, about whether this was her trying to kill this police officer, knowing they were a police officer, so it matters because it's a different charge. And I would argue that the defense has done absolutely nothing to assist. And the thing is, I don't know the jury makeup, but if there's an older person on the jury, right, there's a lot of older people on the road, and older people in general have vision problems. And some younger people have vision problems. Hey, like I was talking about my eye, right, my vision. They're gonna know she's full of shit. People have seen police lights. But even without the lights, if you put yourself in that exact situation, you say you flipped a vehicle, you were looking for your phone, you left the scene, you were walking down the beach, and someone approaches you with a flashlight giving orders, who do you believe that person is? You're going to assume it's an officer. There's not a reasonable doubt that you don't know it's an officer, or at least think it's an officer. Even if it wasn't an officer, I would think you would think it's an officer, right? But let's continue. Watch your steps. Coming down, please. I'll stand for the jury. I'll exit. The jury has exited the courtroom. Counsel, 10 minutes. Thank you, Your Honor. Thank you, Judge. Court recessed. Court reconvened. All right, we are back on the record. State of Florida versus Leigha Day, number 22 CF726. Ms. Day is present with counsel. I'm going to skip this part. It's just them going through the start here. All right, so next witness is Deputy Brian Guerrero. Getting sworn in. Good morning, sir. Good morning. Would you please introduce yourself to the jury and spell your last name? This is the state going first. I'm Deputy Brian Guerrero, last name Guerrero. Thank you, sir. What do you do for a living? I'm a deputy for the St. Lucie County Sheriff's Office. I'm currently assigned to road patrol. Okay. How long have you been with the Sheriff's Office? Approximately 6 years. All right. And you said you were assigned to road patrol. Were you in those same duties back in March 23rd of 2022? Yes, sir, I was. Okay. I want to direct your attention to that date around 11 p.m. Were you called to South Indian River Drive? Yes, I was. All right. And did you arrive upon a scene of some sort? Yes. And what did you see when you got there? I arrived at what appeared to be a traffic crash. It looked like a car was disabled and there was nobody in it. Okay, and do you recall what it looked like? What did the car look like? You said disabled, but it looks like it wasn't running. There was, I'm not sure if it was off or not, but it looked like it was scraped up and busted glass. All right. Without saying the conversation, did you stop at the scene? I did. Did you have a conversation with any witnesses? I did. Okay, what did you do after you spoke with the witnesses? After you said, well, I heard the deputy over the radio. I heard something strange come over the radio. Said that he had been hit and he was shots fired. Okay, so I proceed to go towards him. And who was that? Deputy Blank. All right, so you heard him say that he had been hit. Correct. Okay, and what did you do immediately when you heard that? I entered my patrol vehicle and started heading towards him. Okay, and you started heading towards him, which was what way? Which way was that? It was northbound on Indian River Drive. Okay, and were you by yourself? I was. Okay, and so you got back in your vehicle. Did you drive north? I did. All right. And what happened next? During my on my way, I seen Deputy Leckenbusch running in the same direction as me. I stopped and picked him up. Okay, and he entered the rear of my patrol vehicle. So Deputy Leckenbusch had been on foot, correct. And he entered your vehicle when you saw him, correct. And did you know at this point where Blank was? Not exactly, only by the lights. Only by the lights. Let that sink in. I could see some lights. I didn't know where he was, but I was going towards his lights. The lights. What kind of lights? The lights of his patrol vehicle. Okay, and you can see those up ahead, correct. Did you eventually make it to his patrol vehicle with the lights on? I did, all right. And what did you do when you got there? I seen him bleeding from the neck, and he said that, hearsay, Judge. The court, do you want to be heard? Mr. Bruin, no, sir. All right, sustained as a hearsay by Mr. Bruin. Okay, did you have a chance to observe Blank? I did. And, okay, and what did Blank look like at that point? He was holding both of his hands to his neck, and he was bleeding pretty profusely. Okay. Did you, at some point, did you leave him? I did. Okay, what did you do when you left him? I went to go look for the defendant. Okay, and the defendant, you mean the person that had stabbed him, correct? Okay, where did you go? I went towards there was like a wooded area right next to Indian River Drive, so we went down. I went down some balcony stairs, and as I was going down some balcony stairs, I could hear a female voice coming from the shoreline, like in the water. Okay, and where was Deputy Leckenbusch at this point? He was a little bit north of me. He was on the other balcony. Okay, but in the same general area. Correct, yes. And you said you heard a voice? Yes. Did you at some point see someone? Yes. Once Deputy Leckenbusch said he had eyes on her. Okay, so you heard him call out that he saw somebody? Yes. Objection calls for hearsay response, Judge. The court, all right. As to what Deputy Leckenbusch stated, sustained. Okay, so what did you do next? I went towards Deputy Leckenbusch and the subject, the defendant. Okay, and it's the subject. Was it male or female? It was a female. All right, and where was she? She was like 20 yards into the water from the shoreline. All right, was it deep water? It was like halfway towards like waist level to her. Okay, what do you do next? I gave her multiple verbal commands to come, exit the water, and eventually she did. All right, when she exited the water, did you walk towards her? Yes, we did. And it was you and who else? Deputy Leckenbusch. All right. Did you have a chance to take her into custody? I did. And how did that occur? When she gave her verbal commands, we told her to get on the ground. When she got on the ground, then we detained her and placed her in handcuffs. Okay. When she got on the ground, did you put her in cuffs? I believe it was Deputy Leckenbusch. Okay. Did you get down on the ground with her? I did. And did you hear her say anything at that point? Yes. She made a comment of, I can't believe I did. I just believe that one of y'all. I can't believe I just did that to one of y'all. Okay. So at this point, when you take her into custody there, she says that you're still by the water. Yeah, we're like by the shoreline, basically, like water still coming up, but it's on the sand parts. Okay, and does she get put in the cuffs? She does. And then what happens after that? Once we detain her, I go and try to go ahead and assist Deputy Blank. Okay, so you left the defendant with the Deputy Leckenbusch. I did. Okay, and did you find Blank again? Yes, I did. And what happened after that? He was in the ambulance by the time and fire rescue were assisting him. Okay. And did you go to the hospital with Deputy Blank? I did. Did you ride in the ambulance with him? I did. Okay. And this, did you have a body camera that night? I did. All right, Mr. Bruin, may I approach Your Honor? You may. I'm showing you what's marked as States 13. Take a look and tell me if you recognize that. I do. How do you recognize it? By my initials on it. Okay, have you viewed this? Yes, I have. Okay, it's totally fair and fairly accurate represent what happened that evening. Yes. Okay, state would seek to introduce States 13 evidence. No objection. Thank you, counsel. All right, without objection, it's brought in. I'm not going to quote this part again because we've read it. It's the jury instruction about edited footage. Deputy Guerrero, indiscernible. Right there. I think she's running. Unidentified voice. Running. Deputy Guerrero. Watch out. Watch out. Oh my God. Fuck. Hey, hey. We need rescue over here. Where are you at, Blank? Get in. Get in. Get in. Deputy Lecken. Go. Indiscernible. Deputy Guerrero. Yes, sir. Deputy Blank. She's indiscernible. Deputy Guerrero. She's back there. Deputy Blank. Yes. Deputy Guerrero. Show me your fucking hands. Where are you at? Come out of here. Show me your fucking hands. It's a knife, right? Deputy Blank. Yes. Deputy Leckenbusch. Get the fuck up here now. Deputy Guerrero. You better get the fuck up here. Dispatch operator, 10-4, clear for rescue. Deputy Guerrero, here we go. Hang on, Leckenbusch. Fuck siren. We have her. Deputy Leckenbusch, I don't have her. Deputy Guerrero, we don't have her. She's in the water coming back. You better come up here and stay to the fuck on the ground. Deputy Lecken, get over here. Deputy Guerrero, yeah, we're trying to get her to come back on the water. Deputy Lecken, get over here. Deputy Guerrero, get over here. Walk to the sound of my voice. You better indiscernible or I'll fucking shoot you right now. Deputy, the defendant, heavy breathing, crying. Deputy Lecken, I got her. Deputy Guerrero, indiscernible. Defendant, I do believe I just stabbed one of you. Deputy Guerrero, indiscernible. The defendant, heavy breathing. Dash operator, all units. The defendant, heavy breathing. Deputy Guerrero, let me check on him. Deputy Leckenbusch, stand up. Blank, all right? Deputy Guerrero, I'm going to check on him. I'm going to be back. Blank, blank, you good? Deputy Blank, put those in my car and indiscernible keys. Deputy Guerrero, I gotcha. Deputy Blank, can you indiscernible? EMT, you're going to be okay, buddy. We're just going to get the Deputy Blank. I'm trying to indiscernible. EMT, relax. Deputy Blank, indiscernible, okay. EMT, what's your name? Deputy Blank Blank, indiscernible, 10-12. Deputy Guerrero, you're working on him. Indiscernible, he was stabbed. EMT, indiscernible. Deputy Guerrero, absolutely. EMT, what's that, a gunshot or a stab? Deputy Blank, stabbed. EMT, stabbed, okay. Deputy Blank, indiscernible. EMT, okay, all right. Indiscernible conversations. Deputy Guerrero, you're good. EMT, you're looking good. Indiscernible. EMT, I got you. Deputy Guerrero, you're going to be all right. An identified voice. You're doing good, Blank. Just hang in there, Deputy Guerrero. Hey, I need a driver. Indiscernible conversations. Identified voice. I'm your driver. Unidentified voice. Indiscernible back there. Indiscernible voice. We're going to move him. Unidentified voice. Okay. Deputy Guerrero. They're indiscernible about half a mile down in the water. Unidentified voice. In cuffs? Cuffs, Deputy Guerrero. Yeah, give me a second. Unidentified voice. Indiscernible. Deputy Guerrero, give me a sec. I gotta get out. I gotta get out my phone. Hang on. EMT, need to get out? Deputy Guerrero. Yeah, I need to get out. EMT, hold on. Deputy Guerrero, let me get my phone. Give me a second. Unidentified voice. You want me to get your car? Deputy Guerrero, yeah. Unidentified voice. Indiscernible. Deputy Guerrero, no, I'm going to ride with him. Let me get my phone. Unidentified phone. I'll move the car for you. Deputy Guerrero, thank you. Unidentified voice. Okay, what you need? Deputy Guerrero, unidentified voice. Where are they? Indiscernible. Deputy Guerrero, where's my fucking phone? Unidentified voice. Hey, don't worry about it. Take care of your partner. Deputy Guerrero, indiscernible. Unidentified voice. Where are they at? Deputy Guerrero, they're done there. Identified voice, my car. Deputy Guerrero, let me get in. Hey, indiscernible, can I get in? Hey, let me in. Unidentified voice, you want indiscernible? Yeah. Please, I gotta go with him. Unidentified voice, indiscernible, get you to the hospital. Deputy Guerrero, do you want me to be back there with you? Unidentified voice, indiscernible, passing station 12. Unidentified voice, all right, yeah. Deputy Guerrero, is he going to Lawnwood? Unidentified voice, yeah, hold on. Stand by. Deputy Guerrero, you okay? Indiscernible. Unidentified voice, are you going to intubate now? I think you're going to need to or not. Unidentified voice, probably going to need to intubate him. Stand by. Unidentified voice, I really need to get him hooked up. Deputy Guerrero, look at me. Indiscernible conversations. Unidentified voice, good. Unidentified voice, you okay, buddy? Deputy Guerrero, yeah, we're good. Unidentified voice, you good. Deputy Guerrero, yeah. Unidentified voice, all right, we need to get indiscernible. Unidentified voice, what do you need to do? Unidentified voice, we need to cut it off. Unidentified voice, get him hooked up to get him hooked up. Undiscernible. Unidentified voice, yeah, gotcha. Unidentified voice, I'm going to cut this off. 10-4. Unidentified voice, indiscernible female. Deputy Guerrero, you're good, Blank. Unidentified voice, we can just follow us if it's easier. Unidentified voice, I need blood pressure. Unidentified voice, indiscernible, coming in right now. Deputy Guerrero, you want me to get out of your way, bud? Unidentified voice, you're fine, man, you're fine. Deputy Guerrero, we're still on the drive. I'll let you know. Stand by. Unidentified voice, you okay, buddy? Unidentified voice coming in. Unidentified voice, perfect. Unidentified voice, you all right? Deputy Blank, yeah, just scared. Unidentified voice, we're going to take good care of you, okay? Unidentified voice, indiscernible. Deputy Guerrero, let me out of your way. Unidentified voice, yeah. Unidentified voice, all right, let's take off. Unidentified voice, all right. Deputy Guerrero, my deputies want to know where y'all are taking him so we can follow. Unidentified voice, going to Lawnwood. Deputy Guerrero, I know what street. You're going indiscernible and then US 1. Unidentified voice, hey, how you get to Lawnwood from here? Unidentified voice, US 1. Unidentified voice, going to take Walton onto US 1. Unidentified voice, let's get a secondary IV on him. Unidentified voice, how you feeling, bro? Deputy Blank, okay. Unidentified voice, you're doing okay. Deputy Blank, indiscernible. I told her to walk up the steps. She turned around and stabbed me in the neck. Unidentified voice, indiscernible will be all right. Unidentified voice, all right, let's indiscernible. Unidentified voice, I got it right there. Unidentified voice, indiscernible. Unidentified voice, we're taking. Deputy Guerrero, are we taking? Unidentified voice, we know that you're indiscernible right now. We got you, okay. Unidentified voice, we're going to get you fluids right now, get you masked what you're losing, all right. Deputy Guerrero, you're doing good, buddy. I got you. Unidentified voice, you need to indiscernible. Unidentified voice, Steven, indiscernible. Video recording, stop. What a hell of a transcript, right? That's going to stick with the jury. And now it's Mr. Bruin. And Deputy, you mentioned earlier that she made this statement. At what point specifically was that when she said something like, I can't believe I did that to one of you? We were putting the handcuffs on her. I heard her say, I can't believe I just did that to one of y'all. Mr. Bruin, okay. And Judge, can we play that part again? There was some court. Go ahead. Mr. Bruin fading in and out of the audio. Mr. McCrae, Judge, I would object to that. Hold up. The judge, the defense is objecting to replaying the victim admitting she stabbed an officer. The court, Mr. McCrae? Mr. McCrae, I respectfully object as cumulative. The jury will be able to get a chance to view this as many times as they want. The court. All right. To make sure that it was played smoothly, the state will be allowed to play that portion at this time. Obviously, ladies and gentlemen, any pieces of evidence that are entered, you'll have full access to. You can watch and listen to as many times as you like during the deliberations, but state, if you have it queued up, yes, Your Honor, go ahead. The defendant, heavy breathing, crying. Deputy Leckenbusch, I got her. Deputy Guerrero, indiscernible. The defendant, I do believe I just stabbed one of you. Deputy Guerrero, yeah, you are indiscernible. The defendant, heavy breathing. Video recording, stop. Mr. Bruin, no further questions. The court, cross-examination, sir. Yes, Your Honor. Please, the court. So now it's the defense. Hello, Deputy Guerrero. How are you doing, sir? Good, sir. Thank you. It looked like from your body cam, when you got to the scene, you responded very quickly, and it came across as a shooting, correct? It came across as a shooting? You were dispatched, said it was a shooting, shots fired. No, sir. I responded there for a traffic crash. Okay, so you didn't know anything about the shots fired before that? No, sir. Okay. Now when she said what were her exact words to you as far as what? As far as saying I can't believe I shot somebody or stabbed somebody, from what I remember, she was uttered is that I can't believe I just did that to one of y'all. Okay. Now, wasn't she advised of what she was being handcuffed for? I mean, would she have learned that from the officers who were taking her into custody? You just stabbed a deputy, you're under arrest for attempted murder. They would have told her that, correct? And that's typical procedure, correct? To tell somebody they're being arrested for? Not necessarily, depending on the scene and the circumstances. Okay, all right. So there's no possibility that someone said that other than, I can't speak for the other deputies, but I did not say that, no. Okay, fair enough. There were a lot of people standing while you responded. Did you talk to any of them? Yes, I talked to one bystander. Okay, let's talk briefly about the car. The car itself. Did you personally observe it? I did. It was in the middle of the road, side of the road was the position of the vehicle. I do not recall. Okay. Exactly how the position of the vehicle was. All right, sir. Now let's talk about, describe to the jury, which we just saw, where you identified that there was, you believed to be the subject would have been in the bushes, right? You had a flashlight, a handgun-mounted flashlight, correct? Correct. Pretty bright. So you get some decent visibility, and when you realize that she's out there, when you're running out, do you recall what your words were? When I'm running out, where? When you realize where she is, that you found this person that had crawled out of the vehicle, your first words were to put your fucking hands up, right? Correct. Okay, now that is for your safety, for her safety, for fellow officer safety. Your first response was, put your fucking hands up. Oh my God, we're doing this. We're actually doing this. They told her to put her hands up at this point because she'd already stabbed someone. The first officer to the scene had no understanding that this was a violent person. They responded for a car accident. This is a completely different scenario. Wow. I guess they don't have anything else to go on, right? Correct. And you went ahead and apprehended her, correct? Yeah, moments later. All right, but nobody told her what she was being arrested for. However, you did tell her to put her hands up, and I think it was pretty obvious that she at that point realized she was taken into custody by police. That was a fair assumption, wouldn't you? That's correct. Okay. Do you ever afterwards have a chance to look at the motor vehicle that was in the crash? Afterwards, no. Okay. Were you all, by the way the deputies issued standard flashlights? Do you have a choice to have one that's handgun mounted or handheld? Do you carry one? Do you carry both? It's whatever the deputy prefers. But we do get issued, the current firearms, we get issued a mounted light on it. Okay, very good. All right, Deputy Guerrero, I have no further questions for you. Thank you, sir. State any redirect briefly. Mr. Bruin says this. Sir, before she made that statement, would it be fair to say anything you had said to her would have been on body camera? Correct, yes. Okay, thank you. See, that's the thing. The defense is trying to be like, well, maybe someone else said something to her. Who? The defense is trying to argue that she still didn't know this was an officer, right? She wasn't told to put her hands up. That was wrong of the officer, and that also would have let her know that he was an officer in the first case. And maybe someone let her know the second time, and that's why she realized she stabbed an officer. It's obviously what they're going for. The court. All right, this is Deputy Guerrero released, subject to recall. He's released, Your Honor. You agree, counsel? Yes. Okay, conclude your testimony of this trial. You're free to go. All right, so now it's lunch. I'm trying to see if there's anything else worth mentioning here. All right, the jury has exited the courtroom. Counsel, I need you all back in seats ready to resume no later than 1:30. State, in reviewing the proposed instructions, there's no instructions for count 2 or 3. Mr. Bruin, that's correct. I realized that last night. I completed driving while suspended, and I will incorporate that and then send out another. Yes, sir. Okay, all right. Mr. Bruin, to be honest, I think we're still on pace to finish testimony today. Possibly get 1 or 2 more witnesses tomorrow morning and then go into closing. So the court, all right, let's make sure that we have accurate instructions. So you could work on that. That'd be perfect. Just send them to my office, to the counsel, okay? What could the witnesses for the defense be other than the woman herself? No one, right? I can't think. Everybody enjoy your lunch. All right, now we're back on the record. Let's see here. Jury's brought back in. And now it is John Leckenbusch's testimony. Good afternoon, Deputy. Good afternoon. Would you please introduce yourself to the jury? I'm Deputy Leckenbusch, St. Lucie, Florida Sheriff's Office. And Deputy Leckenbusch, can you please spell your last name for the record? Yes. Leckenbusch. And Deputy, where do you work? St. Lucie County Sheriff's Office. And how long have you worked there? 17 years. And prior law enforcement experience before becoming a police office deputy? No. Prior training to become an officer? Yes. And what was that training? Police Academy. And back on March 20th, 23rd of 2022, what were your duties that day? I was working with Road Patrol. And can you describe what the duties of Road Patrol officers are? Road Patrol varies greatly from traffic crashes to domestic violence encounters to disturbances of civil matters, so it's a gambit of everything. Gotcha. Did you happen to get called out for that service on the evening of the 23rd? I did. And what was that for? A traffic crash. Do you recall where that location was? It was south end of Indian River Drive, and you said south end, like how far south? Pretty close to the county line. Okay. Did you respond to that scene? Yes, I did. And when you got there, what did you see? I observed an overturned vehicle. Rescue was on the scene. There was another deputy on the scene. I also had some people tell me there was possibly someone who left the scene. Okay, now did you stick around the scene or what did you do? No, I was somebody on scene for the traffic crash. I got information the driver had left the scene and went northbound. Were you the only one that went northbound? Originally, I went northbound, and according to the witnesses, I went to the North Water way. Okay, did any other deputy go northbound? Deputy blank. Yes, went a little bit further north than me. We were trying to, box her in. So did you continue on the road, or is that an area you looked at, or no? No, I went to the water's edge on Indian River Drive. Deputy blank went a little further north on the roadway. Okay. How far down to the water's edge as far as the crash site did you go? I originally probably 25 yards up. I went down a dock and continued probably about 1/4 mile to 1/3 of a mile on the water's edge. Okay. Was there the dock you went down? Was there anyone there? There wasn't. Okay. Were you directed as far as path of travel of the person that might have gone? Yes, they indicated there was a female with a tall, skinny female went down the dock, and they went northbound on the water's edge. Okay, so I followed. When you went down there, did you notice anything in the sand? I noticed fresh footprints that were barefoot. Okay, did you follow these footprints? I did. How long do you think you walked along that way? Probably a quarter mile to a third mile. Okay, was your radio on at that time? Yes, it was. While you were walking, did you see anyone on the beach? I did not. Okay. At some point in time, did something come out over the radio that kind of got your attention? Originally, Deputy Blank said he have made contact with the female. At that point, I left the water and started walking, got to the road, and started traveling northbound on the road. Question, at some point in time, did someone else come up over the radio? Yes. I heard almost like an inaudible scream. You can tell it's like a panic sound. I started running at that point, and then he reiterated what happened. He said he was stabbed. Okay, now you started running. Which way were you running? Northbound. Okay. Only 1 second here. I think there might be something in this room, dust or something that makes me cough too. Doesn't help. Really need to look into like one of those filters that catch like allergens and hairs and stuff like that, and just let it run and just when I'm not doing things and let it pick up stuff. For quite a while, I wasn't 100% sure how far up he was. I knew it was north of me because that's where I instructed him to go. Eventually, did you see something? We did. What did you see? Oh, well, this patrol car with his lights on, so you were able to see the lights. Yes. Okay, at some point in time, did you make it all the way on foot to that location or no? No, Deputy Guerrero picked me up in his patrol car as he left the scene. After hearing more or less panic in Blank's voice, we left the scene of the crash because the road was already blocked. We continued up, and he picked me up in his patrol car. We continued the rest of the way. Okay, to get on the scene. When you were there on scene, are you the only two officers there besides Blank? Yes. Okay. Are you directed to go anywhere at that point? Yes. Blank appeared to be, holding his neck. He was telling us the direction. It was like a little bit northeast of the direction of when she went down the wooded area. So you were directed back towards the beach area. Yes. Okay. And when you say, was it you or someone else? Me and Deputy Guerrero. Okay. So do you guys go down to the beach area? We did. Okay. And tell me what you did while you were down there. We could hear noises coming from the beach area. As we traveled down, we started heading northbound because that's the last known direction of travel. As we searched, so I spotted a female in the water. Okay, did you give any commands to her? Yes, I commanded her to get out of the water. Okay. At this point in time, is it still just you and Deputy Guerrero there? Yes. Does she respond to your command? She does. Did she make it all the way to you? She comes the majority of the water. Yes. Once she got to you, what do you do next? We put her in handcuffs. All right. Do you hear any statements or anything she might have said at the time? I did not. Okay. Now, after you have her in cuffs, you got her there. At any point, does officer arrive? Any other officer arrive at this point? Yes. Deputy Kirshner arrived at the scene, and Guerrero left to check on Blank. Okay, so now it's you and Deputy Kirshner with the suspect, correct? What did you do at this point? We attempted to move her up to secure her in a patrol car. Many of the docks were broken. We passed several docks. We had trouble finding a safe way back to the roadway. At that point in time, did you come into an area with the actual scene of the Blank incident? Scene of the incident. Yes, we did. Describe what kind of happened at that when you got there. It was just me and Matt, Deputy Kirshner on each side. We're walking towards a dock that you could tell had stairs accessible. Upon arrival with the flashlights, we spotted it looked almost like a piece of boat with a good amount of blood all over it. The boat pieces, because it was white, it illuminated on the ground. Now, during this time, who are you talking, interacting with? I was talking with Dr. Kirshner, asking him if we should walk towards there because we needed to get her secure, and we were trying to figure out the best route to take to not contaminate the scene. Did the defendant say anything to you guys while the two of you were talking? Yes, she was communicating. She was trying to, as I was talking to her, as if I was talking to her. I was asking Deputy, should we go through there? I was a little hesitant. She said, just go through there. Okay. And then she called us some explicit names. And we're all adults here. What did she call you? Guys. Fucking pussies. Okay, Deputy Leckenbusch, were you wearing body cam that day? Yes, I was. And was it activated? It was. Capture all the audio and video of your interaction that day? It does. Your Honor, may I approach? And at this point, they're reading it into evidence. I'm not going to read all of that. We've gone through that already. And now the jury gets an instruction about it being edited. Deputy Leckenbusch, how are you doing, indiscernible? How are we doing? Female voice, fine. Did you guys see a girl come down here? Female voice, yes, we did. Thin, tall, dark hair. Deputy Leckenbusch, awesome, thank you. Yeah, well, I got somebody in a car heading that way. Male voice. Oh, okay. Deputy Leckenbusch, if she doubles back, then, not yet. Chuckles. Maybe, nah, it's low tide. I think it'll be all right. Indiscernible, is that you? Male voice, no. Deputy Leckenbusch, yeah, she got a pretty good head start on us. You might want to head up a little bit further. I got a foot trail here. It's going to go past your dock. Male voice 10-4, indiscernible. Deputy Leckenbusch, I'll be on the water's edge walking northbound. Dispatch operator 10-4. Male voice indiscernible. Deputy Leckenbusch indiscernible. Blank, tall, skinny, white female. Male voice indiscernible. Male voice go ahead. Male voice, hey, when you got a chance, will you block off the traffic clear? Male voice indiscernible. Male voice indiscernible. Deputy blank indiscernible. Deputy dispatch operator 371. Deputy blank indiscernible. Shots fired. Dispatch operator indiscernible 3322. Deputy blank indiscernible. Dispatch operator indiscernible. Female voice, have you been shot? Deputy blank stabbed in the neck. Dispatch operator indiscernible. Deputy blank indiscernible. She's in the water wearing a green sports bra, black pants, red. Dispatch operator 10-4. Deputy Leckenbusch, she's about 100 yards north of indiscernible. Heavy breathing, go. Dispatch operator 332. Deputy Guerrero, show me your fucking hands. Deputy Leckenbusch, where is she at? Deputy Guerrero, indiscernible, show me your fucking hands. Deputy Guerrero 332. Deputy Guerrero, it's a knife, right? Deputy blank, yeah. Deputy Leckenbusch, get the fuck up here now. You better get the fuck over here. Dispatch operator 381, you're 322. Deputy Leckenbusch 10-4, get up here. Deputy Leckenbusch 10-4, clear for rescue. Deputy Leckenbusch was a dock right here. Male voice indiscernible, last location. Dispatch operator Spring Hill, Indian River. They said that she said she was in the woods, green shirt. Deputy Leckenbusch, she's down by the water, 12-4-7-9 across the street. Dispatch operator 12-4-7-9 by the water. Male voice indiscernible. Dispatch operator 12-4-7 IRV. She's by the water 1039. Deputy Leckenbusch, where are you at? Female voice 12479. Deputy Leckenbusch, I hear her. I don't see her. Might be in the water. She's in the water. Get over here. Defendant indiscernible. Male voice indiscernible. Deputy Guerrero, we got her. We have her. Deputy Leckenbusch, we don't have her. Deputy Guerrero, we don't have. Deputy operator, you're 1012. Deputy Guerrero, water coming back. Deputy Leckenbusch, everybody else. Deputy Guerrero, you better come out of there. Stay the fuck on the ground. Deputy dispatch operator 318 RU 1012. Deputy Leckenbusch, get over here. Male voice, are you trying to get her back from the water? Deputy Leckenbusch, get over here. Dispatch operator 1012. Deputy Guerrero, get over here. The defendant, I'm coming. Deputy Guerrero, walk to the sound of my voice. You better not have that knife or I'll fucking shoot you right now. Deputy defendant indiscernible. Deputy Guerrero, keep going, keep coming. I got her. Deputy Leckenbusch, you got her. Deputy Guerrero, yeah, on the ground. The defendant indiscernible, breathing heavy, indiscernible radio transmission. You know, I do guess I've been talking for almost 2 hours straight at this point. Dispatch operator, all units indiscernible. Deputy Leckenbusch, blank indiscernible. Deputy Guerrero, let me check on him. Deputy Leckenbusch, stand up. Deputy Kirshner, everyone all right. Deputy Leckenbusch, stand up. The defendant crying. Deputy Leckenbusch, indiscernible. Deputy Kirshner, I came up, probably come up this way. Detective Leckenbusch, okay. Radio transmissions indiscernible. Detective Kirshner, indiscernible. The defendant, I guess so. Deputy Leckenbusch, that's the crime scene. You want to walk through that? Or the defendant, yeah, fuck yeah. I'm sorry, I had to read it that way. Deputy Kirshner, I don't want to walk through that. The defendant, why not, you pussies? Just go through, yeah. Deputy Kirshner, I don't have my light. Male voice 332. The defendant indiscernible. Dispatch operator, you're at Spring Hill. Male voice, you're working on it. Video recording stop. And at this point, what do you even say as the defense? This is bad. This is bad. Like, I expected it to be bad going in, but yeah, this is bad. This is like, this is worse than Sarah Boone taunting George, right? Because Sarah Boone's like, oh, I don't remember. She's under arrest for it here, and she's still taunting. So now we have the defense. Good afternoon, Deputy Leckenbusch. Good afternoon. That was a fairly long video. How long would you estimate that took you to locate Leigha Day? Seems long, but it's probably only 6-7 minutes, maybe. Yeah, it just seems long because it's so terrible. Terrible thing she did. Okay, so we can see you haven't gotten much beach there. There's a lot of driftwood. We saw a couple of kayaks. Some docking. Visibility was not good for the circumstances you were in. Correct? Not 100%, no. Right, you can see the lights from the roadway and cars going by. And already it's over. GG. You can see the lights. Okay, but you have your, obviously, you need your handheld light in order to find out where these prints went, right? Well, yes, that, and to check if she was hiding anywhere. Yeah, fair enough. So let's jump back. You got this is clearly close to the crash, was close to the county line, but you got the call that said overturned vehicle, correct? I don't know if it came out as overturned, but something of that nature. It was a crash. What does it matter if it was overturned or not when they arrive? Like, if they keep mentioning this, the defense does, I don't see the point. What's the point where the tires were? I mean, yes, there's like charges involving the vehicle, but that's not the thing you need to be concerned with. Do you see yourself the vehicle? I did. Was it overturned? Yes, sir. So now he's saying it was overturned. But does that mean it was overturned at the time he saw it, or if there was damage to the top showing it overturned at some point? Okay, so when you get her up here and you repeated it, get over here. Did she comply? Correct? Yes, she did. Okay. Thank you, Deputy. I have nothing further for you. State any redirect for this witness, Mr. Stone. 1 second, Your Honor. Judge, if I can approach. And we have a bench conference. Mr. Stone, I'm going to refresh his recollection with a picture of the car. Now, he can't authenticate it. He didn't take the photo. Other officer did, who was not here to testify, but I can do it outside the presence of the jury. Let him look at it and refresh his recollection, then ask him a question following a simple, you had to refresh your recollection. Was the car overturned or not? The court, you can refresh recollection with anything. Mr. Stone, yes, but I don't know if Mr. McCrae is okay with me. Court, is that your intention, Mr. Stone, doing it right in front of the jury or not? To the court. So you're not showing it to I'm showing him the picture. You're showing him, but not the jury? No, but I just make sure that you or the witness do not hold it up so the jury can see it. Mr. Stone, okay, the court, they can stay in the room. Mr. Stone, all right, I'll bring the laptop up to him, okay? Court, that's fine. Mr. Stone, okay? Judge, while we're up there, go ahead. There's with the next witness. I just wanted Mr. McCrae to know that so he doesn't ask. He's a really short witness. He was just located the next day, just jean overalls. He went out, marked it, called crime scene. They came and got it. Next to the overalls was a live round. We're not going to have him say anything about it. I don't know that it's relevant. It would probably be prejudicial, so I don't want you to ask him about it. Okay. That was Mr. Bruin who said that. Mr. Stone. We don't intend to play the body cam photos taken on the scene because the round is in it and we know it's highly prejudicial. The court, the jury is not going to see. Mr. Stone, no, they're not going to hear testimony about it. The court. And you're not going to listen to testimony of that. Mr. Bruin, correct. And he knows not to say anything about it. The court, okay. Mr. Bruin. But I don't want Mr. McCrae to just ask him, what all did you find? And him saying, I already told him not to say anything. So I want Mr. McCrae to know that so he doesn't. There was a picture of it. We even took that out as it was found because the bullet was right next to it, and there was probably no way to show that picture without showing the bullet, so we just took that out. The court, any issues, counsel? Mr. McCrae, I don't have any issues with that, Judge. I do have an issue with refreshing recollection when a witness has not said they don't remember. He said twice that this car, wasn't sure, I guess, but the second time he said the vehicle was overturned. He said it unequivocally in response to a very straightforward question, did not indicate that he needed recollection refreshed whatsoever. I object to the state trying. All right. And Mr. McCrae has a point. Now, I have a suspicion that seeing the condition of clearly it was overturned. But it was not clarified with the witness as to when he saw it, is it on its wheels? Upside down. Mr. Stone, yes. Court, so it is. It's not clear what he means by that. You can ask him to clarify. So it's exactly what I thought. Oh, I did not pre-watch. It's exactly what I thought. It was overturned at some point. But what way was it? Not that I think any of this actually matters to the case. But maybe I'm wrong. Maybe there's something else there. So it's not clear what he means by that. You can ask him to clarify. Mr. Stone, if he doesn't for sure, then I can show him the court when he saw it. Mr. Stone, yeah, you can ask him how was it oriented. Mr. Bruin, okay. Mr. Stone, and Judge, if he can't authenticate the photo, he can't authenticate it. He doesn't have to be taken. He doesn't have to have taken it to authenticate it. No, I know. Yeah, but we're not talking about admissibility of the photo. You would only use it if he truly does need memory refresh, Mr. Stone. Yes. The court, because at this point, Mr. McCrae is right. He has indicated, Mr. Stone, no, I'm not going to have to elicit some testimony first before I can do that. The court, he doesn't remember, but yes, ask him some questions and we'll see what his answers are. Mr. Stone, if Mr. McCrae is okay with me putting the photo in, I don't, I have one photo of the car that's in, no. Mr. McCrae, I'm okay with that. I just still feel that he doesn't need to have his recollection refreshed. He hasn't indiscernible proven that it's not consistent. Mr. Stone, I just have to make a new CD. I have some blank CDs here. I can make a new CD with just that photo in it and show him the photo. Show what? Mr. Bruin says, show what? Mr. Stone, just introduce the photo just to have it into evidence so we can look at it and see it. Mr. Bruin, he may have just misinterpreted the question like the judge said. Mr. Stone, yeah. Mr. Bruin, but he can authenticate the photo if that's Mr. Stone. I want to ask him a few questions to see what we go with it, Judge. The court says, all right, end of the bench conference. Okay. So basically, that was a whole bunch of just stuff about how it's going to be handled. We're talking about the vehicle. Which direction is the vehicle, right? Deputy, when you refer that the vehicle was overturned, can you describe what the vehicle looked like? I was only on the scene for a quick second. Okay. Because there was another deputy working the traffic crash. It was either on its roof or on its side. Okay. So you need... If I were to refresh your recollection with a photo of it, you'd be able to tell me the condition of the car after that point? Yes, sir. Mr. Stone. Okay, Your Honor, I'd like to refresh his recollection. The court just showing Mr. McCrae what you're going to use by Mr. Stone. You can look at this photo, Deputy. Now as you see it, this is your recollection of the vehicle. Refreshed? Yes. And when you arrived, what was the condition of the vehicle? How was it? It was sitting up, but it appeared to be rolled over because it had damage substantially over the hole. Okay, was it on its hood or was it on its tires? It was on its, Judge. This has been the witness. Wheels. Mr. McCrae asked and answered repeatedly. The court overruled. He really didn't clarify yet. Go ahead and answer, Mr. Stone. Was it on its hood or its wheels? It was on its tires. It was on its tires. Okay. And it had, you said that it rolled. There was substantial damage on the side and the hood. Gotcha. Like it had rolled. Mr. Stone, all right. I have no further questions, Your Honor. Court, any follow-up, counsel? Mr. McCrae, no, sir. No follow-up. All right. Is Deputy Leckenbusch released subject to recall? He's released, Your Honor. Do you agree? I agree. So he's been released. And now we're into another witness. This is Frederick Leblond. Deputy Frederick Leblond. Okay, so he's a deputy. I'm dreading it already, having to, again, read body cam footage. All right. This is what I get for trying to, like, do these as quick as possible so I could, keep having content coming out. I could have recorded this over multiple days. Good afternoon, sir. Good afternoon, sir. Please introduce yourself to the jury and please spell your last name for the record. By the way, if this comes out the weekend of like the 9th, 10th, 11th, whatever like that area, I'm probably going to lose my voice for a couple days. So don't be shocked if there's a lack of videos. All right. What do you do for a living, sir? I'm assigned to a road patrol marine unit at the current time. And what agency? St. Lucie County Sheriff's Office. All right. How long have you been with St. Lucie County? I'm on my 17th year. Okay, and what is your current duties? I'm a district patrol in the Marine unit. All right, and what were your duties back on March 23rd and 24th of 2022? I was road patrol assigned as a field training officer. Okay, and were you working on the 24th of March 2022? I was. Okay, do you recall being called out to 12865 South Indian River Drive? I do. All right, what was the nature of that call? The call came out as coughs. That did trigger me there. Excuse me, a property owner found a clothing article under a dock across the street from a residence. Okay, and were you aware of the incident that had happened in the area that night before? I was, regarding Deputy Blank. I was, and that's correct. Okay. And did this witness point out to you where the clothes item was? Yeah, they did. They did, yes. All right, and what do you do after that? I went to the way of the location where they pointed the item was, located, secured the scene with crime scene tape for crime scene to come and process the scene. All right. And so did you touch it? I did not. What was the item? It was a dark colored jean type overall. Okay. And did the crime scene eventually arrive to collect it? They did. All right. All right, sir. Mr. Bruin, no further questions. The court cross-examination. Oh, this was quick. Mr. McCrae has nothing for Deputy Leblond. Is Deputy Leblond released? Yes, sir. Do you agree? I agree. The court. All right. You conclude your testimony. Thank you. And now there is a bench conference by the state. Mr. Stone, I just talked to Mr. McCrae. Mr. Stone. I believe Mr. Stone's the state. Anyway, Mr. Stone. Yes, this is the state. I just talked to Mr. McCrae. We're gonna recall Deputy Leckenbusch to just introduce the photo at this point. This is the photo He stipulated to the introduction of it, so we just enter, we have to mark it, have him asked to move into evidence and asked to publish it. Without the officer here at this point, we don't necessarily need him. The photo of what? The car? The car. Yeah, he's been released. Is there anybody else he's here? He's going to certify that saw it. He saw it, now he's seen and looked at it. He saw it that day. He can authenticate the photo at this point if you need him to, because he looked at it there. I know Mr. McRae, I think, wants the photo in anyway, Mr. McRae. Well, I mean, the photo has not been introduced. I don't have the indiscernible mumbling introduced, Mr. Stone. Yeah, Mr. McRae. I don't think that it's indiscernible mumbling. The sole purpose of recalling him, Mr. Stone, is simply is it just for that photo? The authenticating of the photo, entry of the photo. That's it. No questions, just authenticating the photo. The court, Mr. McRae, if you have any objection to the state recalling a witness that has been released but has not left the building. Mr. McRae, has blank left the building? Yeah, he's gone. But he never saw the car either. Never made it to. Mr. McRae, no, I know. I was just wondering if I would recall him regarding the vehicle. The purpose of the state doing this is that the jury basically can take the picture when they go back to the jury room. Mr. Stone, yeah, just so they can see it. They've heard it, just so, at this point, you want them to give a picture of it? The court. They have no idea what the actual vehicle looks like because there's no photo. Mr. Stone, correct. The court, in evidence. Mr. Stone, there is none. Mr. Craig, yeah, and I have no objection. Mr. Stone, okay. The court, all right, you can go ahead and recall him. Gotcha. Judge, indiscernible numbering, nothing like that. The court, no questioning, just no. It's strictly about the foundation. I showed you the photo earlier. Entry of the photo, correct. All right. End of bench conference. Judge, at this point, the state would like to recall Deputy Leckenbusch. Madam Clerk, what number is this going to be? I don't think it's marked. The next number, it's going to be 20. Let Madam Clerk mark on it. Yes, Your Honor. And now they bring him back in. Deputy, I'm going to approach briefly. You just briefly testified you're still under oath. Yes. Do you recognize this photo? Yes. What is the photo of? The crash vehicle that we responded to. Okay. Is this fair and accurate? A depiction of the photo was taken that day. Yes. Okay. Mr. Stone, Your Honor, at this time, the state would like to move in 20 into evidence. Been previously marked as identification. It states 20, so it's all brought in. There's no objection. And he's gone. All right. Deputy Justice Leblond? Good afternoon, Deputy. Would you please introduce yourself to the jury? Hello, Deputy Justice Leblond, St. Lucie County Sheriff's Office. Deputy, can you spell your last name? L-A-B as in boy, I-G-A-N-G. And Deputy, how long have you worked for the St. Lucie County Sheriff's Office? Approximately 6 years. Any prior training or experience becoming a law enforcement officer? No. Did you go to the academy? I did. Okay, now I'm going to take you back to March 23rd, 2022. You were a law enforcement officer back then. I was. I believe it would have been March 24th where you were called to the scene of a traffic crash stabbing of an officer on the drive. I was. Now were you called in the capacity of your just patrol deputy or something else? No, I was called in as the capacity of a dive team member. Okay, can you explain your duties as a dive team member? Is this going to be like a look for the knife, maybe? I'm out of liquid. Yeah, I would think knife, maybe. Dive team member. So that's a search and recovery. They'll ask us when there's water-related incidents, if there's any evidence or anything like that. We're the people that will go out and search and try to recover it from the water. Okay. Did you guys, how many of you went out that day? I believe it was approximately 7. Okay, 7 of us, 8. When we got there, what did you do first? We set up our area. We were briefed on what we'd be looking for. Do you recall we told you guys we were trying to find a knife at that point? Okay. Were you directed to the area where they were supposed to be looking? We were. And where was that? I believe the knife was about the 12500 block of Indian River Drive. Okay, when you eventually go into the water area, we did. It was like the water area between the docks. Okay, and what do you do when you got down there? Oh, we got down. Me and another member, we began to grid search within the metal detectors due to it being a knife. That's when we located the knife in the water. Okay, so let me ask you this. When you got down there, what was the tide? I want to say at that point it was low tide. And what made you believe it was low tide? Just the docks. You'll be able to see the water line, the stand on the pillars of them, piling of them. Okay, and you said you got down there with metal detectors. How far was it in the water where you found the knife? It was maybe a foot and a half into the water. Okay. Now, as part of the dive team, with search and rescue, when did you find an item like that, what is the requirement to do so? At that point in time, we marked it with like a yellow flag, so evidence. We got crime scene evidence there. At that point in time, we took GPS coordinates of where it was. She photographed where the flag was, where the knife was located. So you said GPS coordinates. How do you do that? She handed me, I don't know specifically what it is, but it's a GPS coordinates on it. She had me hold it over like where the knife was, and she snapped a photo of it. Okay, and you said you marked it to collect it. Do you collect something like that in the water? So with an object like that in the water, what you would do is fill up a container that can hold whatever it may be. At that point in time, it was a Sharps tube. You will fill it with water, and then whatever water was in it, then you'd put the object in there and seal it off at that point in time. Okay. Your Honor, may I approach? You may. Well, we've marked here as a pre-admitted for identification of State 17. Do you recognize this? Yes, sir. Was it? It's photos of me holding the knife and where it was marked at. How do you believe that's what those are? I've reviewed it. Okay, you put any markings on the disc to ensure that's what it is? I did. I signed up with my badge number on it. Fair and accurate depiction of the photos taken. There's no objection. And it was published. Now, Deputy, were you guys instructed as to where she was apprehended? We were. They gave us a general area where they found her at, and the area, same area where the knife was found. It is. Okay, so can you describe this picture? This is the shoreline here. The high tide would be up here during the high tide. This is the dock that was north of the area, I believe, right in this area where the other dock was. Okay. Now, is there anything in the water that's a unique sort of marking or anything? Yeah, the yellow flag here, which is marking where the knife was found. Okay. Show you the next photo here. Can you describe what's in this photo? Again, it's the yellow flag where the knife was found at on the shoreline. Okay, and Deputy, describe the photo. That would be retrieving the knife. And this photo as well. That would be the knife that I retrieved. Mr. Stone, may I approach the witness again, Your Honor? You may. State's identification 2. It's a box for weapons, knives, evidence box. All right, and do you know what's in this box? I would assume it's the knife that was found that day. Okay, and is it sealed? It is. And Your Honor, do you believe it's fair and accurate depiction of the knife that was located that day? Yes. Yes, Your Honor. Mr. Stone, Your Honor, at this time, the states would like to move in evidence states 2. Any objection? No objection. It's published. Mr. McCrae, Your Honor, may I approach? The court, you may. While you publish. Okay, Mr. McCrae, thank you. I want to look in the box. The witness, would you like me to open it? Mr. Stone, yes, I think if you can, by Mr. Stone, Deputy, is the knife that you collected. It is. You can step down and show the jury. Mr. Stone, no further questions, Your Honor. Cross-examination, Mr. McCrae. Thank you, Your Honor. So now the defense is going to cross-examine the guy who got the knife. Good afternoon, Detective Leblond. How are you? Oh, well, sir, thank you. So, in your capacity as dive team rescue, in this case, you didn't have to actually, have underwater breathing apparatus. You first started out with metal detectors. Is that what you usually do? Depending on the water depth and the environment, yes, sir. Okay, you started a little bit about the water height and forth. There's no way you make a determination as to actually where the knife was dropped based on where you found it. Would you agree that tide would have moved an object as light as that? Depending on how close the current is to the inlet and how heavy the object is. Okay. So it can move with water like anything else. Was that the only thing you found during your search? It was. All right, thank you. I have no further questions, and they're released. Give me 1 second here. I will say, and maybe this is my voice leaving me, and my throat hurting, and my lack of monster killing me. I feel like they're a little overkill. The state is like I feel like they've got her. I feel like they've got her, but at the same time, dot all your I's, cross all your T's. This is an officer-involved case, right? So next is Deputy Matthew Girds. Good afternoon, Deputy. Could you please introduce yourself to the jury? I'm Deputy Matt Girds, St. Lucie County Sheriff's Office, and could you spell your last name? Gerdes. And Deputy, how long have you worked for St. Lucie's Sheriff's Office? 18 and a half years. Do you have prior law enforcement or military experience before that? I do not. Did you go through training to become an officer? I did. And that would be the academy? Yes, sir. What were your duties as a law enforcement officer back on March 24th of 2022? I was assigned to the Criminal Investigation Division as a detective. Okay. You were called as part of the investigation involving a stabbing incident on a law enforcement officer on the drive. Yes, I was. And can you briefly describe what you were called or requested to do on March 24th? So, coming in that morning, I had been advised by my supervisor there was an officer-involved stabbing, and they wanted to take some of us to basically canvass the area for any items that were located to support the incident that occurred that night. Now, when you arrived, where did you go first? I actually went to the location of the roadway where he actually was stabbed. Okay. When you got there, what did you have a discussion of what you guys were going to do? What do you guys do at that point? It was paired with another detective, and we were told to go to the beach and walk along the beach, which was the inner coastal along Indian River Drive, and walk southbound to where the actual vehicle, where the crash had occurred. Subsequently, up the drive, we were told to walk southbound and look for evidence or anything out of the ordinary. Okay, and I did doing that. Did you walk the intercoastal? Yes. Along the walk, did you find anything? Yes, I did. Can you describe kind of in order how you found stuff? So walking southbound, I found what appeared to be bare footprints in the sand. I took photographs. We continued to walk. Found what appeared to be a jacket, a black jacket. So there's the black hoodie thing. I believe it was black, hanging on some like some mangroves. And to paint the picture of the tide, you know, obviously changes in certain periods of time. So you know the stuff is in the water, out of the water, on the mangroves. I took photos. We documented. Continued along, found some black boots, and I found a car part that we believe came from the vehicle. So the hoodie could have been thrown in the ocean. Not the ocean, but the water. I guess mangroves. Mangroves, salt water, right? So, yeah. Actually, mangroves can survive in freshwater, I believe, because I believe, this is random, I saw a food YouTuber make a aquarium with crabs that had mangroves living in it. I believe it was freshwater because he had rice fish below. And he said something like they would adapt slowly. They'd die off a little bit and come in. Anyway, let's continue. Yeah, I would say relatively, yes, okay. And how far from the actual incident, the stabbing incident, were they found down the beach? They were, I would say, close to the incident area on the beach where the clothing and the shoes were found. Do you find any specific distance amount that you could? I do not. Okay. Now, did you find at some point in time, were you able to look at anything to determine how far away, as far like mileage, percent of mileage it was from the actual incident of the stabbing? The only thing I determined was the distance between the two addresses. Okay. Where the car accident was and the stabbing was, I determined that to be 0.6 miles. 0.6 miles. Okay, so a deputy. What I'm going to show you, Mr. Stone, may I approach, Your Honor? You may, Mr. Stone. Well, it's been marked for identification as states 4. Take a look at it. Can you tell me what? Can you tell me? Do you know what? Is there any markings on the outside of the bag? Yes, it says black Harley Davidson zip-up jacket with hood. Okay. Is what you guys find on the beach that day? This jacket. Did you bag the jacket yourself? I did not. Okay. At this time, can you go ahead and put your gloves on and cut the bag open? Pause without removing what's in the bag. Can you look inside? Yes. Do you recognize the item? I do. What is it? That's the black jacket I found on the beach. Is it a fair and accurate depiction of the jacket you found that day? Yes. So they move it in. No objection. Deputy, I'm going to show you what's been marked for identification states 5. Take a look at this. Black boots with green and black socks design. Black boots with green design. Black socks times 2. 2 boots, 2 socks. And where were the boots you collected that day on the beach? Black, it would be these. And did you collect the evidence and seal in the bag? I did not. At this time, can you open the bag without showing the contents to the jury? Here we go again. Where it says here we go again is the answer. Pause. Deputy, you recognize the contents of the bag? I do. What is it? Black boots. I don't see the socks initially. There they are. Is that what you collected back on March 24th? That's what I located. Crime scene investigator Leblond collected it. Yes, sir. You're on at this time. It's been introduced. No objection. Now, Deputy, as far as you mentioned, kind of in order, you found the jacket first and the boots and the car part and of a sequential order heading south, correct? Yes. Now, north of where you found the boots, you find, what were the prints you found in the sand? Footprints. Were they like in footprints but not shoe prints? Correct. Bare feet. Bare foot of a person. Did you find any shoe prints in the sand? Yes. Were you able to look at the shoe prints to make any determination? 1 second. I think we discussed on scene that it was a similar match. Okay, now Debbie, let me ask you this. Are you familiar with the body cam technology that your agency has, as well as the photos that your agency takes? Yes. Now, with your body cam, it takes audio, video. Yes. Were you able to take photos with it? No. No. How are you guys able to take photos with officers in your scene? Oh, we have an iPhone that it's the same app as the body cam. It's the body cam. It's the app where you open the app and have the availability to take photos, video, audio, and import photos, and also send email through this app on our iPhone. Did you take photos that day yourself? I did. Let me ask you this, Deputy. Aside from this, the photos, body cam, aside from just audio, video, is there any other data that it collects? Yes, it does. What's the data? It can be various things depending on what type of device it is. If it's cellular, some type of connectivity. It can be things like unique identification of a photo. It can be the aperture, the pixels that are taken of the photograph. It can also have the GPS information of that particular device connected to something to provide the GPS information. Okay. And did you take a look at the photos and our body cam that was collected in this case and look at the GPS data? If I did, okay, Judge, I'd like to take judicial notice of Google Earth of the drive, the two distances. Any objection? Yes, Judge, I'd object. They're objecting to Google Earth. The court, all right, approach. The court, all right, Mr. Stone. You're asking me to take judicial notice exactly of what, Mr. Stone? Of the judicial notice of the Google Earth of Indian River Drive, the location of the incident to the location of the crash. There is case law that states the court can take judicial notice of Google Earth. It's been about a year since that came out. It's just asking the court to take judicial notice of that. I'm going to as well show him a photo that he made himself with the markings. That's a Google Earth photo where he inputted the GPS data of the photos, and body cams will be able to authenticate the photo. Mr. Bruin, he can just authenticate it himself. Mr. Stone, yeah. Mr. Bruin, he's not going to use Google Earth to. Mr. Stone, no. He'll be able to authenticate it by just the same time. The court, Mr. McCrae. Mr. McCrae, thank you, sir. Mr. Stone, I provide the photo to Mr. McCrae as well. The court, Mr. McCrae. Your Honor, I do know the case law I believe Mr. Stone is referring to, indiscernible, judge, to take judicial notice of Google Earth. However, this is not only Google Earth. This is a photo of indiscernible that has been altered to show where the items alleged have been related to the crime were inserted into Google Earth picture. Mr. Stone, he still has to authenticate all of this. If he can't authenticate it, then of course there's objections to it, but I believe it can go through questioning. We can authenticate it. Mr. McCrae, judicial notice of that, judge, I would say is indiscernible. Mr. Stone, I'm not asking. Mr. Court, what is the Mr. Stone for judicial notice of the photo? I'm just asking that judicial notice of just the aerial of the photo, which is the area, not including these. He's not going to authenticate these himself, but just the court can take judicial notice of that. He can authenticate all things. The court, all right, what is the purpose of the court taking judicial notice of it in relation to this jury trial? We're not here for a hearing. Mr. Stone, that's fine. The court, for a hearing or anything. Mr. Stone, no, it's fine. I'll go through, I'll have him authenticate at this point. Court, all right, ask your questions, end of bench conference. So, the defense was objecting to, my understanding, a photo of Google Earth, which if you've never used, you can zoom in and use GPS coordinates. And I assume it was going to be an overview of the area and showing the locations that these items were, because photographs of the items would have GPS coordinates attached to them. Therefore, you could literally show the jury on an aerial view where they were found. That would be my understanding of what he wanted to do. And I'm honestly not sure what he is going to do. I'm not sure if this was the okay to do that. Maybe I'm just getting tired, or like they're just going to let it go. And then if the defense objects at that point, they object. I don't know. Deputy, I'm going to show you what's been marked for identification, states 15 as well as states 15A. Do you recognize both these do, and what are they? It's a map that you and I created in your office based on this case. It's the same thing, image on a CD drive on a CD. So this witness also helped create this. Okay, so let's talk about the map. Kind of describe how you were able to create this. So understanding that the body cameras have GPS, and that the photos I took that day have GPS, they indicate a longitude and latitude, so I punched those coordinates into Google Earth. And they would point to the plot on the Google Earth based on those longitude and latitude, where we did that for the various locations that you see on the map. So it is what I thought. Okay. Let's start here, I believe. What's this at the top right corner? This is a legend that explains the different bolds that I have, as well as it started out with A, which is the accident. Okay. You were able to view evidence in this case that had GPS coordinates for the location of the accident. Yes. And you input those coordinates into Google Earth. I did. And did you give you a plot point? I did. And where is that plot point located on the map? It is, I believe, it's the 1310 block or something like that to that effect. Gotcha. Now let's take number B on the legend. That's where incident location where actually blank was stabbed, which is right there by the steps on the beach. You were able to view evidence in the body cam that had GPS coordinates for that location as well. Yes. And you inputted that data. Yes. And you put a plot point for that data based on location. Mr. McCrae, judge, this is leading. Mr. Stone, it's not judge. It's just questions. The court is direct examination. I'll sustain the leading. Just rephrase the questions, counsel. Mr. Stone, did you create a plot point? I did. And what was the plot point for? It's letter B. It shows the incident where blank was stabbed. Okay. Can you, is there a C on the plot point? Yes, there is. And what is this? Describe it. It's the north of the location. That's where the suspect was found, and also the knife was located. You review any evidence that gave a GPS coordinate for that? I did. Did you input that into the system? I did. Did it give you some sort of indication? It did. Do you plot that into location? I did. It's letter C. So, again, the objection is not changing anything. Okay, this letter D, there it is. And what's it about? It's the location where the jeans and the overalls were found. Did you view any evidence that would give you GPS for that? I did. Did you plot into Google Earth? I did. Did you pinpoint it? I did. Did you mark it? I did. Is letter E? Yes. What is that? It's a suspect spotted on the beach. And who plotted it? Do you know who spotted that suspect? The defendant. I rephrase your question or repeat the question. Was there a deputy that spotted that location? Yes. And did you review body cam footage for that? I did. And did you plot that into the data into the body cam system, Google Earth system? I did. Did it give you a plot point? It did. And you marked on the map? Yes, letter E. Is there a letter F? Yes. And what is letter F? Letter F is the location where I found the jacket. Okay. And where you found it correct? Yes. You already testified you took a picture? Yes. And your photo of a GPS coordinate data? Yes. And you plot the information to Google Earth? I did. They want to break my throat, guys. And it's letter F. It's fair and accurate depiction of the location of the incident that you reviewed via body cam evidence at GPS that you plot pointed for. Judge, is this leading? There's no that data. Judge, he has testified to it. He was just the court one at a time. The objection is overruled. You may continue. Mr. Stone, is it fair and accurate depiction of the plot points that you put into Google Earth that you plot pointed on this map? Yes. Mr. Stone, at that time, Your Honor, the state would like to move into evidence states 15 and states 15A. The court, Mr. McCrae. Mr. McCrae is subject to prior objections. Judge, court, all right, at this time, now 15 is the hard copy. It is, and the digital copy is 15A. All right, at this time, what has been previously marked as 15 for identification entered into evidence. And 15A was moved in over defense's objection. Mr. Stone, at this time, the state would like to publish 1515A. They publish it. Deputy, if you want to turn around and kind of take a look, let's kind of go through everything here. Now, you already testified to their, I guess, a legend on the top right-hand corner. We'll kind of go through each. Now you have A marked as an accident. Can you point to the location of where A is? Okay, it looks like the next part of the legend would be B. What is that? The incident location to the indiscernible. Okay, now C. What is C? Just north of the incident where the subject and the knife were located. Listen, I'm gonna read this. I'm going to tell you if they change it. Right now, it's just him going through the exact same thing again, but pointing. I don't have the video of that, so I'm not going to reread it. It's the same thing we just went through. All right. So we take it, you walk from C down, we take it chronologically the other way because you described everything that's on the map. Okay, so the accident occurred here. Going northbound from the accident location, shoes were located just north of that. Jacket was located just north of that. Continuing up the beach, the suspect was spotted on the beach. Following farther up, we found the jean overalls were located. Then as you go even farther up, all the way up to the north, there was an actual incident location. Subsequently, the defendant was located and the knife was north of this incident location. And again, as you testified earlier, the distance from incident to how far, approximately 1.6 miles. Okay, are you sure it was 1.6? Oh, I'm sorry, 0.6. Okay, thank you, Deputy. Mr. Stone, I have no further questions. Report cross-examination, McCrae. Mr. McCrae, no, thank you, Your Honor. I have no questions for this witness. He's released. Ladies and gentlemen, how are you doing? Anyone need a break? Mr. Stone, Judge, can we briefly approach? Bench conference, Mr. Stone. Probably a good time for a break. I just need to authenticate the 2 discs with the 2 CSI. All right, Mr. Stone, you didn't come in until 1:30. We just got started right away. So Mr. Brew, and I will show them that. They'll authenticate it, and we'll get started. All right, 10 minutes. I'm good with that, Judge. All right. Mr. Stone, we're good on time. I think after that, we're just waiting for the doctor at 4:30. Report, all right. Just medical after the CSIs. Mr. Stone, we have 3 witnesses left. Mr. McCrae, how long do you expect the doctor? Not even. It's very brief. Mr. McCrae, all right. So indiscernible, end of bench trial. All right, so jury leaves, and we return. Jury is in. State is calling Laura Lobnig, which doesn't have deputy in front of it. Just mentioning that. Good afternoon. Can you introduce yourself to the jury? My name is Laura Lobnig. Can you spell your last name? Lobnig. And Mr. Lobnig, Miss Lobnig, back in March 23rd, 2022. Where did you work? St. Lucie County Sheriff's Office. In what capacity? Crime scene investigator. You currently work as a crime scene investigator. I had to step down from my position last year in July due to medical reasons. Do you still do any kind of work in this area? Yes, I volunteer and teach new deputies. Now, you said crime scene and see, this is what happens when I leave the window open, so I have a little bit of fresh air while I do this. You said crime scene investigator. What is that? So crime scene investigator responds to various crime scenes where we analyze, document, collect, and process evidence and help maintain integrity of our scenes and any evidence that we collect. Back in March of 2022, how long had you been a crime scene investigator? Crime scene investigator, about 2 years. Okay, and did you have prior training and experience to become a crime scene investigator? Yes, I have my bachelor's degree in forensic science. I'm certified crime scene investigator. I have over 200 hours of crime scene investigation classes on top of the on-the-job training. Okay. Let's go back to that day where you called out for service on the 23rd. Yes, and what were you called out to service to do? I was called out on an officer-involved incident, and you arrived where your duties on the scene. The scene I had to document the scene, search, and collect evidence. So this is going to be the person that actually bagged everything, I think. Okay, and kind of, you kind of explain searching, collecting evidence. What would that be? Searching for evidence is anything related to the incident, collecting anything we might have found that would, again, relate to the incident. Any documentation. The most important thing is documentation. We did measurements. We did a bunch of stuff. Okay, so we were able to find things you needed to collect. What were kind of the process of you doing that? First and foremost, we always photograph everything. Once we photograph, we collect it. Once it collected, it's transported back to the sheriff's office where we process it if needed. Okay, and did you take photographs and collect evidence back in that day? Yes. Now I want you to take you back to that day. Even when you went to the scene, did you go down to like the docks or the water area? Yes, I did. Can you describe what you saw and collected there? Going down the dock, I saw there was a blood spider trail going down. Going down the stairs to the beach area. More blood down the beach. And then there were various footprints walking across the beach. Wanted to walk south, the tide had risen, so I couldn't walk. So then walking up north, that's where we searched for. We were trying to find something related. We found a shell casing. Let's go back to the dock first. You mention blood spider. Did you take photos of that? Yes, I did. And put those into evidence? Yes, I did. Take any samples of blood from that location? I did. Now, you mentioned you found a shell casing. Let me ask you about it. Do you have any experience in shell casing and firearm ejection? I do. Do you ever watch the body cam of the incident? I watched it afterwards. Okay, So you're able to see where the firearm was fired. Yes, in relation to the dock where the shell case was found. So in relation to the dock, it was found on the north side of the dock down at Bush. Okay, so Deputy Blank is facing this way on the dock. Which side would be the north found? It would be off to the right. Okay, so the firearm ejection, can you kind of explain how that works? So, Mr. McCrae, objection. She hasn't been qualified to be a firearm expert. Court states you want to be heard further on this point. Mr. Stone, judge, I'll further inquire with the questions. Court, all right, ask some questions, Mr. Stone. So how do you have experience with firearm ejection? I've taken firearm classes, shooting reconstruction classes. And do you have any experience with firearms yourself through various scenes? Yes. Have you ever fired a firearm? Yes. So you already have prior training and experience in firearm ejection as well as firearm recreation, correct? And how do you know how many classes or hours you took of that? I know every year we take a shooting reconstruction class. Okay, so every year at least 24 hours. Every year you take a 24-hour course for firearm reconstruction. Okay. So you have experience and knowledge, trained experience, as well as your educational background. In firearm ejection and reconstruction, correct. So I asked you with a firearm, can you be kind of explaining how an ejection works? So ejection from the firearm, other than the bullet, is your shell casing. Your shell casing typically will always eject from the firearm out the right with an automatic weapon. So do you want me to go in depth? So yeah, when it ejects to the right, does it necessarily mean that's where it's going to end up? No, not necessarily. It's just most likely where it ends up going. Okay. So based on, what I saw, that's where we search, and that's where we first went to search, okay? And we find the shell casing in that area. We did. Okay, I'm going to show you what's been marked for identification in State 6. Miss Lobnick, do you recognize what that is? The shell casing was found in the bush. Did you collect it? Yes. Did you put it in that bush? Wait. It's the shell casing that was found in the bush. Did you collect it? Yes. Did you put it in that bag? Bag, not bush. Yes, I did. And how are you sure that you're the one that collected it and put it in the bag? I'm the one that sealed it, marked it with my initials and date. Is that the fair and accurate depiction of the shell case from that day? Yes, Mr. Stone, Your Honor, at this time. No objection. It's been published. Witness asked for gloves. Witness, my hands are sweaty. If you want to step down, you can pull it out of the bag and show the jury. Now, that night, did you collect or do anything in the roadway? Yes, I did. And what do you do? Prior to my arrival, deputies marked a blood trail going south on Indian River Drive with photo markers, so I went through and photographed each photo marker. I collected a piece of the vest, okay, on the roadway. Now, is this all you did before reviewing the body cam? After reviewing the body cam, do you have any sort of, were the blood that was took photos that night consistent with anything consistent with how Deputy Blank was moving? So now this is on the 23rd. Did you have to go back the next day? I did. She went back the next day. She went back on the 24th. What were you there to do on the 24th? So the next day I was called back to the scene. The dive team was out in the water searching. I also called the neighbors a little bit down south where items were found in two separate areas. Okay. So you were with the dive team. Did the dive team find anything? Yes, they did. Take photos of it. I did. What was it? It was a knife. Further along the shoreline, were you ever with Deputy Girds? Yes, I was. Okay, describe what you and Deputy Girds found. So I was walking along the shoreline in the mangroves on the tree branch. We found a black jacket. We found a pair of black boots and black socks. You photograph it? Yes, I did. You collect it and bag it? I did. And now they're showing States 10. She recognizes it. It's a CD with photographs, some scene photographs that she took. She marked them. No objection. They're brought in. All right, Miss Lobning. This photo, I guess, is labeled knife unfolded. Do you recognize this photo? Yes. What is this photo of? It's a photo of a knife that was found in the water, or this, I guess, marked labeled as knife. Do you recognize this photo? Yes, same knife. Same thing. This was marked as LL1468. Do you recognize the photo? Yes. And what's this photo of? It's a photo of the crime scene. Those orange cones, what are those? What are those markings? Those are the photos. There's a mark that the deputy is placed by any blood spatter. Okay. If you want to, you've got it right behind you. It might be easier for you to view there. That easier on the TV, whichever is easiest for you. They're both good. Okay. This is labeled LL10500. Do you recognize the photos? Yes, the entrance to the dock. And again, there's an orange cone. What is that? That's the orange cone. It's a marking of blood. Okay, this is LL512. Close-up photo of the gate and the blood. LL1508 was the photo of. Staircase leading down to the beach with more blood. And LL10554, it's a footprint on the beach right on the dock. Again, this is LL10567 was the photo of. It's a photo of the bottom of the staircase of that dock. And LL10570, more blood on the railing of the dock. And LL10571, the same thing, same railing, just different views. Okay, this is LL10573. Same ending of, it was a kind of weird gray box that was at the end of the staircase. And then LL10576, more blood. LL10580. That's just the bottom again of the staircase, just looking out the beach. Okay, in the beach area, the area where you took the photo, the previous photo, the footprint that we just saw the photos ago. Yes, that's the beach area. It's correct. Okay, and this is LL105787. So that's the same area going down, and there's a dock on top of that. We're looking back at it. This is LL10629. This is past the dock. Okay. So this would be north. It would be the north side of the, or south side. It would be the north side of the dock. Okay, LL10638. That's a shell casing. And again, where did you find it? It was the north side of the dock. Okay, this is LL10676. What is this a photo of? More photo markers labeling blood across Indian River Drive. And again, you testified earlier that you were looking at the photos and you took the photo first, but then reviewed the photo. This is consistent with the body cam trail from when Deputy Colangelo walked. Yes, and this is LL10677. What is this of? Same trail of blood with the body markers. This is LL10776. This was the neighbor's deck down the street where they went down and saw the beach and found the jackets, shoes, and socks. Okay, and LL10787, that's the jacket, and LL10791, better view of the jackets, the back of it. This is LL10821, that's the upside of the up close to the blade from the knife that was found. LL10827, that's a close up of the blade. LL10930, those were overalls found in one of the neighbor's docks, and LL10938, that's the ballistic vest that we found at the end of the trail that was marked. And LL10948, that's the black jacket on the beach. And all right, thank you, Miss Liang. No further question, cross-examination, and I have to cough. Good afternoon. Hello. Just a few questions. So this is the defense. About your testimony, the photograph of the footprint in the sand that jury saw, you took that the next day? No, that was the night of. Or was that the same night? It was the night of, yes. The night of. So the night of the 23rd. It was also at night that you found the jacket, boots, and socks? The jacket, boots, and socks were found in the morning. Okay, so that's... I want to be clear that for the jury, you collected those because you believed they had some relevance to what happened. Correct, correct. And they were any identifying markers on any of those items. Name, the defendant's name is Leigha Day. Was there anything on that? Her name on anything, as in the clothes? Yes, not that I recall. Okay, were you able to tell the jury beyond and to the exclusion of every reasonable doubt that those items of clothing belonged to Leigha Day? No. Thank you for your testimony, and that's it. She's released. Okay. All right, now we're up to, I swear these names. Jean Hiller? Good afternoon, ma'am. Hello, good afternoon. Please introduce yourself to the jury. My name is Jean Hiller. It's Hiller, Hillner, and I'm going to go ahead and spell my first name, Genenye. Her name is a thing. Genynne. Okay, where do you work, ma'am? I work for the St. Lucie Sheriff's Office. How long have you been there? I've been with the Sheriff's Office since 2011 and assigned to work the crime scene unit since 2013. Okay. Just give the jury an overview of what the crime scene unit does. Crime scene investigator assigned to the crime scene unit is requested to respond to a crime scene within St. Lucie County and analyze, collect, process, preserve evidence. Okay, are you in fact a crime scene investigator? Yes, I'm a crime scene investigator, and I'm certified through the International Association for Identification of a Senior Crime Scene Analyst. Okay, and what kind of training do you have to become a crime scene investigator? To become a certified or be a crime scene investigator within the Sheriff's Office in St. Lucie County, I had to go through several hours of training to start with 80 hours of training, and since my time in the unit, I've gone through over 200 hours at various crime scene-related material, basic crime scene photography, crime scene evidence collection, processing crime scenes, processing for latent fingerprints, and then evidence collection, and processing. Okay. And were you working in the same capacity as a crime scene investigator in the early mornings of March 24th, 2022? Yes. All right. And did you get called out to any specific area? My supervisor called and requested me to respond to the Lanewood Regional Medical Center. At the time, I was called to work in this case. Okay, what specific duties as far as being the crime scene in regards to this case? I was requested to respond to the hospital and document Deputy Colangelo and any injuries that might have sustained and collect any evidence needed to be collected. See, right there, they didn't block out the name. Again, I don't understand. Okay, so when you got there, you're able to take your part first. You're able to take any photos of Deputy Colangelo. When you got there, initially I responded to the hospital. I was unable to photograph him. Why was that? He was in surgery. Okay, and what did you do then? I was given 2 bags of items that were clothing of Deputy Colangelo and took them back to the sheriff's office and had, did various things with them. Okay, so you're talking about the same night. Yes. Early morning, I should say yes. And do you remember what you did with them before you took them back to the hospital? When I arrived at the sheriff's office with the 2 bags, I unpacked the bag. The clothing was still saturated wet with blood, so the clothing was hung up to dry, and the duty belt that contained in the bag was photographed and removed as firearm and body camera. Okay. What do you do with the body camera? The body camera was placed on our docking system in the Sheriff's Office Criminal Investigations Division so that the video could be uploaded into evidence.com. Okay, and were you able to take photographs of the point of blank uniform and his equipment that he had on? Not his uniform at that time, just his duty belt and firearm. When we have any kind of incident, we immediately document the firearm, the condition of the firearm, and how much ammunition is contained within the firearm. Okay, is that because you were aware that he had fired off his weapon? Yes. Okay, at some point did you make it back to the hospital? Yes. Once I did those things, I returned back to the hospital and waited until he was out of surgery and he could be photographed. Okay, were you able to get photographs of him after surgery? Yes. Once he came out of surgery, I went into his room, took several overall photographs and injuries he had on him. Okay. Now, after you got photographs of him after the surgery, what did you do next part of your duties? Okay, I took photographs of Deputy Blank. I was done for that time and released from duty until I returned back to work the same day, but during business hours. Okay, so later in the day, what did you do when you returned? I began taking more photographs of his duty belt and his taser, and once I had photographed those, I was stopped and requested to take photographs of a search warrant. Okay. What was the subject of the search warrant? It was a search warrant for a gold Honda that was told to me was a suspect vehicle. All right, and you said you took photographs of that vehicle. I did. And did you collect some items from the glove box of that vehicle? I don't remember particularly if they were in the glove box or items collected from various parts of the car, including the front section of the vehicle. And were some of those vehicles the car title? Yes. And a copy of a birth certificate? Yes. And a copy of a social security card? Yes. Okay, Mr. Bruin. All right, may I approach your honor? You may. They're approaching with a disc with all the photographs on it, social security card and all that. The state will seek to introduce this mark as States 11, which is marked as State 16. The court, Mr. McRae, as States 11. The photos, Mr. McRae, may I have a moment, Judge? Yes. Bench conference. Judge, Mr. McRae would like to take a look at the disc before we introduce. Sorry. Mr. Stone, it's okay if you do it, but not him, right? The court. This is States 11. The photograph, Mr. Bruin. Yes, he's not objecting necessarily, but the court, he needs to see it before it comes in. Mr. Bruin, yes. Court understood. Yes. How many are on there? Maybe 10, 12. Mr. Stone, I can show him on my computer right now if you'd like. Yeah, if you can do that. There's just a handful of them. Mr. Bruin, let's go do that. Let's talk about 16. Yes. Is there any issues with State 16? The documents? Mr. McRae, no issue with State 16. Okay, go ahead and show Mr. McRae States 11 and a bench conference. Pause, Mr. McRae States 11. No objection. All right, it was in previous market States 11 so States 11 is in, State 16 is in. Mr. Bruin, I just have a couple questions about, did you look at the deputy's firearm? I did. Okay, and so like we talked about before, he had during the incident that he had fired a shot. Yes, I did. Okay. And you just look to check that out and make sure that numbers match up as far as the live rounds that were in the gun. Yes, so standard procedure, the magazine was removed, the ammunition was chambered, and the firearm was removed, and the ammunition was unloaded from the magazine for us to count. Okay. Mr. Stone, is it still in the laptop? No, it's different from one we're looking. It's different one we're looking for, Mr. Bruin. All right. This has been entered as State 16. Can you open that up? The items you took? Yes. And the birth certificate. And it's Leigha Michelle Day. Any other items? A social security card. Any other items in there? Application for a vehicle certificate of title. Okay, is there a name on that? Yes. Leigha Michelle Day. Thank you. Put them back. Mr. Bruin, Judge, if we can publish the other exhibit that I believe 11. Is that correct? Pose? Yes. All right, so it's been published. And all of these photos will be from States 13. First one I'm showing you marked on the disc, Mr. Bruin. Yes, so the record is clear. You mean States 11. I'm sorry. Yes, States 11. So they messed up the numbering there. By Mr. Bruin. So States 11. This was marked as a download. Can you tell you it was a photo of? This is a photograph that I took of the taser and Deputy Blank's duty belt. This photograph is taken to document the actual taser's position. Additionally, it was a physical blood on the taser and the duty belt. Okay. The next one is marked as 8-1-12. Can you tell the jury what that is? It's a photograph of the items that are received from the hospital that contain the items of Deputy Blank. Okay. And you see some of these items are just in case we can't see. Primarily, those items are consisting of things that were in his duty belt, his body-worn camera, his flashlight, handcuffs. There are some keys in there, and then a knife. Okay. And then 8-1-3-2. This is a photograph of Deputy Blank that I took to the hospital, and that's after the surgery. That's when he came out of surgery. Yes, and that's 8-1-3-6. The same image is kind of showing overall picture of Deputy Blank and his injuries to his neck. And 8-1-4-7, the photograph injuries we generally take overall mid-range close-up with a scale. So there's the same injury on the left side of Deputy's neck with a scale. Thank you, ma'am. 8-1-7-8. This image depicts the photographs that I took of the chambered round at the top of the firearm and the ammunition was removed from his magazine. Okay, again. I think we touched on this earlier, but how many total rounds could that hold? So in total, we can do ammunition count for a deputy with St. Lucy's Sheriff's Office. We are looking for 14 rounds of ammunition. 13 were photographed in this photo. 1 from the chamber and 12 from the magazine. The magazine can hold 13 in total. Is always required to have 1 in the chamber. So a total of 1 missing. Yes, so that's 81-90. This is a photograph of Deputy Blank's firearm that I removed from the magazine to document the blood that is visible on the firearm. 82-19 is a photograph of Deputy Blank's duty belt and taser and blood that was visible on the taser. This is the opposite side. Okay, 83-32. This photograph depicts Deputy Blank, your body-worn camera, and the mount that is attached to his uniform. This photo was taken to document the blood that was on the front of the body-worn camera and the holder. Okay, 8-3-4-2. This is a photograph of the fastener for Deputy Duty Belt and the blood that is visible on his duty belt. Okay, 8-3-4-8. This is a photograph of Deputy Blank, duty belt, and where his 2 extra magazines were removed, along with the blood that was visible on the taser holder and the belt itself. Okay, 8-3-5-9. This is a photograph of Deputy Blank, walkie-talkie, microphone attached to him. 83-6-1. Photograph of Deputy Blank, flashlight that was in the large bag that we saw earlier, and blood that was visible on his flashlight. All right, 83-7-2. This is a photograph of Deputy Blank, pants, his belt, and blood that was visible on his pants. Okay, 83-90. This is a photograph of Deputy Blank shirt, the items that were removed from his shirt pocket, the sides that were removed from, and the blood that was visible along the front side of his left side of his shirt and the sides. Okay. Did you package up his uniform? Yes, I did. Okay. And then, did you also put his shirt in the plastic that we see here today? Yes, I did. And it was at the request of the State Attorney's Office. Yes, it was. Okay, all right. Thank you, ma'am. I have no further questions. Cross-examination time. Defense. Good afternoon, Miss Hiller. Hello, good afternoon. A couple of brief questions to clarify. When you get Deputy Blank's duty belt, who physically handed it to you? Sergeant Jennings handed me at Lawn Wood. Okay, do you know where he got it? I do know where he received it from. It was turned over to me. Okay, and you put it in the bag? Yes, no, it was in the bag already, sorry. Now then, hold on a second. You said there was a photocopy of Leigha Day's birth certificate and social security card. Yes, who took the photocopy? Those were removed from the vehicle the way they were packaged. We didn't copy anything. They were in the car already. So there was the car already photographed? Yes. Photocopied? Yes. Did you ever recover the actual documents itself? The title, the vehicle title application as the original, the social security card and birth certificate were found from the vehicle. We never found other copies of that. Okay. So it'd be fair to say that you pretty know what you're going to see when you look at the deputy's firearm. You know it's commonly issued, correct or no? You're asking me if I know what kind of firearm it's supposed to have or what's supposed to be there. I'm asking you to know what firearms the deputy carries that are issued in terms of handgun. They are issued Glocks. The Glock, what caliber would it be? 45, all right. And that was this gun, yes. Okay, were you able to tell the jury if the flashlights are issued by the agency or if the deputies choose their own? Sheriff's Office does issue flashlights. I do believe some deputies are able to purchase their own and use their own, but the Sheriff's Office does issue flashlights. Part of your analysis of the items that you looked at, specifically with regard to the flashlight, did you check to see if it was working? No. You look at it to read how many lumens or how bright it is, and you're familiar with the lumens rating? Yes, and I did not. All right, so you're not able to tell the jury how bright that light is? No. All right. And now, since she's free to go, and now the state is asking for a bench conference. Mr. Bruce, we got a hold of the doctor and let him know that we finished early. This is probably going to be about 10 minutes ago. He was on his way to Lawnwood to get his notes and he'll be headed here. We have a brief break at this point, just waiting for him after he's done. The court, all right, so about 20 minutes was heading towards Lawnwood to get his notes, and come here. So expecting him within the next 10 minutes. All right. Then I'm trying to get him to please come early. So I know 4:30 was the time. So I'm trying to get him to come early. Mr. Stone, Judge, we have a couple of self-authenticating documents. One is medical records. One is her driver's license that Mr. McRae would probably want to take a look at before we actually enter them anyway. So I think it says DL. So I'm assuming driver's license. Maybe not. So, all right. Use the time wisely then. And a bench conference, and jury leaves. And I'm going to step away for a moment and be back. I had to step away and actually, I didn't really let my throat rest. It's been like 10 minutes, but I went and got some nice cold water. I went outside and closed some windows, and now we're back. We're back, and the jury's entering, and we are up to the doctor. Remember, this is supposed to be brief, and I state. Please be brief. Dr. Christopher Benetti. Good afternoon, sir. Good afternoon. Could you please introduce yourself to the jury and spell your last name for the record? Sure, my name is Dr. Christopher Benetti. My last name is spelled Binettete. Okay, and now what do you do for a living, sir? I'm a vascular surgeon, all right? And what does that mean? I manage any kind of disease involving blood vessels from the earlobes to the toes outside the heart. All right, can you tell the jury a little bit about your education and training? Sure, I attended University of Connecticut for 15 years. I did my undergrad in biomedical engineering with an electrical subdivision. I did my medical school, University of Connecticut. I did my general surgical residency training at the University of Connecticut, my vascular surgery fellowship at the University of Connecticut. That's 15 years altogether. Okay, where do you work? I work at Lawnwood Regional Hospital in St. Lucie Medical Center. All right. How long have you had those positions? 9 years. All right. And were you working in the same capacity on March 24th of 2022? Yes, sir. Okay, were you working in the early hours? Were you on call? How does that work? So I was on call. So that means if there's any sense of emergency beyond what the trauma service would normally handle, I would be called in as a subspecialist to manage the patient. Okay. And did you have occasion to operate on Deputy Sheriff Blank? I did, yes, sir. Okay. And if you can think back and tell the jury, what was the nature of his injuries when you first saw him? Sure. So when I met him, he had already been intubated and prepped on the table. The trauma surgeon was there holding direct pressure on his neck. He had suffered a low-velocity penetrating trauma to his left neck, consistent with a knife wound. And what kind of complications that can present? So with this particular complication, he had an injury to one of the larger arteries in the neck, the carotid injury. It was a through-and-through injury. Through and through the carotid artery. Yeah. Right, yes, sir. Okay. And that injury you just said it was the carotid artery, yes. But there are any other major arteries, veins, or blood vessels in the area? Yes, so it's a high-end real estate in terms of vessels. There's the carotid artery, there's the internal jugular vein, there's the vagus nerve, hypoglossal nerve, and the esophagus. So any injury to that area requires an exploration because of the sensitivity of all those structures. Okay, and with this type of injury, was applying pressure, is that a good thing to do? It's a good thing to start, yeah, but ultimately it's an unstable, indirect pressure that's always key. But ultimately you need some kind of definitive intervention from an arterial injury, especially when it's through and through, especially that won't be sufficient. Okay. So let me ask in a different way. If Blank hadn't gotten to the hospital, Mr. McRae, objection, judge, this calls for speculation. The court overruled. Mr. Bruin. If Blank hadn't gotten to the hospital and gotten medical treatment, what would the result been? Yeah, so injuries to a large vessel, high volume, high pressure arteries without immediate intervention from a medical perspective usually result in death. Okay. And did the trajectory in this case, did the trajectory help at all for its survival? Yeah, so it violates. There's a thin kind of wide muscle called the plastema muscle. I didn't do medical school. And the neck, and because it was violated, all of the structures underneath it are kind of risk of being injured. So in a sense, yes, it was only struck the carotid artery. Had it been a little wider of a strike or it caused a nerve sever, the nerve injury come across the internal jugular, that would have been much more challenging wound to me, and it probably would have resulted in additional blood loss in the field. Fortunately, for the deputy, it was injury that was kind of direct, from the skin through and through carotid. Likely the vertebrae stopped additional passage of the knife. Okay, and what about possible nerve damage in this area? So yeah, the nerves that I had mentioned, unfortunately for the officer, those nerves were not injured during the injury. Okay. And what specific surgery did you perform in the deputy? Okay, so if I say any terminology that's confusing, please by all means just ask me to elaborate. But because the injury was both in the outer surface of the artery and then went through the artery and entered the inner surface of the artery, that required a complex repair. If I were to just sew those pieces all together, it would have resulted in the artery being sufficiently narrower. And so what we do is we employ a patch angioplasty, meaning that I borrow a piece from his vein, from his leg, and reshape it, kind of mirror or match the original portion of the artery, oversew that onto the space, kind of recreating the original shape and size of the vessel. Okay, in your medical opinion, without performing the surgery, what would have been the result? Death or major stroke? Okay, thank you, sir. Cross-examination. He didn't have a stroke, did he, doctor? No, that's because he received immediate life-saving medical intervention. Right, and you describe this as a direct low impact. Low velocity versus high velocity, like a gunshot. Like a gunshot? Yeah, that would be considered high velocity. Okay, and you did... Am I mistaken in saying that your testimony, well, this was low impact? Low velocity. The speed of the knife is much slower than the speed of the bullet. Yes, okay, and so as a result of your good work, so he was back on the job. Did you know that? Yes, sir. He had approximate. How long would you estimate the recovery time? It depends on how you stage the recovery. There's something that I can't comment on because I've seen him from month to month versus day to day. Okay, fair enough. Thank you, doctor. I appreciate your time. And no objections. He's released. Bench conference. Mr. Stone, I think we have these two self-authenticating exhibits, and then the court self-authenticating. Mr. Stone, yes, and that's it. No more testimonial evidence. Mr. Stone, that's correct. After the introduced, we'll rest. The court, all right, have you had an opportunity to review it thoroughly? Mr. McRae, I've talked to her a little bit. Mr. Stone, the documents. Mr. McRae, oh, I'm sorry. The court, no, the documents. Yes, I have actually. I was indiscernible. All right. So no objection, no objection. So the self-authenticating documents, all right, so good. Now it's into your honor that we'll introduce them, and then we'll rest after that. Court, all right. Then I'll send them out and we'll talk some more. Mr. Stone, yes, Your Honor, and a bench conference. At this time, it introduces pre-marked for state identification of States 18, which is a certified driving record of the defendant, not a diving record. Okay. So no objection. And then they bring in the medical records of Deputy Blank. No objection. So now the jury leaves. Yes, thank you, Judge. So the jury has exited the courtroom. Mr. McRae, note the state has rested their case in chief. Any motions? Yes, thank you, Judge. At this time, I am just indiscernible. Yeah, go ahead. Mr. McRae, thank you, Deputy. Thank you, sir. Just give me a second. I have a case that I would like to refer to, Your Honor. It's Thompson v. State Supreme Court and stands for which I know that we already know, but it's a Supreme Court decision that supports the assertion that in order for an accusation of attempted murder on a law enforcement officer, the defendant has to have an awareness that it is a law enforcement officer. And third, if I can just get to my case, that law enforcement officer is in the lawful performance of his or her duties. Your Honor, what is Thompson v. State, Supreme Court of Florida, June 12, 1997? It stands for the proposition the knowledge of a victim's status as a law enforcement officer is a necessary element of a crime of attempted murder of a law enforcement officer. The Supreme Court has held now that knowledge of the victim's status as a law enforcement officer is a necessary element of the crime of attempted murder of a law enforcement officer. Which personally I think has been proven. In the prosecution for attempted murder of a law enforcement officer, whether knowledge of an officer's status did or did not exist in particular is in fact factual finding to be left to the jury. Now, Judge, we have heard regarding specifically, I'm going to narrow in on that one issue that goes to knowledge of blank at the time of his stabbing. We have heard from civilian witnesses, Mr. Sandell, he was the first one he described, he saw a car pass him. Frankly, Judge, the credibility of his description was a little, one is somewhat strained, but in any event, that his testimony did not go towards whether or not Leigha Day was aware that blank was a law enforcement officer. Then we had Deputy Cruz. I mean, not Deputy Cruz, Miss Cruz, another civilian who took the stand and also talked about basically the status of the traffic on the road and saw regarding the wreck. As an aside, the judge, she did not ID the defendant. She said the car, we had to point to where opinions diverged. She said the car was not in the middle of the road. We want to move on to the next witness, being by far the most important one, Deputy Blank. Deputy Blank, Judge, you heard him specifically, did you identify yourself as a law enforcement officer? Not only are we able to know the answer to that question from his response from the stand, but we also know the answer to the question from his body cam. At no point in time did he say law enforcement deputy, St. Lucia County Sheriff, anything. He never identified himself. He never saw it on the body cam. We never heard on the body cam. We took the stand. I said to him twice, you never identified yourself as law enforcement. No, I did not. I asked him if he knew that about his opine that she knew that it was it, and that was based on a number of assumptions. One of them being that my client had perfect hearing, perfect vision. Not only perfect vision, perfect night vision after crawling out of a vehicle that probably flipped on its entirety when the way it settled. It looked like it flipped, but it did land on its tires. So we got our defendant who has crawled out of a flipped car. She's down a beach. She sees her 25 to 30 yards away, very bright light in her face, and his first words are, "Hey, did something happen here?" He did not ever say, "St. Lucie County deputy, keep away, keep your hands away from your side, put your hands up." He, in fact, actually let her get close to him with the light in her eyes. Because at this point, she's like a victim of a car crash, right? Am I crazy? And I would address that in a moment when you could see that she was not able to see, and yet he still never said sheriff. Now he's of the opinion that she is in full capacity, full control of her senses. It simply does not protocol within the sheriff's department, but it's simply common sense that a police officer in the execution of his duties has to identify himself as a police officer. It simply has to be that way because case law has held that for a very long time. We heard from Guerrero. Guerrero, I asked him, what did you say? What did you say when you saw that you thought it was the person you were chasing? He said, I believe. He said, stop or I'll fucking shoot you. You may have said put your hands up. I've got this testimony here, but the reason why I asked him those questions was to put into serious relief the difference between shining a light in somebody's eyes who just crawled out of a passenger side of a vehicle that is either barely on its side or may have flipped 20 to 30 yards down the beach. This is nonsense, in my opinion. This is nonsense. Barely side flipped 20, 30 yards down the beach and saying, hey, what happened? Get over here, as opposed to saying, what I'm sure the protocol is, I'm a law enforcement officer, step towards me. Protocol. The thing is, at this point, when he's saying this to her, she's stabbed someone. They had no indications she was a criminal yet when they first approached her. She was someone who appeared possibly injured from an accident and wandered off. Come this way, whatever, there was no testimony, judge, anywhere except for an allegation that she said, I can't believe I shot one of you guys. She didn't say shoot. Well, she was not the person who testified as that. It was not with her entire time. At one point, she put into cuffs and told, I would submit. Although that she had stabbed a police officer. Then she heard that she was never told what she was going to be arrested for. I believe it was Guerrero said, when I asked him, don't police officers or deputy tell someone what they're being arrested for or make them? He said, no, not always. So I guess the assumption there is the policy would be to put handcuffs on somebody without telling them why. That being aside, there's no evidence here, and there is no, in fact, direct evidence from the victim saying that he never identified himself. It was not a law enforcement officer, judge. It was not self-evident. He had testified there was very, very little ambient lighting. He had to rely on his flashlight, which he said it was directly used around her. Again, the thing is, even if you can argue at first glance, she didn't know he was an officer. There was an extended period of time. She was 1 feet away. She had the time to know this was an officer before the stabbing. She saw who it was and then made the choice. When you look at the video, it's in her face. She can't see. She also testified that she was distraught. She was upset. She may have been crying. All those factors, judge, lead to a reasonable conclusion that unless somebody identifies themselves as to what they're there for after you crawl out of a car, a major car wreck, approaching with a flashlight, the man with a flashlight, she could not, that charge cannot go to a jury based on what Deputy Blank testified to. And based on what his body cam showed us as to the charge of attempted murder, superficially of a law enforcement officer. Again, judge, I'm sure you don't need it, but I'm relying on the Florida Supreme Court, Thompson v. State, as to the other two charges. Judge, I'm not going to address those at this time. The court, thank you, counsel. Mr. McCrae, thank you, judge. I have nothing further with regard to the judgment of the acquittal. The court states, do you want to be heard on the defense motion for judgment of acquittal as to count 1? Mr. Stone, just briefly, judge. Even from his own case that he cited, it says whether the knowledge of the officer's status did or did not exist in a particular case is a factual finding to be left for the jury. That is what we have here. It is an element of the offense. We've charged that offense. There is an element that can be proven by circumstantial evidence, just as any other element can. The state has put forward enough prima facie evidence to go to the jury on that issue and all other issues. The state just says leave it up to the jury. They know what the result's going to be, right? The court. All right. Thank you, sir. The court has considered the testimony presented in the state's case in chief, specifically the testimony of Deputy Blank, along with Deputy Guerrero, Deputy Leckenbusch, and I believe those were the ones that testified they were there that night. Each of them at some point testified as to Deputy Blank's vehicle with the red and blue lights illuminated. There's also reinforced in different pieces of evidence presented through body cam footage. The state has entered as evidence the visibility of that from down the beach, or where this occurred, the proximity that Miss Day and Deputy Blank were in prior to the stabbing, prior to them starting to walk up the stairs from the beach. The state has presented some evidence as to each and each element, all 6 of the elements on count 1. So much so that it is a factual distinction for the jury to make. This is not a legal decision for the court to make. It is a factual determination that at this point for the jury to decide whether or not she's guilty and whether or not each of those 6 elements have been proven beyond and to the exclusion of every reasonable doubt. So I'm going to deny the defense motion for judgment of acquittal on count 1. Mr. McCrae, are you and your client, or on behalf of your client, going to present evidence? Is she going to testify? Do you have any other witnesses? I have no other witnesses, Judge. I didn't think you would have any. I have talked to my client regarding her right to testify. You need additional time to discuss it with her. Miss Day, do you want additional time to discuss it with me? The defendant, no, thank you. Mr. McCrae, she said no, thank you. Does that mean you wish not to take the stand? You know that it is your right to take the stand if you want. You don't have to, or you choose not to. Yes. All right, Judge, I don't need any more time. We have discussed this. Mr. McCrae, any objections to me acquiring on this point? No, none whatsoever, Your Honor. Judge, she's very soft-spoken, so the court. We're going to turn the mic on. Miss Day, go ahead and raise your right hand. Go ahead and swear her. And she's sworn. The defendant, yes. The court. You can put your hand down, ma'am. Miss Day, you understand that whether or not you become a witness in this trial is your decision, and your decision alone to make. Now, obviously, your attorney can give you his legal advice as to the pros and cons of becoming a witness in this trial, and you should give great weight to any advice he may have, but receiving that advice from your attorney is still your decision, not your attorney's decision. Have you had an opportunity to speak with your attorney about whether or not you should testify? Yes. The court, were you able to ask him all of the questions you wanted to ask him about whether or not you should testify? The defendant, I didn't have any questions. The court, okay. But you had the opportunity to ask him if you wanted to, is that correct? The defendant, yes. The court, okay. And after discussing whether or not you should testify with your attorney, have you yourself made a decision whether or not to testify in this trial? The defendant, I would like not to. I didn't know this. This puts a whole wrench in the defense, in my opinion, because I really thought what we were gearing up for, it felt like to me, was we were gearing up for this woman to get up on the stand and explain that she has some vision problem, or she can't see, or even just claim that night she didn't know. And that maybe she realized after the fact what she'd done, right? Maybe she stabbed him, ran away, then saw the lights and realized what may have happened. I thought that's where we were going with this. Wow. The court, all right, and this is your decision, not your attorney's decision. Is that correct? Yes, all right. I'm satisfied that Miss Day is making a voluntary, knowing and voluntary decision not to become a witness in this case. All right, then, when the jury returns, the state is already rested. Mr. McCrae will have to rest in front of the jury when they return. Yes, sir. Damn. And then we'll send them, because it's about 20 to 5 now. We'll send them home, have them return at 9:15 to 9:30 to start, and we can talk about the jury instructions. Say if you've been able to amend the packet, counts 1 through 3. I just need Mr. Brew. I need to add them in real quickly. Take 5 minutes to do. All right, email it to me. Let's deal with the jury. The jury comes in. Mr. McCrae, now that the state has rested their case, do you wish to present any evidence, sir? No? Thank you, Your Honor. At this time, the defense rests. All right, ladies and gentlemen, both the state and defense have rested. There are legal issues I need to address with the attorneys, but we can do that without you being present here in the courtroom. I'm going to release you for the day, ask you that you return to the first floor by 9:15 tomorrow morning. It's just all the standard stuff. And I'm going to have a short recess, and I'll be back. So we are back. If this is just going to be jury instructions, I might not read it all direct. Let's see here. Verdict form. I don't believe this has changed. Count 1, attempted first-degree murder as charged by law enforcement. Guilty of attempted first-degree premeditated murder as a lesser included. Guilty of attempted second-degree murder of law enforcement, lesser included. Guilty of attempted second-degree murder included. Guilty of attempted manslaughter by act, lesser included. Guilty of aggravated battery, lesser included. Guilty of felony battery, lesser included. offense but not guilty. Mr. McRae, those are the lessers that you requested on count 1. So the defense is requesting a ton of lessers other than first degree, attempted first degree premeditated murder. A first degree murder as to charge of law enforcement. Oh. Basically, this is worded wrong. I don't know if that's from the court or from the filing, because she didn't murder the guy. She tried to. At least that's a charge. It's a charge. She's not guilty yet at this point of his filing. As of now, you know. I'm just seeing if there's anything worth actually covering. Because right now it's just jury instructions, right? A lot of no objections in there. You want to read it, it's all out there. Technically, you could go back frame by frame, like pause as I go. I'm looking for any objection or anything major. Recess until 9 a.m. And now we're at the next day. I would have just kept going if I had known that. I would have pulled off. No issues with any of the forms. Tilting of a screen. Judge is explaining what closing arguments is and kind of what they're looking at here. This is why I didn't go through it, so I can read this here. So this is closing arguments. We're at the point in the trial now where you guys are going to get the case soon. We're going to talk a little bit about the facts. We're going to talk about law enforcement and everything that applies and the charges in this case. So count 1 is attempted first-degree murder of an officer with a weapon. In this case, there are lesser included offenses to attempted first-degree murder of an officer with a weapon. Your verdict should be for the highest offense proven beyond a reasonable doubt. In order to determine which is the highest offense possible, the best way to look at it is to kind of prove your way up starting from the first lesser offense. So this is a verdict form. You guys will get this back there with you. It has a title at the top, and right there we have count 1. It's attempted first-degree murder, premeditated murder of a law enforcement officer. And you only check 1. So as you can see, this is charged guilty of attempted first-degree premeditated murder of a law enforcement officer, and then there's also a lesser of guilty of attempted first-degree premeditated murder. So they could get officer. Didn't know it was an officer, then it's just first-degree premeditated murder. Second degree of an officer, attempted second-degree murder, manslaughter by act, aggravated battery, felony battery, not guilty. So there's all those options there. So as we were just talking, the way to look at it is to kind of prove your way up. We'll start at felony battery and work all the way up as charged. Now, there's page 2, and there's what's called interrogatories. These questions are, and it says, if you find the defendant guilty of attempted first-degree murder of a law enforcement officer, attempted first-degree premeditated murder, second with an officer, second-degree manslaughter by act, you must determine beyond a reasonable doubt in committing the offense, did Leigha Day carry, display, use, threaten to use, or attempt to use a weapon? And you'll either check yes or no. And for all offenses, if you find her guilty of any of them, you must next determine beyond a reasonable doubt whether the injury suffered by blank was, and you'll pick 1, severe or moderate or slight for count 2, where leaving the scene of an accident is either guilty or not guilty. For count 3, the same, guilty, not guilty. It'll be dated, and then there'll be a space for the foreperson to sign. Let's start going through, like I said, we'll start at the bottom, we'll work our way up. So felony battery. Leigha Day actually intentionally touched or struck blank against his will. There was evidence of that with his crime. It's a unique situation. It's all on video. There's video of her taking the knife and stabbing him in the neck. 2. Leigha Day caused great bodily harm, permanent disability, or permanent disfigurement. And there's a definition in the instructions of what great bodily harm is. And I submit to you that we've proven beyond a reasonable doubt that those 2 elements of felony battery, so at this point, that's been proven. So you would go up to the next level, which is aggravated battery. Leigha Day actually and intentionally touched or struck blank against his will. The touching or striking is the knife in the throat. Leigha Day, in committing the battery, used a deadly weapon, a knife. There's a definition of a deadly weapon. Common sense kind of tells you a knife is a deadly weapon. Next is attempted manslaughter by act. This is Leigha Day intentionally committing an overt act. An overt act, we've heard that before. That could have resulted in the death of blank, but did not result in blank's death. So this would be some sort of act committed that could have caused it, but didn't cause it. And the overt act went beyond mere preparation. The problem with this is it's not an accidental stabbing. This isn't a situation where a knife was flung or swung around, and it is you can see on the video. It's an actual act of stabbing in the neck. So it's proven. Ladies and gentlemen, but I submit to you that we've proven beyond this. Next is attempted second-degree murder, so this will be the next level up. Leigha intentionally committed an overt act that could have resulted in the death of blank, but did not result in the death of blank. What would the overt act be? Stabbing in the neck. Could it have resulted? Yes, we have evidence from that from the doctor and just from watching the video, seeing the injuries and the testimony from blank. And it did not result in his death, because he's clearly here to testify. The act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. An overt act went beyond mere preparation. So what is imminently dangerous to another demonstrated of a depraved mind? And there's a definition for it. It's a person of ordinary judgment would know it's reasonably certain to kill or do serious bodily or bodily injury. So an ordinary person would know stabbing someone in the neck, reasonably certain to kill someone or do serious bodily injury. Kind of self-explanatory. It is done from ill will, hatred, spite, or evil intent, and it is of such a nature that the act itself indicates an indifference to human life. Now what's missing between attempted second and attempted first, it's premeditation and the intent to cause death. So attempted second-degree murder of a law enforcement officer, same elements as second, but it adds it's required to prove blank was a law enforcement officer. Leigha knew blank was a law enforcement officer, and blank was engaged in the lawful performance of a legal duty. Now, we'll get a little bit more of that in a little bit. We're just going to move on from now up to attempted first. As I said, we prove our way up. As you look at the crimes, you say, okay, they've proven beyond a reasonable doubt. We'll get the next one and work your way all the way up as charged. So attempted first is Leigha attempted to commit the crime of first-degree premeditated murder. Leigha committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation, and Leigha failed to complete the first-degree premeditated murder. So what does an overt act consist of? Some movement towards committing the crime after mere preparation. Example, stabbing someone in the neck would be an overt act. How to prove premeditated first-degree murder? First-degree premeditated murder, so in order to prove attempted, you have to know what first-degree murder is and give you a definition of it. Blank is dead. Death was caused by a premeditated attack of Leigha. There was a premeditated killing of blank. That's the definition of attempted first-degree murder is. Well, he's not dead. Attempted is clearly you're trying to do this but failed to do it. Okay. So he was saying that would be first-degree murder. She tried, so it's attempted. The question of premeditation is a question of fact to be determined by you from the evidence, and this is the instruction you'll get from the judge. It will be a sufficient proof of premeditation if the circumstances of killing and conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of killing. This is direct evidence as well as circumstantial evidence. You can look at both of those and utilize those in weighing whether or not we prove beyond a reasonable doubt of premeditation. Now, what is premeditation? A premeditation killing is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. Now, the definition says the law does not fix the exact period of time that you must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. So there has to be a period of time that passes for you to form that decision to do this act. So it's an example of passing time of stoplight. Somebody has been in a car and it's green, you get near an intersection and it turns yellow. What goes through your mind as it turns yellow? The car in front of me is keep going so I can go through it. Am I going fast enough? How far away am I? Is there anyone turning in front of me? Can I make it? Should I press on the gas? Should I slow down? These are all things you're thinking about when you're approaching the intersection of a yellow light before it turns red in mere seconds. That is enough to formulate premeditation. It does not have to be hours, days, it could be seconds. As long as it's in the mind of the defendant at the time of the act, that is premeditation. So attempted first-degree murder of an officer with a weapon, same elements as attempted first, just like second plus blank was a law enforcement officer. Leigha knew that blank was a law enforcement officer and blank was engaged in the lawful performance of a legal duty, and during the commission of the crime she personally carried, displayed, used, threatened, or attempted to use a weapon. Now there's count two. It's leaving the scene of an accident. I'm not going to read all in detail what that is. You guys will have it back there. It's Leigha Day was the driver involved in the crash. The crash or collision resulted in damage to property. The property was not attended, and she failed to stop or leave information or leave a note and immediately contact law enforcement. I submit to you, we've proven that beyond a reasonable doubt from the testimony of the Sandells that were there that she got in the accident, she careened through the trees, flipped over her car, got out, and once they started calling the police, she's gone. Count 3 is driving while license suspended. Leigha Day drove a motor vehicle on the highway. Her license was suspended, and she knew it. Now, whether she knew it is a question for you to determine from the evidence. There's a caveat in there that proof that exists in the entries of records of the Department of Highway Safety Motor Vehicles showing that there's notice of suspension that was given via delivery is enough. So you guys, we did not present it physically to you, but in evidence you'll get it. Her certified driving record. It was checked back on March 31st, 2022. It was suspended at the time. There's her name, her mailing address, and her other identifying information. You'll have that. And on page 2 of it, it's going to say actions required. The description of the sanction is for personal injury protection of property, not carrying liability insurance, and it's a suspension. I'll tell you that this was in effect of 10/21 of 2021, so 5 months before this incident. They mailed her the notice on 10/1, 20 days prior to the effective date. It's proof beyond a reasonable doubt that she was driving on a suspended license at the time. So how do we prove attempted first-degree murder of an officer with a weapon? There's evidence of premeditation, so let's go through that first. She was in an accident, driving on a suspended license. A witnesses on scene called 911. She fled on foot. She had just wrecked her car, flipped it. She knows that she got a suspended license. She knows she's in trouble for that. She's sitting there on scene with the Sandells and the Talachis and Miss Cruz, and they call the police, and she's not sticking around to see what happens because she knows what's going to happen, so she flees. She removed her jacket, her boots, and her overalls along the way, because what did Miss Cruz and Mr. Sandell sell? She had a black hoodie on, some kind of shirt. They couldn't really describe the pants or legs. They couldn't really be sure if she was barefoot or not, but they said black hoodie. And when Detective Girds went the next day, as he walked from the stabbing back to the accident happened, right where the accident occurred, when he found the river along the way, he finds the jacket, he finds the boots. And then some people go out of the dock the next morning as well and call law enforcement. They say someone's jeans overalls are on our dock. These aren't ours. We don't know what they are. They come out there and they collect them. This is further along the way. She attempted to walk away from blank twice. First, when he says, "Hey, ma'am, how are you doing?" She tries to go. "No, stop, ma'am, you need to stop." And when he says, "Were you in an accident?" doesn't say a word, tries to go into the dock. She knows what's going to happen if she goes up on that dock, and she's not going to let it happen because she's not getting arrested. She hid her hand from blank, concealing the knife. That's direct evidence of premeditation. She does not want him to see what she has in her hands. She does not want him to know that she's in fight or flight. With me, it's you or me. Today, either I'm going to get away or you're dying. One of the two. I'm not going up that beach with you. And you'll see on the video that she passes him. She pulls her hands and conceals them in front of her so he can't see them either. When he was trying to direct her to the road, she said she didn't want to go. She doesn't want to go to that road because she knows what's going to happen. When she went past him, she continued to conceal the knife from his view. She waited until the right opportunity to strike. She waited until she was near the top of the stairwell. As he walks by that gray box, he's shining the light on the stairwell so he and she can see where they're walking, and turns and stabs him when he least expects it. That's evidence of premeditation. So let's take a look at it. Here's the car. Here's the evidence directly that we have, the vehicle that she fled. She crawls out the passenger window as Mr. Sandell testified to, and she wasn't going to stick around because God knows what's going through her head, and she sees that car going, I wonder what happened. I'm not sticking around for this. I'm not sticking around for an officer to know what my license is, suspended, and I just got in a crash. I'm gone. And I'll be right back with another part of the recording. And then we find the jacket. There's a picture of the jacket that Deputy Girds had found. Then there's the jean overalls that were collected. And Mr. McRae and Miss Lobnick, during the questioning, you didn't find those until the day after. Mr. McRae asked Miss Lobnick. The question is, well, they could have been anyone's, right? Maybe it's a day later. But Blank's body cam from that night, if you watch right here in this area, he went on the same dock that night. They collected the jean overalls, and they're there. Video recording started. Live in the court right there that night. Video recording stopped. Next, let's talk about this interaction with her. We have actual evidence of it. Everything was caught on body cam. Live in courtroom as he sees her. Hello. Live in courtroom. She's concealing her hands. 10:23, hello, hi, what's going on? Live in courtroom. She tries to leave. Deputy, ma'am, stop real quick. Possible 10:12, signal 3, Charlie, what's going on? The defendant, I don't know. The deputy blank, you don't know. Defendant, no. Deputy blank, all right. Were you in a crash? Mr. Stone, live in courtroom, tries to leave again. Deputy blank, ma'am, don't. Mr. Stone, once she realizes, oh, deputy blank, don't walk away. Mr. Stone, live in courtroom. He's asking about the crash. I'm not staying. Deputy blank, no, walk in, come over here. Mr. Stone, live in courtroom, and watch her hands. Deputy blank, okay. Defendant, okay. Mr. Stone, live in courtroom, watch her right hand. Deputy blank, walk upstairs, all right, let's get out of the water area. The defendant crying, I'm scared. Deputy blank, you're scared. The defendant, yeah. Deputy blank, all right, let's walk up here, let's get off this water, okay. The defendant, okay. Deputy blank, don't run, walk slowly. Video recording stop. And as you can see, she passes common sense would tell you, with this here and there, I'm going to hold the ledge to pull myself up so I don't fall. Oh no, she's not moving those hands to where he can see them. She will not let him see what is in that hand, and then waiting for the right moment, waiting until he shine the light. He has to walk by that box. He feels like, oh, she must be distraught. Everything must be okay. Just got her up there. She waits until he least expects it. Video record starting, walk slowly. The defendant crying, deputy blank, what the fuck, indiscernible, I've been stabbed, SO, give me a traffic, I'm bleeding. Show me your fucking hands. Gunshot. Give me rescue. Shots fired. Video recording stop. Also, her own words for premeditation. After she's cuffed, she leaves the beach. While they're taking her off the beach is Deputy Leckenbusch and Deputy Kirshner. Listen to what she says to them when they arrive at the crime scene. Someone who is scared and distraught and worried. Video recording started. Deputy Kirshner, indiscernible. Deputy, I guess. Defendant, I guess so, yeah. Deputy Leckenbusch. That's the crime scene. You want to walk through that? Or defendant, yeah, fuck yeah. Video recording stop. Fuck yeah. She's proud of it. Is that someone who's scared of what happened, worried about what happened? No. Fuck yeah, I stabbed that guy. Fuck yeah, that's the crime scene. And then what else does she say when they were not walking through it? Video recording started. I don't want to walk through that. The defendant, why not, you pussies? Video recording stopped. She calls them pussies for not wanting to walk through a crime scene. These aren't actions of someone who accidentally stabbed someone. These are actions of somebody who wanted to stab somebody. She wasn't going to jail. She was getting away, or that officer is dying. That's it. And Deputy Girds kind of laid it out for us. If you take a look, accidents happen here. Boots, jacket, the Sandells, Miss Cruz identify her with the hoodie. She takes off. No one is going to find me wearing that. Then right here is where Deputy Leckenbusch goes down. Two people are going to say she just went walking that way. She's been spotted. Now got to get rid of the jean overalls. People don't know what I'm wearing those. Keeps going up the beach thinking she's making her way up here until she's finally in contact with Blank. She tries to kill him. Then she gets arrested right there in the same place they find the knife. So overt act. She stabbed him in the neck with a knife. We've kind of gone over that. That's the overt act. Now, evidence of intent to kill, the severity of the injury, testified by Dr. Benetti. You heard him testify that this was a high real estate area. That is, went through and through the carotid artery. He testified it went through the muscle membrane there, and he said on the other side of the muscle membrane, where the knife had gone through its nerve endings, the esophagus, the jugular. He said because it was a through and through stab, that he's alive solely for that reason, because if it had been a slice, it would have been more high velocity, like a bullet flying at a super high speed, as opposed to a knife velocity, whole different story, and he needed immediate surgical care. He would have died or had a stroke. He testified what he had to do. It wasn't simple, like, just suturing something. He had to take part of his vein, 3 inches of the vein from his foot, and graft it in there to save his life. And the location of where he wasn't stabbed in the leg, the side, he stabbed him in the neck. That's evidence of intent to kill. She's proud of her actions by her own words. Now, Leigha Day used a weapon. Blank said he was stabbed with a knife. Leigha Day stayed on the beach. I do believe I stabbed an officer. That's what you're going to get to hear. That statement, you're going to get to hear it and take your own ears and listen. You're the fact finders. You're going to determine what you hear. Knife was found by Deputy Labdegang on the water feet from where she was apprehended. So there's a knife. There's a picture of it. You'll have the knife back with you. You'll have the photos as well. And there's the beach, as you see right there. Right there in the water is where they find it. This is the same exact area where they apprehended her. And here's her words. Here's what she says. This is the only people that have been in contact with her at that point with Deputy Blank and Deputy Guerrero and Deputy Leckenbusch. Find her on the beach. What does she say after she's cuffed? She's never been told he stabbed a cop. She's never been told, hey, you're going under arrest for this. She simply gets out of the fucking water. Show me your hands. You better not have that fucking knife. And they cuff her. And what does she say? Listen. The defendant. Heavy breathing. I do believe I just stabbed one of you. Video recording stopped. Video recording started. The defendant, heavy breathing. I do believe I just stabbed one of you. Video recording stopped. I do believe I just stabbed an officer. Blank was a law enforcement officer. This is the other element I have to prove. He's in uniform. You've seen it. We have it here. He wore the same uniform when he testified that he wore that day or similar. Not the exact same uniform. He was working for the St. Lucie County Sheriff's Office, was on the road patrol that evening. Now, Blank was executing a lawful duty. He was dispatched to the scene of a crash. From the testimony, he was informed that the sole occupant of the single vehicle crash had fled the scene. He was attempting to locate the suspect in order to ask questions to ascertain what occurred. So there's a crash. They're investigating this crash. He's going off to find her. That's his legal duty. Now I submit to you, ladies and gentlemen, we've proven this case beyond a reasonable doubt of all elements of attempted first-degree murder of a law enforcement officer, and I submit to you that it's going to come down to this. We talked about it during jury selection, that I have to prove every element beyond a reasonable doubt. Not some, not all, but one. I submit to you that this is, when Mr. McCrae gets up here, this is what he's going to focus on because it's true. Blank never told her I was law enforcement officer. But if you remember during jury selection, I was talking to Constance Gettler. I put a hypothetical to her about rain. She's out in her yard and she's mowing the lawn and she sees the clouds. She hears thunder and lightning up and noise on the roof. She never actually sees it rain. But she says, yeah, it's reasonable to believe that what's happened because of all the evidence surrounding it. That is exactly what happened here. Blank drives by this area with his lights and sirens on. You have the video. You can hear it. You can see it. He said, I drove by that dock with him all the way up to the crash site, so she would have heard him as he's heading there. She knows. She already knows cops are coming because they're calling. But she would have heard him go by. Oh, they're on their way. Thank God I'm going this way. Blank had his red and blue lights flashing, illuminating the tree line at the dock. He gives her commands to stop multiple times. She adheres to the command. She didn't adhere to any commands that the Sandells or Miss Cruz gave her on the scene. She left. She wasn't sticking around. But when Deputy Blank was there on the beach, he tells her to stop, get back. She's adhering to the commands of a law enforcement officer. He was in full uniform. At one point, she was in a foot of him, with the area illuminated for her to see his uniform, and a lot was made of the fact that he said it at deposition that when you saw her, she didn't immediately recognize you. We play the video. You'll get to play it. When she first comes into contact, she's way down the beach. Yeah, she's not going to immediately recognize him at that point. I submit to you that she did, because you can see the lights in the trees. And it's a big deal being made of the fact that, well, she should have known, that it was him, even though it's dark. And people talk about how dark it was on the beach. And it wasn't dark enough for her to literally walk all the way up there. But if that's true, you'll watch the body cam. He's talking to his radio. He says, hey, I think that's a signal 3. I'm with you. Normal people don't do that. And she's hearing that. That's evidence of her knowing this was a cop. When she went up the dock, the vehicle was almost eye level. The lights were visible. You can see where his vehicle was parked and the lights were. Upon being cuffed, she stated, I do believe I stabbed an officer. The one person, this is, I think, very important, the one person that she stabbed, of all the people she interacted with, the only person that can arrest her. She didn't stab the Sandells, Palachis, Miss Cruz. The 2 people in the dock that saw her. That's 7 people she just bypassed. But the moment she comes in contact with a cop, all of a sudden that's the person she chooses to stab? But she didn't know he was an officer. So this is a still frame of Deputy Leckenbusch's body cam with him on the beach to show you how much these flashlights illuminate the area, how far down they do. And he's flashing the light down the ground towards her when she's interacting with him, illuminating everything for her to see. And if you look up here, and I'll show you this. This is a video from Deputy Leckenbusch's body cam. Look at the tree line. Because when he first goes on the beach, you see kind of like a white light. That's Deputy Blank on the dock. He said, is that you? He says, yeah. He says, I'm going down further. Look what Deputy Leckenbusch could observe on the tree line above him. Video recording started. Lights of the car. You're telling me when you see the light of her, she's coming out. Video stopped. Of a tree line, you can see from Deputy Blank point of view the lights. She's not going to see the shining in her face. Oh, there must be a cop right there. Where that's at. And then Deputy Blank's body cam. Video started. Mr. Stone, live in courtroom. You see the lights yourself. You see them illuminating the tree line. Video recording stopped. Mr. Stone. And here's a still shot of where she's originally when she sees. She's down around this tree. Now she's here. Clearly. See all the lights up there lit up. Video recording start. Deputy Blank. Hello. Mr. Stone, live in courtroom. Again, his interaction with her, you see the lights and listen to him on the radio. 10:23. Hello. The defendant. Hi. What's going on? Ma'am, stop real quick. Mr. Stone, live in courtroom. Adhering to his commands. Deputy Blank. Possible 1012, Signal 3 Charlie. What's going on, Mr. Stone? Live in courtroom. Because normal people say Signal 3 Charlie when they're holding their shoulder. Defendant, I don't know. You don't know. The defendant, no. All right. Just, are you in a crash, ma'am? Come up here. Don't walk away. Live in courtroom. Again, adhering. The defendant, indiscernible. No, walking. Come over here. Mr. Stone, live in court. And watch how he illuminates the area. Deputy Blank, walk upstairs. All right, let's get out of the water area. The defendant crying, I'm scared. You're scared. Defendant, yeah. All right, let's walk up here. Let's get out of the water. Okay. Mr. McCrae, live in courtroom. Your Honor, can we approach, please? That's the defense, and the Deputy Blank on the video. Don't run. Walk slowly. The court, the judge, live in courtroom. Counsel approach. Video recording stop. Bench conference. Mr. Stone is repeatedly playing the most prejudicial, inconcernable of this video. They've seen it once during the trial, and he's showing it now. Mr. Stone, Judge, I, Mr. McCrae, indiscernible to the jury. This is cumulative. It's prejudicial to focus on this one fact over and over again, indiscernible. Mr. Stone, Judge, the most prejudicial part is the actual stabbing, which has been shown once. That's it. I'm going to show the part up until the beginning part of it and turn it off. I'm not going to show him going up and sitting there and calling in shortness of breath and going to the ambulance, but I have to show it. Part of the evidence. I have to prove that she knew he was a cop. It's one of the elements, and I know it's bad. And sure, you know, it's not, no one wants to watch it, but I have to show it. I have to prove these things. Mr. McCrae, for the record, indiscernible to the jury right now. The court, all right. The video that defense is objecting to, the repeated playing of, it is an evidence. The jury can watch it as many times counsel is making an appropriate argument as to the video. He can argue it however he likes as long as it is not violating any evidentiary rules, and he's not. All admissible evidence in a criminal trial case is prejudicial by its nature. Mr. McCrae, it's cumulative, Judge. The court, it's not cumulative. It's an evidence overruled. End of bench conference. Mr. Stone. So next, I want you to watch where at this point she goes up the steps and he turns and stabs him. She's at the top. And I want you to focus on when he gets up, what he's able to see along that tree line. Video record start, walk slowly, crying, what the fuck, I've been stabbed, SO, give me traffic, I'm bleeding, show me your fucking hands, gunshot, video recording stop. What's lit up? The trees. Even there, he's at the step. The area where she turned, and even there you can see the tree line, you can see the lights. He's in a still frame of his body cam interacting with her just a foot from her. Light not flashing in her eyes, light illuminating the area so everyone can see everybody. He can see her, she can see him. And lastly, ladies and gentlemen, how do we know that she knows he's an officer? Her own words. Video recording starts. I do believe I just stabbed one of you. Video recording stop. Ladies and gentlemen, you're going to get instructed on the law in this case. You've listened, you've paid attention. When you look at the evidence together as a whole and you apply the law to the facts, the only verdict you can come back with is guilty as charged. Thank you. The court, thank you, Mr. Stone. Mr. McCrae, are you going to utilize the board? Mr. McCrae, I'm not a judge, but may I move it? Mr. Stone, I'll move it for you. I got it. Mr. McCrae, make your closing argument, sir. So, I'm going to cut the video here. I'm going to come back after I've eaten and let my voice rest. And then I'm going to give the defense the best I can with my voice. Because I feel like it's not fair to cover it when it's so injured. I'm probably going to, I think I'm going to take a break, get some ice water, try to make things feel better, get some pizza. I think at this point I've probably talked for like 3.5 to 4 hours. It feels like that at least. We'll see how long the video ends up being. Everything so far has been filmed together from the actual file here that I'm reading. I still have, by the way, editing to do, and there's going to be, at the end of this, we're going to go through the sentencing as well. So there's a lot to go through. Just know that I'm doing my best because I rush these things. I try to get them out as quick as I can. To me, I think the state, I want to mention this when I talk about this here since a little bit of a break. I think the state did well. I think the state proved beyond a reasonable doubt. I think they did amazing in the close. I think they reiterated every point that I wanted them to reiterate, and I think it was done well. Sarah Boone case, there are some complaints people had with the prosecution, but in this case, I can say that I have no complaint with anything that the prosecution has done or said. It has seemed perfect to me. I'm really curious what the defense has to say because we didn't get to hear them have witnesses. And we didn't get to hear the defendant on the stand. And I am back. Hasn't been long because I wanted to make sure that the state's closing argument was still fresh in my mind. Mr. McCrae, thank you, Your Honor. May it please the court, opposing counsel. So, ladies and gentlemen, during jury selection, I told you how important this case is. You see now what I meant. If during this trial you may have looked at me or heard me object and thought I was a jerk or disruptive or whatever, please put that out of mind. What your feelings about me, please put that out of your mind and focus solely on the facts. I'm kind of wondering if he caught some glances from the jury. What I say isn't evidence, Judge. Easy has told you that a number of times. What Mr. Stone just said is not evidence. He was not there. None of us were. During his first closing argument, and Mr. Stone will get another one to rebut what I say, he said 7 times she knew, or he knew, she knew, he was a cop, she knew she was in trouble, she knew to get out of there, she knew. That is not what he said, by the way. With 7 times knew that she was a cop, I believe the 7 was that 7 separate times she did not kill people. She didn't follow their orders. But when it came to the cop, she followed their orders and attempted to kill the man. Those are assumptions. You cannot convict in a criminal court on assumptions about what she knew. That's speculation. Okay, except, there's an entire charge about knowing if someone's an officer. Technically 2 in this case. So you do have to make a decision about whether she knew beyond a reasonable doubt it was an officer. Pure and simple speculation about what Leigha Day knew after crawling out of a car that she had flipped. She got out, ended up disoriented, distraught, crying on the beach, wandering aimlessly. She didn't beeline straight for someplace. She was wandering around, and then what happens? Mr. Stone pointed out she passed 7 people, 7 civilians. No, she didn't stop and stab one of them. She was not in fear of them. She goes down the beach. Who knows what she's doing? And as for the sand print, they say, well, it looks similar to the boot we found or whatever. That's not relevant to prove what she knew and what her intent was. What is relevant is what happened. The first words out of Blank's mouth. Hello. Hello. What did Leigha Day say? Hi. Clearly disoriented. Distressed. Clearly distressed. Deputy, would you turn the lights off, please? Deputy, may I ask you to turn the lights off? Mr. Stone, Judge, may we approach? Counsel approach. Bench conference. Mr. Stone, this is not in evidence, Judge. He can't. Mr. McCrae, demonstrative aid. This is exactly the model that was on his pistol. It's Mr. Stone. He has no evidence that it's exactly the model. He has no evidence of that. Mr. McCrae, it's a demonstrative aid, Judge. I should be allowed to. Mr. Bruin, Judge, this is a recreation. Mr. McCrae, recent. Mr. Bruin, there's case law against recreation, Judge. A demonstrative aid is different than a demonstrative aid. This is different than a demonstrative aid. It's a literal recreation of an incident. Mr. McCrae, Judge, they testified as to what she knew, what she saw, indiscernible. To do that, it's a demonstrative aid. He can rebut it all day long. The court. The courtroom setting with ambient lighting that's going to be in here, the inside as opposed to outside on the beach, this is not going to be an accurate recreation. It will be misleading to the jury counsel. Mr. McCrae, we can leave the lights on, Judge. Court, you can argue what's in evidence, what's in that video, what they can see as far as the brightness of the light, the darkness of the beach, but I'm going to sustain the state's objection as to a recreation with the flashlight here in the courtroom. Mr. McCrae, I'm not arguing with your ruling. I will just say that this was a demonstrative aid. Thank you. End of bench conference. Mr. McCrae, so you will have to rely on your imagination as to what she saw that moment, which seems to be what the state is seeking, that you rely on your imagination as to what she saw at that time. No, we have body cam footage of what she saw, or what it looked like there. Is it a traumatic experience to flip a car, crawl out of it, stumble down a hill, walking around a beach, past 7 people, and somebody says hello, and she responded immediately? She could not have known at that point in time who that that was an officer or who that was. It could have been one of those 7 people. It could have been the owner of the dock. She wanted to get away from that car. Who wouldn't? You get out of a car, it's wrecked like that, you get away. No, you don't. So what do we do? What do we do? We know that Leigha Day stabbed Blank in the neck. Well, she's definitely not guilty then, huh? We know this, we saw it. We know that Blank showed up at the scene alone and said, hello, something happened. You were in a car wreck. No, don't walk away. Now she wasn't running. Don't walk away, and she is terribly distraught. This doesn't have anything to do with the fact that her license was suspended or whatever. She had just crawled out of a car that had flipped, and she was in absolute terror, fight or flight. These people who she passed was on a threat. She doesn't know who was coming at her. Really, and Mr. Stone is correct. He said what Mr. McRae is going to come up here and tell you that that Blank didn't identify himself as an officer. And I say again, I told you in jury selection, nobody wants to see our officers injured in the line of duty or any other way. I mean, nobody wants to see our law enforcement injured. But what do we know thus far? We can't rely on the prosecutor telling us what she knew. We simply can't. What did she know after falling out of the car that flipped? She had the knife. She lost things. I guess the clothing issue was to show she was trying to hide, but she didn't run away. She stopped when somebody said hello. It sounded like an empathetic voice. He didn't scream at her, get the fuck down or I'll blow your fucking head off. He said, hello. She said hi. Something happened. This sounded to her like possibly someone was going to help her. Where are you going with this? Oh, this man was going to help me, so I stabbed him in the neck. She didn't know where she was. She didn't know who these people were. So we know she stabbed him. Do we know why? And there again, Mr. Stone asked you to assume that she knew and she didn't know. Blank did not deserve this. Thankfully, he's back on the job. He's back on the street. And what did we hear? We heard from first witness, Mr. Sandell, a seasoned guy, I guess, has a house here or something right on Indian River. Mr. Sandell took the stand. Really didn't tell us anything about and couldn't about the interaction between Blank and Leigha Day. He was there, he saw the car, the positioning it was in. It was kind of odd the way different witnesses were talking about the positioning of the car. Who cares? But I really don't think that goes to the weight of the evidence. You saw the car flipped and she got out through the passenger side. Mr. Sandell tells us nothing about why this happened or even how. Miss Cruz, the young lady who was also there that evening, she took the stand very briefly. She didn't tell us about anything really that goes on the way of the evidence that can help when you go back and make your deliberations regarding this. And the most important, of course, witness was Deputy Blank. We saw his shirt, which had been cut open. Some safety pins back on it. He didn't have a reflective vest on. He didn't have a reflective shirt. He didn't have anything that visually identified him as a police officer from any kind of distance at night with the light of your eye. Yes, he was injured, stabbed in the neck by Leigha Day. We can't get around that. And Mr. and Deputy Blank truthfully said, no, I never identified myself. I never said I was a St. Lucie County Sheriff deputy. Next up was Deputy Guerrero. He went in there not playing, gun drawn, put your fucking hands up, I will blow your head off right now, or something to that effect. And I asked him, why'd you say that? For the protection of yourself, for the protection of your fellow officers, deputies. He said, yeah, okay, fair enough. Yeah, she just stabbed someone, an officer. So obviously he's going to say these things, right? Like, it's changed. The situation has changed. Because of her. We had Detective Leckenbusch. You'll remember that he said, well, it was close to the county line. It was an overturned vehicle, went to the water's edge, went 25 yards from the site of the crash, and so forth. Really didn't see anybody on the beach. There again, doesn't give you a lot to work with in the terms of charge at hand. He was there. He went back to the beach area. Nothing you can make a determination, certainly, about why this happened and how it happened, although we know it did happen. We saw it on video, how and why. The why is very evident in the video. She very much is hiding a weapon. Like, the best you can go for is attempted first-degree murder, right? Because we saw that part. And then the evidence saying she didn't know he was an officer, to me, is just ignoring reality. Leblond wasn't there, gave you no evidence to prove or disprove a material fact that being did Leigha Day stab Deputy Blank, which we already know she did, and talked about the detailed procedures. Labby Gang showed up. He was the dive recovery team, found the knife. There was some prints on the sand, found the jacket, which was a Harley Davidson jacket. No testimony about the size, or certainly no name or anything. Identifying factors. Again, that's something you can think of. You feel that's important. I submit to you that it still doesn't go to whether or not she knew what was happening to her was a deputy approaching her with a very bright light in her eyes after crawling out of rolled wreck. They're not explaining away the lights on the trees, the blue and red lights. Miss Girds talked about the firearm, about how a semi-automatic usually ejects the shell to the right. They found a shell. And when you look at the video again, when Deputy Blank fired his weapon, could you see you see her when you fired? He said, yes, go back and look at the video and see if you agree with that assessment. What does this have to do? Let's talk about this so-called confession. This was well after the fact. She now knows she's in custody of the police. We cannot assume the state cannot ask you to base a verdict on assumptions. She knew at this point she's in custody. It was a fight or flight, and it was really what boils down to. What did she say? You fucking pussies. And then I do believe I might have stabbed one of your guys. That's not premeditation. That's not even knowing who you stabbed until after they have you, knee on your neck, cuffed, the cops around telling you they're gonna fucking blow your head off. I do believe I stabbed a cop. The state wants to paint her as some premeditated killer, but she's not. Leigha, stand up, please. That's a 24-year-old girl who flipped her car, staggered down the beach. This ends in a terrible, terrible outcome. Thank God Blank is fine. Back on the job. You can have a seat. Have a seat, Leigha. But Leigha is not guilty of the highest charge that she is accused of, and that is, of course, attempted first-degree premeditated murder of a law enforcement officer. The facts don't support that. The facts support that she came staggered off the beach out of the water. Who knows what she was doing down there? Those questions can't be answered. We don't have the answers to those questions. Well, we could if she had spoken, but they can't hold that against her. But we do know what she did once the police were there, and it was very clear they were police. All we can do is know what we know, and that, again, is that she got out of the car, which you've seen a number of times, and got down the beach and was clearly disoriented, distraught, crying. Says some very unpleasant things. Didn't realize it until she's down on the ground. I believe I just stabbed one of your guys. So we don't have attempted first-degree premeditated murder of a law enforcement officer. We do have a young woman who stabbed a law enforcement officer in the neck, a very serious crime. But it's not attempted first-degree premeditated murder of a law enforcement officer. These are a lot of requirements to get what happened, and you would have to make assumptions in order to get that. You can't make your verdict. You can't render your verdict on assumptions. What you know is what you can render your verdict on. The next, in Mr. Stone, I'm going the different direction. Mr. Stone went from bottom up, the least charge up to the most serious. Ladies and gentlemen, I submit to you that it's not attempted first-degree premeditated murder of a law enforcement officer. The next step would be, okay, was it guilty of attempted first-degree premeditated murder? When you look at those jury instructions, you'll see that it doesn't match 100%. I'm not going to keep going over the same things that you've seen or heard twice, or seen or heard 3 or 4 times this morning. We get down to attempted first-degree premeditated murder. Now, to be honest with you, with what you know now, it's easy to say, but I believe that given what you know, the facts as they have been presented to you, this could be viewed as an attempted first-degree premeditated murder. The only problem I have with that is the premeditation. Well, she hid the knife behind her, kept it out of his sight. Why was she hiding a knife? She was planning to stab him. And I know Mr. Stone made the analogy of light, green, light, red light, whatever, in order to try and get you to understand that you can form an intent to do this in a very short amount of time. But that's not how this whole thing played out. It played out over a few minutes. That just means she has even more time, right? She didn't see this guy and say, I'm going to fucking kill this guy. She was in fight or flight mode. Well, she saw the guy, had a knife out, hit it behind her back immediately. So I feel like he's doing really bad here. Again, she had crawled out of a flipped car and is staggering around the water past several people, doesn't know who's coming at her, focused on attempted first-degree premeditated murder. Well, she does know because they know they called 911, right? She knows that. This could, if you want to stretch it, it could be self-defense. In no way is he going to... Now, that doesn't fit but it fits with the idea that a highly stressed fight-or-flight mode young girl will be taking off the beach with a very bright light in her eyes and nobody identifying themselves. That's an untenable situation. I submit to you if Deputy Blank had said, St. Louis, Lucie County Sheriff, get down your stomach, not hi, hello, how are you doing? He doesn't know she's a threat at this time. He thinks that she might be a disoriented person in the car, but no, she's purposefully hiding a knife at this point. She's got her wits about her enough to do that. To his credit, he did admit that he never even at any point identified himself. So I would submit respectfully, ladies and gentlemen, that the facts that fit that we know beyond a reasonable doubt without having to assume, without me getting up and saying, she knew, he knew, they knew, we don't know what someone else knew. We know what we know, and we know that there's got to be somewhere in your mind, did she know that was a cop? She certainly did after she got taken into custody. She behaved bizarrely when she got taken into custody, but we can't know if she knew that was a cop, and that is why police say St. Lucie, well, detectives say St. Lucie police detective. Step forward. Let me see your hands. Get down on the ground. Hello. That's what he said. I'm not mocking him. I'm just saying he didn't identify himself to a woman who just stunned, and therefore the best crime that you can render based on what you know for a fact would be attempted second-degree murder. A knife to the neck. That's no game. A knife to the neck from a young woman coming off the beach, completely disoriented, having passed 7 people, not knowing who this is. It's not the correct response. The action is illegal that she took, but the action she took was attempted second-degree murder. So they're going with second-degree murder, attempted second-degree murder. So they're going with no premeditation, and they're going with, they didn't know it was a cop. It's the best they've decided on. Now, if you believe, and when you do read this, that it was attempted manslaughter by act, this is also a very close fit. But this is for you to decide. But I submit to you that you cannot even consider the charges as being 100% relevant in matching these with the events that you've seen as they unfolded, that you heard until you get attempted to a second-degree murder and downwards. It's not guilty. We all know that. It's not guilty. I can't stand there and say that to you as an officer of the court. It's just not true. Felony battery, that requires the type of injury that the doctor described. That's why the doctor was called to demonstrate and let the jury know that this was a moderate to serious injury. You can get to attempted manslaughter by act, read the instructions. Now, I don't read through the verdict forms with you because I'm going to hear them over and over again. But I can only stress to you what I said again in jury selection, reiterated. Nobody wants to see our law enforcement hurt. Nobody wants to see someone convicted wrongfully. So now is where your work begins. When I sit down, Mr. Stone will come up here and try to rebut everything I say, raising his voice and pointing at her and calling her a premeditated murderess who knew all these things and confessed it does not make it true. It's attempted second-degree murder, ladies and gentlemen. This is a very, very narrow, well-defined crime, and what she did fits that perfectly. We're asking you to render just a verdict here, just for justice for Blank and for Leigha Day. Despite her actions, a conviction of attempted second-degree murder is very serious. But I cannot in good faith get in front of you and argue that it's other than that, but I can in good faith argue she did not know, given her mental state, that Blank was a cop who took that stand, and I said I never identified myself. I didn't have reflective clothing on. Ladies and gentlemen, the only legal verdict, the only crime that really fits these facts, as we know them, is attempted second-degree murder. You're in a position now where when you wake up tomorrow and look at yourself in the mirror, you don't want to wonder if you made the right decision, because if you wonder if you made the right decision, you probably did. You have an abiding conviction of guilt, and it kind of wavers and vacillates. It's not guilty under the law. But I'm not asking you for not guilty, because we all saw what we saw. You will convict her of one of these crimes, and the only correct one is attempted second-degree murder. You will get a lot of information to bring back with you and go over. Watch whatever you feel you need to in order to come up with the right verdict. We're depending on you to do this. We're grateful to you. This is where the work begins. I don't get to talk to you again, but remember what I say, and remember what happened to Leigha Day as well as what happened to Mr. Blank. He was not the only victim that night. He was not the only victim that night? What? She didn't crash because of someone else. What do you mean he was not the only... He's literally the only victim that night. But thank God this is not a murder trial. Thank God he's working out. Just a couple of words. St. Lucie County deputies, maybe things would have turned out differently. All we know is the facts support attempted second-degree murder. Beyond that, it would have to rely on assumptions and guess about who knew what, when, and where. Every single element, attempted second-degree murder is there, not more, and unfortunately not less. That is the crime alleged, that is the crime here, and you should convict of it. Ladies and gentlemen, thank you for your time. Please remember what I say. Mr. Stone will try and refute everything that I've said. She's not a cold-blooded killer who confessed. It's just not what happened. Watch anything you need, look at any of the evidence you need, come to the right decision, attempted second-degree murder, and then you will know tomorrow that you made the right decision because you can't come back and fix it. Ladies and gentlemen, thank you again, and please remember when I say Mr. Stone, as I said, let's get a chance to rebuke my closing. This is the last time I will address you. Your hard work begins at the end of Mr. Stone's closing. Thank you for your time and your commitment to coming to a lawful, just verdict of attempted second-degree murder. Thank you, ladies and gentlemen. Thank you, Your Honor. That's all I have. Thank you, Mr. McRae. Mr. Stone, yes, Your Honor. Thank you. You may have your rebuttal argument, sir. So now it's back to the state. No one is saying she's Charles Manson. No one has said that at all. No one is saying she's Jeffrey Dahmer. The defendant that night did take that knife while she's walking those steps and jam it into the throat of blank. That's a fact. That's not asking you to assume anything that's on video. I'm just going to read you one of the instructions again. The question of premeditation is a question of fact to be determined by you and the evidence. There will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. It's up to you to look at everything, to look at and make your determination if there's premeditation. Now, you guys, when we were in jury selection, I asked you, I told you, you guys can't consider sympathy for victim or defendant. Mr. McRae asked you as well. Here's the jury instruction of rules for deliberation. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence. Yet, here we are in closing, asking the 24-year-old girl to stand up so we can see the poor little girl in a courtroom. Why is that? Asking you for sympathy. Not asking you to look at the evidence. Look at her. Yeah, look at what she did on video. You hear wandering aimlessly. She wasn't wandering aimlessly. She chose to leave the scene. She chose to conceal herself. She chose to conceal her hands all the way down the beach. It's not like within a second or two, we're seeing 22 minutes, is what Deputy Blank said looking at the CAD report. 11 to 11 p.m. 11 p.m. is where the accident is called, and 11:20 is where the interaction occurs. Now, rely on you have to rely on your imagination. This isn't Tomorrowland at Disney, guys. I'm not asking you to rely on your imagination. I'm asking you to look at the facts, rely on the evidence, and apply the laws to the facts. I thought this was interesting. You wreck your car like that, you get away? I don't know that. I didn't know that when I get in a car wreck that's bad, I just leave. That's what you're supposed to do. Had nothing to do with driving on a suspended license. It had everything to do with both of those. That's why she left. She knew what was going to happen if she stuck around. He didn't die. It was moderate. Thank God he's still working. He didn't die because of any actions by her. He didn't die because of sheer dumb luck. Now, the testimony of maybe having a stroke, maybe die, that was for the surgery aspect of it. What did he testify to? If he didn't get immediate medical care, he was going to die. Her actions, her stabbing, was to kill him so she could get away. She's on the beach. She knows the cop. She's trying to make a decision, as he says, fight or flight. What do I do? Do I run from a cop who's got a gun? Do I stay? Do I figure this out? I've got a knife. I'm not going to let him see it, but when I get a chance, when I get an opportunity, if he's not paying attention, I'm stabbing him and I'm gone. He's not yelling her down. I'll blow your fucking brains out. He's trying to be calm. He's trying to be exactly what an officer to be. Hey, come here. Come off the beach. Were you in an accident? He's not being a jerk. And when she wasn't in fear of the other 7 people, the people who passed her were not a threat. No, they weren't a threat, but Blank was. Oh, Blank absolutely was a threat to her because Blank was the only person she came into contact with that night that can arrest her for the crimes that she had just committed. He was a threat, and she was not going to let him take her into custody, and she was going to do whatever she had to do to make sure it didn't happen. Nothing to identify the distance? Well, they're the lights, the circumstances surrounding everything she did from the time she left the accident, all along the map the Deputy Girds described. And she knew what was going on. And when she got there in the tree line, you could see the lights there, not to mention she put from him. Of note, the defense never mentioned those lights in the trees. They know it's bad. For me to the podium with him flashing lights, she didn't see his uniform this close, and then the statement of, I do believe I stabbed an officer. Well, it was well after the fact. No, it wasn't. It was seconds, minutes. She stabbed him. Those deputies come flying up. They get her on the beach. No one says anything to her, nothing about stabbing a cop. Of course, they're angry because they see a person on the beach, regardless of whether he's in uniform or not. As officers come on the scene, see a guy holding his neck with blood everywhere, and he said, the person that stabbed me is down there. You think they're going to walk down and be like, hey, man, come on out of the water. She just stabbed a deputy to get away from her actions. You don't think she's not going to stab another one? Those statements are, it's facts. It's proof that she knew. I do believe she stabbed an officer, listened to it, watched the videos, look at everything you have. Ladies and gentlemen, there's an old parable about 5 blind monks and are traveling along a roadway, and they come to a town. They're in a town. People keep talking about this grandioso animal lives there, and they have never seen it. They want to go there. And one of the monks walks up and touches the trunk and says, well, that feels like a sphere. Another one walks up and touches the ear and says, that feels like a fan. One grabs the tail and says, I think it might be a sword. I don't know. One touches the stomach and says, it kind of feels like a rug. It's wide. Another one touches the leg and doesn't describe an elephant either. He describes some other object. See, where they looked at the parts of the element individually, they missed the elephant in the room. When you look at everything together as a whole, you see the big picture. When you look at all of it, you see the big picture. That's what she got in that crash. Her license was suspended. She's not going into custody. She's not going to jail because she stuck around until they started calling the police. And then she went down the beach, and they all described her with a hoodie. She took the hoodie off and left it. Then she went down the way and came into contact with those people where Deputy Leckenbusch was at. And then the very next docs removed the jean overalls because they saw her with that. She's taking steps to get away, fight or flight. I'm not going to jail. Then she comes into contact with Deputy Blank, hides the knife. Won't let him see it. Doesn't even use the railing to get up and waits until he does not see he's in a situation of vulnerability, and she stabs him in the neck to kill him. And he almost dies. As I said, sheer dumb luck he's here today. When you look at all that evidence, and you look at all that, apply the law to those facts, the only verdict you can reach is guilty as charged. Thank you, Your Honor. All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Leigha Day, the defendant in this case, has been accused of the crime of attempted first-degree murder, premeditated murder of a law enforcement officer with a weapon, leaving the scene of an accident and driving while license suspended. Leigha Day is accused of attempted first-degree premeditated murder of a law enforcement officer with a weapon in count 1. Attempted first-degree murder includes the lesser crimes of attempted second-degree murder, attempted manslaughter by act, both of which are forms of attempted homicide, both of which are unlawful. However, an attempted homicide that was excusable or that was committed with justifiable use of deadly force is lawful. Now, if you find there was an attempted homicide of blank by Leigha Day, you will then have to consider the circumstances surrounding the attempted homicide and deciding whether it was attempted first-degree or attempted second-degree murder, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempted murder or to commit a felony upon the defendant or to commit a felony in any dwelling in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful in any of the 3 following circumstances: 1, where the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution without unlawful intent; or 2, when the attempted homicide occurs by accident, misfortune, in the heat of passion upon any sudden or sufficient provocation; or 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat of a dangerous weapon is not used, and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or greater bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon and used in a manner likely to cause death or greater bodily harm. Greater bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. As such, does not include mere bruises. I now instruct you on circumstances that must be proved before Leigha Day can be found guilty of attempted first-degree murder, or attempted second-degree murder, or attempted manslaughter by act. To prove the act of attempted first-degree murder, manslaughter of a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1. Leigha Day attempted to commit the crime of first-degree premeditated murder. 2. Leigha Day committed an act towards the commission of a first-degree premeditated murder that went beyond mere preparation. 3. Leigha Day failed to complete the first-degree premeditated murder. 4. Blank was a law enforcement officer. 5. Leigha knew that blank was a law enforcement officer. And 6. Blank was engaged in the lawful performance of a lawful duty. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or in the state or any political subdivision thereof who is vested with the authority to bear arms and make arrests of those primarily responsible is the prevention and detection of crime of the law enforcement of penal, criminal, traffic law, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement towards committing the crime after mere preparation. An overt act need not be the last possible act towards completing the crime. Prove that a first-degree premeditated murder of law enforcement officer had taken place. The state would have to prove the following 6 elements beyond a reasonable doubt. 1. Blank is dead. 2. The death was caused by the criminal act of Leigha Day. 3. There was a premeditated killing of blank. 4. Blank was a law enforcement officer. 5. Leigha Day knew that blank was a law enforcement officer. And 6. Blank was engaged in the lawful performance of the legal duty. A premeditated killing is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period that must pass between the formulation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Now, if you find that Leigha Day committed... Hold up. Yeah, I think I figured out what's causing the cough. I think there's some stuff I moved around earlier in here that had pet hair on it. And I think that's what's getting me right now. Now you find that Leigha Day attempted first-degree premeditated murder of a law enforcement officer, and you also find beyond a reasonable doubt that during the commission of the crime, she personally carried, displayed, used, or threatened to use, and attempted to use a weapon. You should find her guilty of attempted first-degree premeditated murder of a law enforcement officer with a weapon. I thought about skipping all this, but I decided not to, at least so far. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary contemplated by its design and construction. By 2, any object was used, threatened to be used, or attempt to be used, or intended to be used to inflict bodily harm. If you find that Leigha Day committed attempted first-degree premeditated murder of a law enforcement officer, but you're not convinced beyond a reasonable doubt that she personally carried out, displayed, or used, or threatened to use, or attempted to use a weapon, then you find her guilty of only attempted first-degree premeditated murder of a law enforcement officer. Considering the evidence, you should consider the possibility that although the evidence may not convince you the defendant committed the main crime of which he is accused, there may be evidence she committed acts that would substitute a lower crime or crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you'll need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated by the definition of first-degree premeditated murder of a law enforcement officer is attempted first-degree premeditated murder, attempted second-degree murder of a law enforcement officer, attempted second-degree murder, attempted manslaughter by act, aggravated battery, and felony battery. Okay, so I am going to skip these because we just kind of went through this already. The steps, with the... Well, both the prosecution and the defense. I don't think I need to read all of it. Here we go. Now, to prove the crime of leaving the scene of a crash involving damage to an unattended vehicle or unattended property, the state must prove the following 4 elements beyond a reasonable doubt. 1, Leigha Day was the driver of the vehicle involved in a crash or collision. 2, the crash or collision resulted in damage to another vehicle or other property. 3, the vehicle or other property was not driven or attended by any person. 4, Leigha Day failed to immediately stop at the scene of the crash or collision and then either locate or notify the operator or owner of the vehicle or other property of her name and address and the registration number of the vehicle she was driving or attached securely in a conspicuous manner, and or the vehicle or the property a written note giving her name, address, and registration number of the vehicle she was driving without necessary delay, notify the nearest office of a duly authorized police authority. For the defendant to be involved in a crash, a vehicle, though not necessarily a defense vehicle, must collide with another vehicle, person, or object. Involved means drawn to, participate, and implicate or relate closely, to connect, to have an effect on, or concern differently, or to affect. Vehicle means every device in, upon, or which by any person or property is made, transported, drawn upon a highway, except personal delivery devices, mobile carriers, and devices used exclusively upon stationary rails or track. To prove the crime of driving while license suspended, the state must prove the following 3 elements beyond a reasonable doubt. 1, Leigha Day drove a motor vehicle upon a highway in the state. 2, at the time her license was suspended. 3, at the time Leigha Day knew her license was suspended. Whether Leigha Day knew of her suspension is a question to be determined by you from the evidence. Proof that there exists an entry in the records of the Department of Motor Vehicles, proof that there exists in the entry of the records of the Department of Highway Safety and Motor Vehicles showing the notice of suspension was given by personal delivery is proof that such notice was given. Proof that there exists an entry in the records of the Department of Highway Safety and Motor Vehicles showing the notice of the suspension was deposited in the United States with first-class mail postage, prepaid, addressed to the licensee, the last known mailing address furnished to the department is proof such a notice was sent. If you find that Leigha Day had previously cited for driving while license suspended and her license had not been reinstated, you may conclude that Leigha Day was new of the suspension. Driving means that the operator be in actual physical contact with a motor vehicle for any place open to the general public for purposes of vehicular traffic. Motor vehicle means any self-propelled vehicle. Operating a motor vehicle combined not operate upon rails or guideway, excluding vehicles moved solely by human power, motorized wheelchairs, and electric bikes. Highway means the entire width between the boundary line of every way or place of any part that is open to the use of the public or purposes of vehicular traffic. A privately owned parking lot that is open to the public use by vehicles is considered to be a highway. That's interesting. Notice means person or delivery or deposit in the United States first class delivery prepaid address to the defendant or last known address. Suspended means whatever. Or suspended means the privilege to drive a motor vehicle has been temporarily withdrawn. I think I've explained that enough. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation, and the information through each stage of the trial unless has been overcome by the evidence to the conclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged. Committed, the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whereas the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative or imaginary or forced doubt. Such a doubt must not be influenced you and return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt or having a conviction that is one not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to alone you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in determining which is the best evidence and which evidence should not be relied upon as considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how witnesses act as well as what they did. Some of the things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Now, whether the state has met its burden of proof does not depend on the number of witnesses that are called or the number of exhibits offered. Ooh, I really gotta get something in this room, especially now that I've moved all that stuff. But it's set upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to prove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside the court has been placed before you. Such a statement should be considered with caution and be weighed with great care to make certain it is freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you consider the total circumstances, including but not limited to whether the defendant made the statement she had been threatened in order to make it, whether anyone had promised her anything to get her to make it. If you consider the defendant's out-of-court statement not freely or voluntarily made, you should disregard it. Now, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not according to the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in those instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict or another. You may find the defendant guilty as charged or guilty of lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And it's just, he's reading it, and it's just reading the form. 1 second here. Now, a separate crime is charged in each count of the information, although they have been tried together. Each crime and evidence applicable to it must be considered separately, and separate verdict required rendered as each. Finding of guilty or not guilty as to one crime does not affect your verdict as to the other charge. Now, in just a few moments, you will be taken to the jury room by the court deputy. First thing you should do is choose a foreperson who preside over your deliberations. The foreperson should see to it that your discussions are carried out in an organized way. This is just explaining getting a foreperson. You can't use your phones, that type of stuff. And the jury exits the courtroom. Now he talks to the alternates. They're discharged. They're just going through things. Let's see here, wait. Court recess, court reconvened. The jury has reached a verdict. Let me get a cough out before we get into this one. And a drink of water. Hopefully we're good here. Alright, so if there's anyone in the courtroom that doesn't believe they can contain their emotion regardless of what the verdict is, take this opportunity to step out to the hallway. Right, here we go. We, the jury, find Leigha Michelle Day as count 1 attempted first-degree premeditated murder of a law enforcement officer, guilty of attempted first-degree premeditated murder of a law enforcement officer. Okay. So they did find her guilty of first-degree premeditated murder. There's more to it they're reading, but that's the verdict. As count 2, leaving the scene of an accident, causing property damage, guilty as charged in the information. Count 3, driving while life is suspended, guilty as charged in the information. So says we all, this 4th of April, 2024, and is signed by the foreperson. And it's just all confirmed. The jury. And they thank the jury. The bailiff, watch your step. The court. All right, the jury has exited the courtroom based on the jury's verdict. When are the parties ready for sentencing? Mr. Stone, judge, it is mandatory life. I guess. I don't know if she's entitled to a PSI or not. Mr. McCrae, she is not, judge. You have no discretion in legislation. Based on the verdict, I have no discretion. Are the parties ready to proceed at this time? Mr. Stone, yes, Your Honor. Yes, judge. May I talk to her? Go ahead if you need a moment. Go and talk to your client. Pause, Mr. McRae. May we have, can you fit us in sometime next week towards the end of the week? I'd just like to discuss with my client. I know that you have been robbed of discretion by the legislature. However, I would like to talk to Ms. Day about what happens, if anything, next. The court, we do have time next week. Next week we have is hearing week. We do have some time. Let me see. Mr. McRae, can I give you Wednesday, April 10th? Let's set it at 2 o'clock. Thank you, Your Honor. That would be just fine. All right. So then they convene. He doesn't have discretion, but I still have the sentencing. So we'll get to that. So now we're at sentencing. Madam Clerk, go ahead and call the case. Leigha Michelle Day, and it has the full number. Court calls for the day right this way. Good afternoon, Your Honor. Patrick McRae on behalf of Leigha Day. Jason Boone on behalf of the state. Court, all right. We are here. Ms. Day is present as counsel. This is sentencing following the trial in which Ms. Day was found guilty as charged. Both sides ready to proceed at this time. Mr. Boone, yes, Your Honor. I provided a score sheet. I've also provided a restitution order to the Florida Sheriff's Risk Management Fund for the workers' comp in the amount of $167,930. She's entitled to a hearing on it. It's a civil lien. I don't know if she wants to waive the hearing or not. Mr. McRae, Your Honor, as to that, we will waive a hearing on that. And Mr. Boone did provide those documents to me prior to this hearing. All right, you want these to go in the court file? Yes, Your Honor. State, are you requesting anything in addition to the statutory cost of prosecution? No, Your Honor. Mr. Ray, what is the requested attorney fee for the jury trial? Mr. Cousins, you recall the schedule for this case will be $1,500. Mr. McRae, thank you. $1,500, Judge. Ms. Day, do you have any objections to the requested attorney fee in the amount of $1,500? The defendant, no. The court, all right. State, there are any witnesses you wish to present during the sentencing hearing? No, Your Honor. Blank is present. He does not wish to give an impact statement, and anyone else want to say anything? The court, Mr. McRae, are there any witnesses the defendant wishes to present? Yes, Your Honor. Miss Day's mother would like to make a statement to the court. Okay. All right. Huh. I didn't see this coming. Sandra Veely. Witness. Yes. All right, go ahead and state your name, ma'am. My name is Sandra Veely. I am her maternal grandmother. All right, and ma'am, what do you wish to say? The witness. I know that this is not an intentional act on her behalf. There was a lot of things happening in her life prior to all of this, and she did try to get help. She really did, and we love her very much. We're still going to stand by her no matter what's happened. That's all. The court, I appreciate that, ma'am. The witness, thank you. Is there anything else you wish to say? The witness, I love you, Leigha. State, any questions? There's no questions, Your Honor. All right, thanks, ma'am. Thank you. Mr. McRae, any other witnesses? Nothing further, Judge. Mr. McRae, any argument from the defense? Mr. McRae, no, Your Honor. I know that given the circumstance, Your Honor has no discretion regarding sentencing, therefore I will stand silent. State, any argument as to your sentence? Mr. Boone, just yes, Your Honor. The jury heard all the evidence in this case. Their verdict came back resounding there was intent, it was premeditated, that she knew he was a law enforcement officer best in the Law Enforcement Protection Act. It is mandatory life, and I ask you sentence her to life, Your Honor. Court, thank you. Mr. Boone, I just like to point out, although we did submit score sheet, she is being sentenced according to 782.065. The court, is there any objection to the score sheet itself, which has 156.6 total sentencing points? Mr. McRae, no, Judge. It's an accurate score. It also reflects one prior. I believe failure to register a vehicle, if I'm not mistaken. Court, and Mr. McRae, I believe I asked you back after the jury verdict as far as a waiver of pre-sentence investigation. Yes, Judge, we waive it. All right. The pre-sentence investigation. That at this time, based on the jury's verdict, the court is imposing the only lawful sentence. So count one, Madam Clerk, life in prison with credit time served 750 days. Count two, the second degree misdemeanor, 60 days in the county jail with credit for 60 days, the time served sentence. Count three, another second degree misdemeanor, 60 days in the county jail with credit for 60 days, another time served sentence. Sentences on count 1, 2, and 3 are all concurrent with each other, and I'm assessing all statutory fees and costs to include a $1,500 attorney fee, $50 application fee, $100 cost of prosecution. I am ordering restitution payable to the County of Florida for the Risk Management Fund in an amount of $167,900.39. That's 167,900.39, Madam Clerk. Mr. Bruin. And Judge, just on that issue, can we just have the inquiry of the defendant on record as to her not wishing to have a hearing on that? Ms. Day, as to that restitution, your attorney indicated there was no objection. Is that an accurate statement? The defendant, yes. The court, yes, okay, ma'am. All fees and costs are reduced to judgment liens. Now, ma'am, if you feel that I've done anything illegal, you have 30 days to appeal. You cannot afford an attorney for that appeal. One fee provided to you. Now, at this time, if you'll step over to the deputy, he'll take some fingerprints. Will be remanded to serve the sentence. Madam Clerk, there's your restitution score sheet. All right, we'll go off the record. I remain on the bench to observe the fingerprinting. Off the record, and record resumes. All right, we are back on the record. State of Florida versus Leigha Day, case 2022 CF 726. Madam Clerk, the court has pronounced life sentence, time served sentences for count 2 and 3. After reviewing the audio recordings, the court neglected to announce that she's adjudicated guilty on counts 1, 2. She's adjudicated on count 1, 2, 3, ma'am. The clerk, the judge would be concurrent. Judge, would the concurrent just be on 2 and 3? The court says are all concurrent, all together, all 3 concurrent. Okay, thank you, Judge. All right. That's it. Life. Life. What do you think? I mean, she did it. I don't think there was a question for me that she did it. There wasn't a question for the defense if she did it. The only real question was it premeditated? I think the fact she hid the knife and timed it and waited to the last possible moment, but yes. Did she know he was an officer? The lights, she knew the officers were coming, 911 was called, and she didn't stab him until after she got closer to that vehicle. The lights are shining in the trees. I believe yes. I believe that she's guilty, and there's no question about the sentence because it was mandatory. Life. Talked long enough. I've got a lot of editing to do, putting this all together. It's different. I didn't do other videos on this case. This is me catching up, following the court documents. Let me know what you think in the comments. I'll try to be in the chat. I don't know when this will come out. It might come out Sunday, it might come out late Saturday. I don't know. I'm going to assume Sunday. And I'm going to try to be in the chat with you. I think it ended up as everyone who saw the body cam expected. There is no defense. There's someone who wanted to avoid. She got 60 days for the other charges. She turned 60 days into a life sentence.